we initiate chaos theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All above the petty express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
Welcome, you guys. I'm your conductress, Mo, and we are just waiting for the closing arguments to start. Now, it does seem like both the state and defense have kind of stipulated, like they did in the first part of the trial, to only reading one charging document and then stipulating to the rest of the victims. So it doesn't look like we're going to have like 2 or 3 hours of kind of charging documents. The defense was able to get some interesting things into some of the instructions. They pointed out that the state had kind of amalgamated all of the statutes that they're trying to charge Adrian under. So he wanted them to clearly delineate each, statute and not kind of mix them together. They were also able to get in basically that the doors being unlocked were an additional source or reason that the shooter was able to get into the school and, take these children's lives. So even in the instructions, it seems like they are getting clearly in that there were other faults. Whatever you feel after watching this trial of Adrian, there were other people who dropped the ball, if not more and greater, at an institutional level. Now, both sides have been given an hour and a half with a little bit of leeway from the judge. The defense did ask for 2 hours, but the judge was very concerned about the jury's ability to maintain focus for 4 hours. The judge did kind of get my ire yesterday, because he basically told Nico that he couldn't hold the jury's attention for 2 hours. Now, he's been the most entertaining person in this trial. Now, that being said, it will be interesting to see how the closings are. The state kind of alluded to the fact that their closing was going to be fairly brief. It didn't seem like he was going to be struggling with the hour and a half sort of time limit. Now, it does appear that the defense they are going to be splitting it up like they did their opening statement. So I believe it's probably going to be the same sort of breakdown that they had in their opening, that Suspenders or Yukon Cornelius will kind of tell the narrative story, and then Nico will come in to really hammer home the timeline and how the state's timeline is, well, ridiculous. No, the unlocked doors had nothing to do with the defendant, but what the defense got in is that they were a factor in how he was able to get into. Because right now the state is making the case that Adrian alone could have stopped this, that there were no other factors other than Adrian. So the defense was able to get in that a contributing factor was, in fact, that these doors, both interior and exterior, were left open. C marked, was anyone watching Runkle show last night? It was pulled by YouTube mid-show. I don't know if I have no idea. I do know that I was having a lot of problems with StreamYard on Monday, so I don't know if maybe that was a StreamYard thing. And everything is fine over here. I just like that the defense hyper-focused on the exact time that Adrian was charged with. Yes. Oh, no problem, Wolfram. I'm trying to, I was writing myself notes of things to remember from yesterday. Uh, Funnily enough, half of my notes are like things to remember today and possibly bring up. So I did want to make note of that. Also, in one of the more, again, examples of disrespect, the defense caught that the state had misspelled several of the children's names on the charging documents. I don't know how you're that bad, but they did manage to get that corrected. And it's it's incredibly disrespectful when it's coming from the side that claims they're the only one that care for children. The fact that they misspelled the victims' names is is a bit maddening. We've been under a major solar storm from the sun. We have that too. And just as a warning, if you're in the southern part of the United States or anywhere basically in that big old bullseye of a snowstorm, do have supplies and have things charged in a safe place to stay warm. Have extra supplies in your car and things like that, just in case you get stuck in the cold. It is going to be a doozy from what everyone's saying. Now, we don't know from the state if they're going to be splitting their closing arguments. This does feel like a case in which the special prosecutor is probably going to do both the, first closing statement and the rebuttal. He just, he seems to like showboating. I did think that he did an okay job in cross on the defense's expert. I think that the defense's expert wasn't as standoffish in cross. I thought he got the defense expert to agree to some things that I would have maybe fought back on. So it will be, oh, okay. Our first best Gigi said, C. Mark Drunkle put out a post that YouTube hit him for TOS rules. Not sure if it was the airsoft pew pew or something said in chat. And thank you, Beverly Flores. I don't know. I kind of, I'm growing slowly. Last year, I was not as active as I could have been. The year kind of kicked my behind, but I'm hoping this year is much better. I thought it was nuts that yesterday the only thing the defense got was a stipulation on how that Adrian Garcia did not say shots fired. Yeah, that being said, I call balls and strikes. I do think that the state did an okay in cross for the defense's witness. I wish that the defense's witness had been much more staunch in his stance that you may have, that he was standing for 3 minutes, but we know in fact that he was talking to a witness and trying to process the scene. So that's where it is. Now, Nick should be joining in a little bit, but he did have real life stuff going on because, he actually is a real lawyer. I am a fake lawyer and I play one poorly on YouTube. Do not take legal advice from me. Literally, I dress up in a conductor's uniform to, cover trials on the Petty Express. I'm your hot mess priestess. I shouldn't be your life guru. I don't even listen to me. And we're supposed to get ice and freezing rain Friday night into Saturday morning and maybe snow on Sunday. In my part of Texas, it's the power outage that could be the biggest problem. Yeah, so that is the other thing. Do try to research whether your community is going to have shelters with warmth and stuff, because it is very possible that a good swath of the country could be without power for a while as, linemen do what they can to get power lines back up. So be careful, be safe. If you don't have to go out, stay off the roads. Driving in ice doesn't work even with four-wheel drive. I don't know why I have to say that in Indiana, but every year we have people that attempt to drive with four-wheel drive on ice. And then, just as a little thing, because I think we all can get a bit Twitter-pated if a verdict doesn't happen today, depending on when the lawyers stop talking, they're going to have possibly another hour of jury instructions to be read, and they might not actually get to deliberation until 1 or 2 o'clock today. Now, myself personally, I have 250 pages of notes just from this case alone. And I'm guessing that the jurors have something comparable. I always try to remember, so I don't get Twitter-pated about waiting for a verdict, that they haven't been able to talk to each other and decompress and kind of, BS about this case and all the crazy that they've seen for the entire time. So this is going to be the first time, and I'm guessing they're all going to look at each other and like, what the hell did I just sit through? So, in saying all of that, let's give the jury some credit that as much as we'd like them to do the old Futurama, they march out and then they march right back in, like on a little rotator. I will say from personal experience, and I've only done jury duty once, but I was very aware that whatever choice I made, though it was the dumbest case you'd ever imagine, that whatever I chose, whatever this, we, the jury, decided was going to affect the person at the defense table for the rest of their life, or at least the immediate future. So, as much as we'd like them to do this was stupid, 2 hours in, 2 hours out, it's probably, I would be shocked if we got a verdict back extremely swiftly, just with the amount of evidence and different things. And if there's disagreements, we don't know, we're not there. It would be nice to go to one of the trials at one point when they have comfy chairs, to see how the jury is reacting. Now, I can tell you, when I did jury duty, the state prosecutor, or the prosecutor, thought he was selling me. Now, he was not, and I felt bad, but he did not prove his case because there was no investigation. So it would be interesting to see how these jurors are reacting, especially with how much emotional things were brought into this case by the state. I do believe that the state's timeline, their expert witness, is out, but will the jury be swayed by the parents' testimony? That was difficult testimony. The testimony of the teacher who lost all of his students. Will the jury be swayed by sort of the subtle but omnipresent emotional, manipulation from the prosecution to basically look at these juries and say, if you let this man go, are you going to be able to defend that to these parents? It's really, I find that more inherently evil, if I'm honest with you, than the outright horrible demonic evil that the shooter had. The subtle use of social and emotional pressure to try to push someone to change a verdict in law is incredibly terrifying to me. And Beverly Flores, but there was no reason for them to bring those witnesses because he didn't unalive them. That's what bothers me so much about this trial. Yeah, I do not like the way that the victims were used in this trial, victims or survivors, whichever they'd like to be called. I wish that they had had a choice in telling their story when they were ready to. Even the teacher that her testimony was stricken, you could tell that she didn't want to be talking about this, that this was traumatizing, that going back and trying to relive this for testimony was incredibly difficult. And we saw that along multiple witnesses. And this could have been stipulated to. This could have been a 3-day trial had the state narrowly focused on the time that they say that Adrian didn't act. Now, I think that the defense, and I've said this before, I have no power over this, but I do believe that the way that the defense was able to cross examine incredibly sympathetic and emotional witnesses should be taught in law school. They were masterful. I was very worried at the start of this case how the defense was going to treat these incredibly, fragile survivors of this tragedy. And they have proven to be not only, full of grace for these witnesses, even when they were snarky with them, even when they were deliberately, kind of not being clear or kind of going over his questions. They were unfailingly kind to all of them. And I believe that that's one of the best examples of how to cross-examine an extremely emotional witness and help them regulate. I don't remember the woman's name, but she was the sort of after-school care ACE worker. And by the time the state was done getting her to relive this entire thing, she was shaking. And within 10 minutes of just asking her very calm, very measured questions, she was able to really get herself back under composure. I've also noticed there have been several times where the defense and not the state will ask the witness on the stand if they need a break. It's been very interesting because a lot of times you'll see the state very protective of their witnesses, and this time they were not, which again kind of points me to, I don't have any evidence, but it looks like manipulation. I mean, if it quacks like a duck and it swims like a duck, it's probably not an elephant. I do wonder if we're going to get the crying preacher voice from the state. I will tell you that if I'm a juror and watching the opening statement with that sort of, the state lead attorney, he has this very sort of old school Baptist preacher, like brimstone and fire kind of theatrical voice. And I didn't like that voice. I didn't like the quaver in his voice. And I know that's a double standard because, I appreciated that in the Koberger trial that this state prosecutor was moved by the level of carnage that he saw. But the difference between, when the state prosecutor had to struggle in the Koberger sentencing to, keep his voice calm and to not tear up, is that he composed himself, took a deep breath, and went forward. He didn't, this was a sentencing, but he was not using that to try to sway the judge. He was pretty, aware that they had signed a plea deal. Kylie says, I'll take that over the female prosecutor saying anything at all. I really don't like her. Yeah, she's been a little giggle goofy. And hi, Mimi's. I believe they were supposed to be starting early. I don't know what's going on. That is the one thing about this trial that I do wish Court TV or whoever is doing the pool camera would do, is we've kind of missed out on a lot of the out of presence of the jury sort of, we never get to hear sidebars, but when there are times that they need to do an argument out of the presence of the jury, we haven't been getting all of those. I don't know if that was something that the judge specifically put in like the decorum order as far as the media was concerned. Yeah, Falanos, I didn't like her. I hate her ever since she said, I was busy running a law office, about not turning evidence over. Yeah, she Kathleen Kennedy too close to the sun. I mean, but who? I mean, Kathleen Kennedy, the first woman to destroy 3 intellectual properties. I mean, we can screw things up just as much as the men. Oh, and thank you, Mo, off the case. I've had 2 donations come in so far, and I have a donation coming in today and another on Saturday. Well, that is great. I am so glad because I know how worrying it can be to lose. Well, I don't know personally, but I can imagine it would be, you know, there's so many things you don't even think of, all the little, you know, detritus and things you need for everyday life. So I'm glad that you are getting the things that you and your family need. That is great news. They are now they are running a bit late. Now this judge has been quite punctual, so I'm actually a bit shocked. Or maybe the time difference always. No, they were supposed to be there at 8:30. It will be interesting to see the public reaction. I do worry very much that if there were parents that haven't been able to stay in the courtroom, or people that are watching only the segments from court TV or little snippets, that they're not going to get the full picture. I've noticed, and I've been sort of watching when court TV puts out little, like tweets or things about this trial, they've been very pro state. So I do feel like if Adrian Gonzalez is found not guilty, there's going to be that disconnect for a lot of people who haven't followed this trial. And I don't blame them. It's a very hard trial to watch, but have not heard the defense and have only heard from the state and cherry picked arguments from the state. I do worry there's going to be a large disconnect. And I do worry that the parents and the families are going to be hurt even more by, in my opinion, the legal truth that Adrian is not guilty or not liable, or if he has some liability, that it should only be him that's going to be punished. I do. I have a judge's robe. Yeah, based on the new watchers on other channels, I'm going to be in fights for 3 days if this goes not guilty. Yeah, and it's very, as I've said throughout this entire trial, the monster is dead, and we're left with a combinations of a couple of officers who tried their best and a bunch of dumbasses and cowards. And can we hold someone criminally liable for having a leader that's either not, equipped to handle the situation, or they didn't have the training? Believe me, Sebastian, Nick and I have been asking ourselves for the last 4 days, why are we still here? That being said, I do think that if he gets found guilty, we're going to have a lot of questions. Is anyone going to want to be a school resource officer? Are all the, resource officers in Texas going to be held to this impossible standard of, if you're the first on the scene, you better stop it or we're going to ruin your life? So, what are we doing? Are there other schools that are chronically under security, under locked, under, guarded by, systems and the keys that don't work? Yes, he is coming in. He just had a real life meeting to go to, so I do not. And have you noticed the gallery is emptier? I did, but I also know that if I were a parent, I don't know that I could listen to testimony. I honestly don't know that I could watch this trial, and my heart goes out to the parents that have sat each day listening to some of the most heartbreaking testimony for their children. And good morning, Slinky. So my heart breaks, and I'm pissed off that we could be doing something interesting. We could, or something to help. We could be investigating if other schools are as lax in their security as this one was. But instead, we're going through and we spent more time doing a half-assed investigation on who we could pin the blame on rather than, hey, let's do a statewide check and make sure all of these doors are shut. Let's make sure the schools are doing what they're supposed to be doing. Let's make sure the officers have the right training. Let's make sure, this, that, and the other. But instead, we spent almost a year trying to figure out who to pin the blame on. Yeah, and that's right. I'm glad that only one parent had an outburst. I was shocked that we haven't had more. I commend the parents because I can only imagine if I truly to the heart of me believed that this man allowed my child to get unalived, that this man was a coward hiding, then it would be incredibly hard for me to listen to the defense. And for the most part, the families that have stayed have listened to the defense. And I appreciate that. Uh, KU Thunder, God, I hope not. I really do. I really do. I hope that the state doesn't sink to that level. That's good. It was so crazy to me the way the school was. I have kiddos in a public school and kiddos in a private school, and both of those schools I can't even get in the door until I push the little door ring bell or ring doorbell. And because I wear so many wigs, I have to make sure I'm not wearing a wig and then put my driver's license up, uh, you know, so that they know who I am. And Ginny quilted it. I work at a high school as a sub. The district won't hire a police officer. They have a worthless retired cop. I'm very I'm very pro police. Yeah, and I am so jealous. Do you have a quilting sewing machine? Now, look, I I need another sewing machine or hobby. Like I need glitter dropped on my floor. Uh, But do I want a quilting sewing machine? Yes, yes I do. Do I need a quilting sewing machine and or have time for a quilting sewing machine? No. But I do wish. And Granny Smith, my hubby's schools are each like a fortress. The high school has a guard at every door. This tragedy is on the school that didn't enforce door safety. Yeah, I have my regular machine that I can do. Uh, they are pricey. Look, this is totally off topic, but if you want to get a quilting long arm sewing machine, you are looking at investing more than I paid for my first car. So, yeah, it's a niche sort of, thing to buy. And we are just waiting for court to start. I do not know what the delay is. The judge has been fairly punctual throughout this entire trial. So this is kind of interesting. I don't know if we're maybe having more motions going through, or perhaps the state is going to be showing hard pictures and they're talking to the families about what they're going to be showing. Uh, I'm not sure. I do expect the state to play on every emotional heartstring. I I will imagine that they will show pictures of the award ceremony. If they wanted to do a decent emotional, non-traumatizing, if you really wanted to get the impact that these children were no longer here, that these beautiful, vibrant babies were stolen, you would have shown pictures of them in life and done a respectful tribute. They have used these children, and it's just gross. Sebastian Mueller, if Gonzalez was charged with 29 felony counts of abandoning or endangering a child, why won't the school principal not be charged? That's a good question, and I'm still digging to try to figure out how they came up with Chief Arredondo and Adrian Gonzalez to pinpoint as the ones solely responsible. Now, the police chief, and thank you, Slinky, Texas, for 5 memberships, and those went to Ginny Quilted It, Medita Finn, Just TKU2, no, K2U, sorry, Rosie B, Elon Dobb. So congratulations. Welcome to the Church of Mo. We have dark chocolate sarcasm and, well, emotional support snacks. Now, I am going to get started probably next week on the weekend. We are going to start our members book club. We are reading Small Sacrifices by Anne Rule. It is free on Kindle, and we'll probably be breaking down the first couple chapters next week. Oh, not that. Not Eric. I mean, if you're going to play Eric Clapton, at least play Layla, which wouldn't be appropriate. So don't play Eric Clapton. No, they would play freaking Sarah McLachlan. Because now, I do think it's interesting. Again, all of these civil things from, and thank you, Sebastian, for becoming a hand worker. There is a story about that, but it feels a little inappropriate. So we'll probably do the handwork story on Verdict Watch because it is fairly inappropriate. And I'm already wearing a conductress outfit. So I'm trying to get into purgatory, at least, y'all. Look, I'm not Steve Gosney. I'm not going to end up in heaven like on the first try, but I am aiming for purgatory, so I'll wait for my inappropriate children's story until after we're on Verdict Watch. Now, I think what will be interesting is I'm still going to be going over and making videos of the various reports to come out of Uvalde. So even if we get a verdict today, I will still be adding to the Uvalde playlist, and these will be just me reading the reports. These are very dense reports. The DOJ one, the first report that I started on, is 610 pages of how Uvalde effed up, and they are breaking it down quite well. So if that's something that interests you, or you like to have, someone on in the background reading to you, I will be doing more of those videos and putting them in the Uvalde playlist. There was a DOJ critical incident report, which is what I'm doing now. There was also a Texas House commission or report commissioned, and there was also a City of Uvalde report. So it will be interesting for me to see how those reports both differ and agree and where they found things lacking. So those are more a labor of love. They're going to be like hour to hour and a half long videos that will be in order. If it's anything that interests you, it really interests me. And I figured I had thought we were going to get a lot of things answered. Jim, I am looking at the Philadelphia guy who was digging up graves. Yes, that is a Petty Express, case. So what my plans are, depending on what you guys want to do, is we will watch the closing statements, and I don't particularly hang around for the jury instructions afterwards. Y'all, that was the hardest part of jury duty. Y'all want to know the hardest part of jury duty? Well, first of all, it was getting picked because I wrote down that I watched trials and make sarcastic remarks. Like literally on my jury duty slip, it says occupation, and I put trial commentary and snark. It wasn't that I was trying to get out of jury duty. Like I was like, put me in, coach. I'm ready to go. Because I was like, this will be a great story. I cannot believe they picked me knowing what my career was, or my semi-profitable hobby. But for my LinkedIn, my career and passion. But I swear, you guys, and I had pink and purple hair. Y'all, I live in rural Indiana. I come in wearing like a holy roller skirt because of my leg and nerve issue, Birkenstocks, because of course I do. I didn't wear a t-shirt that said ask me about jury nullification because I couldn't find puff paints in time. But I figured like there's no way in hell any lawyer in the state of Indiana, like rural Indiana, is gonna pick me. Nope, they made me foreman. I am glad. I am very glad that I had a stupid case because as much as I joke, as much as I, hee hee, I didn't sleep well the night before I had jury duty because I know just how much rides on what I think. It was not Florida, but it was stupid enough to have been a Florida case. I do have a video somewhere back in my videography. Well, yeah, which is why I was shocked I was picked because I figured that the defense would like me, but then they would see that I covered trials and they'd hate me. And then the state would see my hair and just hate me. But when I was the only one that was able to explain what presumed innocent means, I guess they both wanted me on their team. Because I kept thinking I'm going to get striked. They're gonna look at that occupation thing and see that this is a bad idea. No, they made me they they made me the first person, and then the jury looked at me and they're like, "You know court stuff." And I was like, "Yeah, I do. You're the foreperson." The only thing that pissed me off is we didn't get to keep our notes. And had I known that the court kept our notes, I maybe would have made all of my notes basically making fun of the case, which is kind of like the notes I already take. But had I known that the prosecutor and one of the witnesses may see this, I would have maybe not written, LOL, this cop called himself a super cop. Wish I could comment. Real court sucks because I can't turn around, look at chat and say, "What?" So, yeah, had I known that my notes would be turned over to the prosecutor and local police, I probably would not have made fun of them. I hope that only the little bailiff lady saw them and then she shredded them. Otherwise, I always drive the speed limit and I know where we put speed traps. Besides, I don't look anything like I used to with the purple and pink hair, so we women, we're chameleons. What the hell? Okay, I'm making sure. My ADHD, y'all, I am ready. I got my snacky snacks. I've got my raging case of ADHD and type A personality. I am like, we are late. Late. Well, it wasn't that, but it was just like me. Are you kidding me? Is this really a case? Did we waste 2 years of this man's life for this? Well, while we have time, I'll kind of tell you about my jury duty trial. So, the dumbest trial to have ever trialed in the state of Indiana, and I happen to be the foreperson on the jury. Now, I have no statistical documented facts. It's only my anecdote that this was the dumbest case to have ever cased in Indiana. Now, first, I get in there and I'm just like, don't be a kid case, don't be a kid case. Turns out this entire case is about a gentleman who lives very close to what has recently become a large swathe of property in a wooded reserve area that's like pay to basically people go onto the property, pay a fee, and can hunt deer. And on the first day of hunting season, this property is surrounded by other properties that also encourage deer hunting on their properties. So one of the adjacent property owners, was pretty used to people breaking into this new pay hunting property to kind of poach and not pay and different things. So he had been aware of trespassers and issues with trespassers on this new hunting preserve. And remember, it's the first day of deer season. Now, it's not a national holiday, but it is an Indiana holiday. The homeowner is on his property adjacent to the new preserve, getting ready to, get deer, as you do. A state trooper had been, oh.
You can be seated in the courtroom. Thank you. Good morning, members of the jury. We have finalized the charge of the court. I'm going to read it to you. You don't need to memorize anything. You will have a copy of it, and it'll be in the jury room during your deliberations to consult. After I complete my reading of the charge, both sides will argue the case, and then we will ask you to deliberate. This is cause number 25 FC 0001U. State of Texas versus Adrian Gonzalez. Charge of the court, members of the jury. The defendant, Adrian Gonzalez, is accused of 29 counts of endangering a child. The defendant has pleaded not guilty. You have heard all of the evidence that will be admitted as to whether the defendant has been proven to be guilty of these offenses in violation of the Texas Penal Code. Both sides will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether the defendant has been proven to be guilty or not. You will have a written copy of these instructions to take with you and to use during your deliberations. First, and I will note, ladies and gentlemen, the notes you've taken throughout the trial, the bailiff will hold those for you until after the deliberations are complete. As I told you, if we have a dispute as to anything regarding the evidence, we're going to rely on the
Oh, no. This is a violation of my type A note-taking rights. Don't encourage me to take 300 pages of notes and then say, we're going to be taking those from you. I'm not saying that I'm a little territorial over my notes, but if I start growling at you and snipping, you are warned. It's like food. It's like, get away from my trapper keeper.
official court record, so the notes will be retained during your deliberations. First, I will inform you of the general principles of law that must govern your decision in the case. Then I will inform you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant may have been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After a careful and impartial consideration of all of the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish the guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt as to whether the defendant is guilty, you must find the defendant not guilty. Jury as the fact finder. As the jurors, you must review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law as provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, nor mention anything that is not in evidence in the trial. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by lawyers are not evidence. Evidence consists of the testimony of the witnesses, materials, and physical items that were admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are to be given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and the evidence that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based upon the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice or sympathy. You are admitted exhibits. You will be provided all of the admitted exhibits for your examination in the jury room. Testimony. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson or presiding juror, number one, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and number two, identifies the name of the witness who made the statement. The verdict. The law requires that you must render a verdict of either guilty or not guilty. The verdict of not guilty simply means the state's evidence did not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree.
We are just starting out. They were a bit later today. I don't know what the holdup was, but they're starting with the the kind of preliminary jury instructions and statutes. I don't know if he's going to do them all in one big block. Typically, some judges do like a little bit before the closing statements. Then after the closing statements, they do the last chunk. But I haven't been in a Texas courtroom, so I'm not sure what the procedure is.
On the verdict. When you reach a verdict, the foreman or presiding juror should notify the court. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf if he elects to do so. The defendant may also choose not to testify. The defendant's decision not to testify cannot and must not be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Instructions on count one, endangering a child. Excuse me. Accusation. The state accuses the defendant of having committed the offense of count one, endangering a child. Specifically, the accusation is that the defendant, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Manuel Flores Jr., a child younger than 15 years of age, in imminent danger of death, serious bodily injury, or physical or mental impairment by engaging in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having the time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, and delay the shooter, or failed to otherwise act in a way to impede the shooter until the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. And that as a peace officer for the Uvalde Consolidated Independent School District, the defendant had statutory duties to act as follows: to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater, or after being informed in any manner that a threat had been made by one person to do some injury to another person.
Well, that was actually one of the things that the defense had a real problem with when they did ask for a directed verdict. The state did not indicate in their case that they were using Melody Flores as witness 1. I don't believe that the jury knows exactly who witness 1 is. Now, they could think that witness 1 is Melody Flores, but it could also be Sergeant Pargas who arrived. So that is the other thing. And the state's going to have to climb an incredibly high hurdle. We all saw those officers in the hallway. What makes Adrian uniquely responsible for this? And the state hasn't proven to me that he did anything wrong. Well, except the first witness was from the funeral home, and Adrian didn't get any information directly from him. He got it kind of tangentially and incompletely from dispatch. So this shouldn't be a trial.
To prevent the threatened injury if within his power, or to protect the safety and welfare of the people in the jurisdiction of his school district, and that the defendant did not voluntarily deliver to Jose Manuel Flores Jr. to a designated emergency infant care provider. Relevant statutes. A person commits the offense of endangering a child if he intentionally, knowingly, recklessly, or with criminal negligence by omission engages in conduct that places a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. A person commits an offense by omission only if the person has a duty to act. A peace officer has a duty, A, under the provisions of Article 6.06 of the Texas Code of Criminal Procedure, to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. B, under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, after being informed in any manner that a threat has been made by one person to do some injury to another person, to prevent the threatened injury if within his power. C, under Section 337.
Well, again, Camille, that was one of the big things that the defense was saying the state had not proven its case. They didn't clearly delineate that. They sort of did. Again, it's not been clear. They did sort of state that Adrian talked to Melody Flores, but they never uniquely stated that she was witness one in the indictment. So, again, like many things in this case, we are wondering what the hell is going on. We have no answers.
.081 of the Texas Education Code to protect the safety and welfare of people in his jurisdiction. Such endangerment is not an offense if the defendant voluntarily delivered the child to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Definitions: conduct, an act or omission and its accompanying mental state. Omission, a failure to act. A person commits an offense only if he voluntarily engages in conduct, including an act, an omission, or possession. A person who omits to perform an act does not commit an offense under the law, unless a law provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Intentional conduct, a person acts intentionally as required by this offense if the person has the conscience.
Everything is fine over here. This is going to be the first time that this education code is used like this. This is, I believe, a novel use of this particular code in a criminal trial. But basically, this makes anyone from a teacher to anyone related to the school criminally liable should this happen. Now, why indictments have escaped the school administration, I don't know. I was thinking that any civil cases against the school were probably waiting for the outcome on this trial, because it would be very hard to sue the school. However, rightly, because they did screw up, in my opinion, it will be very hard for any of the families, victims, or survivors to sue the school district if a jury finds Adrian guilty of this neglect. So I am with you guys in questioning why the people responsible for setting up this dangerous situation aren't being held accountable. I am not sure, but I do know that we might be seeing, if Adrian is found not guilty, several lawsuits against the school district if they can be held accountable.
This objective or desire to engage in the conduct that would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Knowing conduct. A person acts knowingly as required by this offense if the person was aware that his conduct was reasonably certain to place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Reckless conduct. A person acts recklessly as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a person younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person is aware of but consciously disregards that risk. Criminally negligent conduct. A person acts with criminal negligence as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person ought to be aware of that risk. Bodily injury means physical pain, illness, or any impairment of physical condition. Designated emergency infant care provider means an emergency medical services provider, a hospital, or a child placing agency licensed by the Department of Family and Protective Services that agrees to act as a designated emergency infant care provider and has on staff a person who is licensed as a registered nurse and who will examine and provide emergency medical services to a child taken into possession by the agency. Excuse me. Application of the law to the facts. You must determine whether the state has proven beyond a reasonable doubt 6 elements. The elements are that number 1, the defendant in Uvalde County, Texas, on or about May 24th, 2022, engaged in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112, and or B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to the gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 of Robb Elementary School. And number 3, Jose Manuel Flores Jr. was at the time a child younger than 15 years of age. And number 4, the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. And number 5, the defendant was a peace officer for the Uvalde Consolidated Independent School District and had a duty to act by virtue of the provisions of the endangering of a child statute and or other state statutes, providing that he had a duty to perform the said acts that he omitted to perform. And number 6, the defendant's conduct was not a voluntary delivery of Jose Manuel Flores Jr. to a designated emergency infant care provider. You must all unanimously agree on the elements listed above. If you agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you must find the defendant not guilty of count 1, endangering a child. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must find the defendant guilty of count 1. Stipulation of facts by the parties. The defendant has stipulated that the named child victims in the indictment either suffered death or physical bodily injury on May 24th, 2022 as a result of the mass shooting at Robb Elementary School in Uvalde, Texas. All right, counts 2 through 29, ladies and gentlemen, instructions on those counts endangering a child. The state accuses the defendant of having committed the same offense of endangering a child in counts 2 through 29. Specifically, the accusations in these counts are the same as those in count 1, except that the alleged victims, all children younger than 15 years of age, are as follows.
No, we're stipulating.
Count 2, Azuzio Sergio Garcia. Count 3, Xavier James Lopez. Count 4, JC Carmelo Ivanos. Count 5, Annabelle Guadalupe Rodriguez. Count 6, Alexandria Anaya Rubio. Count 7, Leila Marie Salazar. Count 8, Elena Torres. Count 9, Rogelio Fernandez Torres. Count 10, Nevia Alicia Bravo. Count 11, Jacqueline Jaden Casares. Count 12, McKenna Lee Elrod. Count 13, Elena A. Garcia. Count 14, Tess Marie Mata. Count 15, Miranda Gail Mathis. Count 16, Alethea Haven Ramirez. Count 17, Maita Elena Rodriguez. Count 18, Jayla Nicole Silguero. Count 19, Ameria Joe Garza. Count 20, Noah Oscar Arona. Count 21, Chloe Melinda Torres. Count 22, Jordan Demetrio Olivares. Count 23, Jadian Canizales. Count 24, Samuel N. Salinas. Count 25, Kendall Faith Olivares. Count 26, Mia Sorillo. Count 27, Gilberto E. Mata. Count 28, A.J. Martinez. Count 29, Maya Zamora. Relevant statutes and definitions in regard.
Now, Ronan, last night I pulled up Legal Vice's coverage of the Uvalde shooting. The way he was laying it out, it sounds like the police chief was obviously the issue. Why isn't he on trial? The police chief has been indicted on the same charges as Adrian. He is only charged with 10 counts, however. I believe that the children had passed away before he arrived on scene. I'm not quite sure why he only has 10, but that's the only thing I can figure. That being said, he is supposed to be facing a trial. Whether he is still going to face a trial, excuse me, depending on the outcome of this trial, I'm not so sure.
To the above, the relevant statutes and definitions for counts 2 through 29 are the same as those that have been set forth previously in the instructions for count 1. Application of the law to the facts, you must determine whether the state has proven beyond a reasonable doubt the same 6 elements listed in count 1 previously with respect to each of the remaining counts 2 through 29, except that the names of the victims alleged in these counts are different. Likewise, you must all unanimously agree on all such elements with respect to the remaining counts 2 through 29. With respect to each of the remaining counts 2 through 29, if you all agree the state has failed to prove beyond a reasonable doubt one or more of the 6 elements, you must find the defendant not guilty of that particular count. However, if you all agree that the state has proven beyond a reasonable doubt each of those 6 elements, you must find the defendant guilty of that particular count. Rules which control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson or your presiding juror. The foreperson should conduct the deliberations in an orderly manner. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheets. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. Number 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter alone. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your verdict sign his or her name to the particular form that conforms to your unanimous verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Date, January 20th, 2026. Sid Harrell, judge presiding. Ladies and gentlemen, there are 29 verdict forms attached. They are all identical other than the name. I'm going to read the first form to you to illustrate what they all say, and the rest will be attached to the verdict for your consideration. Now, the verdict forms are not to suggest to you what your verdict should be. However, should you decide to use these verdict forms, each and every one must be signed by the presiding juror, the foreperson, indicating your unanimous verdict. Count 1, verdict, not guilty. We, the jury, find the defendant, Adrian Gonzalez, not guilty of count 1, endangering a child, as charged in the indictment, with a signature line for the foreperson and a line for the printed name of the foreperson. Verdict, guilty. We, the jury, find the defendant, Adrian Gonzalez, guilty of count 1, endangering a child, as charged in the indictment. Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical verdict forms for each of the 29 counts alleged. All right, ladies and gentlemen, at this time, both sides have an opportunity to argue the case. The state does have the burden of proof, so they have the opportunity to open and close the arguments. I will ask them to address you at this time.
Thank you, Your Honor.
Not that I'm aware of, but let me see if there's any articles.
No, please, the floor. Abraham Lincoln said that it is much the duty of government.
For the love of God, it's called a lapel mic. Pretend you're an influencer. Dear God. I will go back. Let me boost the sound. More. Giblet head can't even be next to a microphone. What the hell is wrong with this? I mean, why must you be so afraid of the microphone?
No, please, the floor. Abraham Lincoln said that it is much the duty of government to render prompt justice against itself as it is to render the same against the people. What he was saying was, we have a government comprised of prosecutors and police officers whose job it is to render justice against citizens when they violate the law. And that's what we're accustomed to. Prosecutors and police officers working together when someone has violated the law so that they may be held accountable, so that we may have peace and dignity in our state. But Lincoln reminded that no one is above the law, that those in government can also violate the law. And when that happens, it is the government's job to also render justice against those they work with. And so on May 24, 2022, when 19 children were slaughtered, and 10 others were injured, Texas Rangers from all over the state came to Uvalde, Texas, investigated the crime scene, talked to witnesses, analyzed the case for up to a year. And after analyzing the case, one of the members of the government has been brought to you for justice. But ultimately, in our country, in a democracy, it is the people that decide their government. You do that by electing officials. You do that by sending letters or requests to have the law changed. And when one of the members of your government violates the law, you decide whether or not that is acceptable. Because make no mistake, the 12 of you will set the bar for law enforcement in these situations. If it's appropriate to stand outside hearing 100 shots while children are being slaughtered, that is your decision to tell the state of Texas. And by the same token, if that is not appropriate, that is not how we expect officers that are charged with the duty of protecting children to act, that will also go out from this courtroom. The judge has told you that your oath was to render a true verdict according to the law and according to the facts. He has given you the law, and it is that same law that we discussed in voir dire some 2 weeks ago. You recall we talked about this is a special statute because we're dealing with a special group of people. We're dealing with children under 15 years of age, and so we're expected to act differently when we're talking about children that are frail, can't defend themselves, 15 years old or younger. And in this law, the law of child endangerment, none of us are allowed to endanger a child. None of us can point a gun at a child, put them in danger, put them in harm's way. But there is also the protection that if you have a duty to act, you can't stand by while the child is in imminent danger. If you have a duty to protect the child, you can't stand by and allow it to happen. We talked about the people that have a duty. Parents have a statutory duty, and police officers have a statutory duty. And those two sets of people cannot fail to act when a child is in imminent danger. And so the charge in this case is that these 29 children were in danger. Not just danger, but imminent, immediate, close at hand danger. And that there was a man who had a duty to act, who failed to act. And that failure to act, he was aware or should have been aware that that placed those children in danger. But we're also very specific about it. How is it that he failed to act? He failed to act after being aware that shots are fired, being told the general location of the defendant, of the gunman, having time to respond. He failed to act by either engaging, distracting, delaying, or even attempting to do those things. And also being aware that shots were fired and being advised of the general location of the shooter and having time to act, and having been trained in that active shooter training, he failed to follow his training to respond by advancing toward the shooter until after the children in 111 and 112 had been shot. That is the obligation the state has to prove to you beyond a reasonable doubt. Two other quick mentions of the law that the judge has given you that I'm afraid we may not have discussed in detail on voir dire. The first was that the defendant must engage in a voluntary act. The first was on causation. We talked about when you have child endangerment by omission, there can be two people that can be held responsible. The person that is causing the danger and the person that has a duty to prevent that danger failing to act.
I'm just going to object to that. Sorry, at this point. There's concurrent causation is on his board. That's not in the charge.
I'm not discussing that. That just now went through that, Judge, and I just didn't mark it off. I didn't say concurrent cause. I talked about what we talked about in the law that.
Okay. All right, I'll overrule the objection. Go ahead. Ladies.
No, I'm not overruling this objection. He knew, this slimy piece of crap knew that he was going to make something up. But very apropos of you, state prosecutor, to use Lincoln, the man who jailed the grandson of the man who actually wrote, Francis Scott Key, the man who wrote the Star-Spangled Banner. Yeah, Lincoln put him in jail without due process because he wrote nasty things about Lincoln behaving like a tyrant. So yes, the grandson of the man who wrote our, national anthem was jailed by the same president that this man says kept the government to account. No, he threw out habeas corpus. But it's really good that you decided to go ahead and use them because it shows me exactly how you feel.
Gentlemen, I just noticed the clerk brought to my attention, we were working on that charge yesterday. Your date's wrong on it, it's 21. January 21, the last page of it. So it says 20, but it's 21. You know that. Go ahead.
The second issue is voluntary. The defendant must engage in a voluntary act. That's as opposed to an involuntary act. An involuntary act, I believe we talked about during jury selection, is, if you stumble and knock somebody over an embankment and they're injured, that wasn't.
Don't let this man near an embankment. What the hell? Like, I was going to be respectful and I wasn't going to pause very much, but who is accidentally near an embankment and causing people to drop down? We are all the court reporter right now. What would you say you do here, sweetie?
It wasn't a voluntary act on your part. A gust of wind blows you into somebody. You're not responsible for that kind of conduct. If somebody swerves into oncoming traffic and hurts somebody, that certainly looks like you should be responsible for that conduct. But what if it was the very first time you'd experienced a heart attack and you lost control of the vehicle? That's not a voluntary act. That's an
Where in the hell is he coming up with these hypotheticals? If you happen to have a heart attack and run into someone, we probably won't charge you. The state of Texas should really put that in their tourism stuff.
voluntary act. You're not responsible for that. But if you make a decision to seek cover and ask for cover as opposed
Don't
to
tempt
going
me.
in and stand by while people are being injured and killed, that is the kind of thing that's the voluntary act. It is defined in the statute.
Has anyone checked his law degree? Did he graduate from the DeVry College of Law? Did he color in that little Timmy Turtle really well and he thought he was going into an art college and they let him into a law college? I just feel like an aborted art career was at the bottom of this level of legal, agility.
And finally, on mental states, there were 4. Intentional is not really something to discuss. Nobody believes that Adrian Gonzalez meant for this to happen, wanted this to happen. But the other 3 deals with their level of awareness. Knowingly means simply you're aware that by standing by, it's reasonably certain the children will be in danger. Aware is reasonably certain. Reckless is 1 degree lower than that, and that is not that you're reasonably certain the conduct will happen, but reasonably certain that there is a risk, a substantial and unjustifiable risk that the children will be in danger. But there's still an awareness. But in addition to that, there's criminal negligence, in which the law is simply, you should have been aware, based on all those circumstances, that by you failing to act, the child was at risk. So that's the mental state. Not that he intended it, wanted it to happen, but at minimum, he should have been aware that by standing there, hearing 100 shots, he should have been aware the children were in danger by his failure to act. And so then we move into, and beyond the law, into what the state's case was. And it's pretty straightforward. This is not the order we put it in, but this is just the order I drew it up, because training is a big part of who Adrian Gonzalez was. And you have the training that he trained others, because that tells you what he knows. And it also tells you a lot about what the state has done before you got here. In that lesson plan that was introduced into evidence, it tells you that amidst active shooting, the state of Texas stepped forward and required active shooter training for school police officers. And that active shooter training includes stop the killing, stop the dying. And it's not terribly complicated. The training is go to the gunman, advance toward the shots. Pretty straightforward. Not complicated, not hard. Go to where the gunfire is. That's what the training is. We brought you evidence that Adrian Gonzalez taught the class that said, advance to the gunman, stop the killing, stop the dying. Even if you're the only one there, solo entry, you've got an obligation to go in. Why? Because in our state we have a priority of life. Innocent civilians, their priority of safety is above the police officers. The officer going through this training is aware that the safety of the innocent is above the safety of the police officer. And in Adrian Gonzalez's training, he says,
He didn't have training. Now, I am sure that the defense is going to highlight this, but Adrian was trained to facilitate, not to take in information and then regurgitate it, not to, collaborate and make a syllabus about this, active shooter training. No, he was given a packet of information. He went through it because they taught him how to be able to read a packet. It's essentially what they do. Training is simply, I can teach you how to clean your room. I can take you through a PowerPoint. It's not as though he had additional tactical training that these other officers did not.
the citizens have a right to expect that. And if you're not willing to do it as a first responder, find another career. Adrian Gonzalez.
Sir, do you really want me to explain what I think you should do as far as your abilities shown in this case and your career calling? because I think you should definitely think about becoming a, I don't know, a house painter, you know, people's replacement for narcotic sleep aids. You could read books. But with what I saw in this trial, you should find a new job because you don't seem to be able to point anywhere on a map where you can show me that you proved these points, anywhere in the transcript where you made a cogent argument. I don't know. Perhaps you should be, updating your LinkedIn, is all I got to say.
Is teaching his fellow officers, take your job seriously. It's okay to move aside. It's okay if you're not up to that. Let somebody else step in that is up to it.
Hey, prosecutor, do you think anyone is going to step in to be up for it if being up for it means if they make a tiny mistake, if they don't process in the same way that, Texas Ranger Dilbert did with his bionic smelling and radioactive ears, who's going to want to take this officer's place? If Adrian is guilty, do you think that any resource officer in a school is going to act first?
Because as citizens, we have the right to expect that. When we call for help, we have the right to expect somebody that is put on the badge and put on the gun and put protect and serve on the side of their car will do that when we call. Because if they're not willing to do that, where are you? What are you left with?
You and your prosecutor lady friend over there weren't even willing to look at previous interviews to bring this case. So if we're talking about people being unwilling to do a good job at their job and they should leave, how about the two of you chucklefucks haven't done anything cogent in this trial? So maybe both of you should take up interior design. Sorry. They're pissing me
When you're in
off.
danger. Who do you call? And so Adrian Gonzalez, armed with this training, the next thing we spent a considerable amount of time on was the shot count. The casings along the west side, the casings along the hallway, the casings in 111, the casings in 120.
Now, this is one point that I think that the defense should have really, really talked up because of the state's reliance on the shell casings for their theory in this case. It came out, I've been reading through the DOJ report. Apparently, Uvalde officials, while the Texas Rangers were investigating this crime scene, were taking VIP, Congress people, media people, different thing, into the crime scene so they could have a looky-loo. So we had a bunch of, VIPs and people in and out of this crime scene, a crime scene which you say that you took the exact placement of these rounds as a way to build your theory. I do think that that should have been very much more brought up because we learned halfway through, I think, Texas Ranger Dilbert, that one shell casing had actually gone home in a boot. But you have 376 officers on the scene contaminating it on the day. You cannot use those shell casings, however they are grouped, to put any theory of where and when the suspect shot because they were moved. This crime scene wasn't in its original place.
Well, and why did we spend all of the time on that? Because it's the state's position.
Maybe we're
that
noticing
each
more.
shot was notice to Adrian Gonzalez to advance toward the gunfire.
Again, the state has an almost insurmountable hurdle that, again, if I'm a jury member and I know that there is Adrian on the scene and there's a bunch of other officers who have been excused for going away, not listening, not bringing their radios, I'm wondering why this guy is being singled out. And the state has made no good argument. Again, why was Adrian uniquely and solely responsible for this.
Each shot was important to those 19 children and those 10 survivors. Each shot. But the shot count, also as we did that, and obviously if you have this kind of slaughter, there's going to be blood, and we apologize for that. But the blood also tells you a story of children engaged in this, doing as they were trained. To hide in the dark, remain quiet, and wait for the police.
Hello, hello.
Hey, thank you so much for taking on the morning show.
Oh no, that's fine. I'm just resisting the urge to like, oh, is he done yet?
I've been listening to most of his, and it's why is he talking in generalities? This is a case against one specific person. We are supposed to expect. Did you watch your own trial, sir?
You know, what's sad is I was getting ready to say he's actually remained more on focus and talking about the statutes than he did in his opening statement. His opening statement was 15 minutes of, don't you feel bad?
Mm. Oh, they have a rebuttal closing as well.
Yes.
So now focus is on statute. Everything but talking about what Adrian actually did.
Yeah.
Everybody's hiding from Dave.
Did the defendant have time to act? We brought you videos, the funeral home videos, as well as the hallway videos, as well as dispatch.
The hallway
Tell you
videos
what he was
has nothing
aware
to do
of
with
when he
did
was
he
aware
have
of
time.
it. And what was going on as he stood outside the fourth grade wing for 3.5 minutes before he made his first move, before he moved forward.
No. Oh, is it back on talking about 3.5 minutes?
We also brought you the defendant.
We haven't gotten to a time.
1 minute and 4 seconds. That's it.
Yeah, no, this is about as specific as he's gotten with things. No, this is normal speed. This man is pure, uncut Colombian Ambien. Do not operate heavy machinery while listening to this prosecutor.
Statement. And the defendant's statement, I think, clears up almost the entire case. That is what he told the Texas Rangers shortly after this happened. If you're worried about whether or not he had notice and whether he had time to act and what his decision-making was, listen to these words from Adrian Gonzalez. He's over there. He's over there. He's wearing black. I say where? I hear shots going off. Hear sounds coming from behind the building. I get on the radio and say, shots fired at Rob's school, and give the location and where he is. Trying to get from the front of my vehicle to the back of my vehicle. There's only a tree in a building. She tells me he's over there. She's pointing, saying he's over there. He's dressed in black. I say where? She says the teacher's parking lot. I want to say I saw a black car at the end, and then I hear the round.
Mo!
Yeah, I don't know what my computer did. Sorry.
It's,
It kicked
all of
me
a sudden I
out.
got, what, I'm listening and trying to get back. Oh, I need to do this. You got silent.
No, no. I Thanos snapped myself, and now I'm back. I have no idea what just happened.
Some evidence of auditory exclusion. He tells the Rangers, as Melody Flores is telling him where he is, he hears the rounds going off. She goes, he's over there by the teacher's parking lot. Then I hear the sounds going off. I heard 7 or 9 shots while I was inside the building. The coach said parking lot in all black. That's when I heard the rounds start going off. I never saw him. I never went to the school until I got coverage over here. Then I made entry.
Wait a minute, didn't they
I heard like
stipulate
3 or
to
4.
that was actually not him saying that?
Well, they did. They didn't. They stipulated to Adrian not being the one that when Coronado, Saucedo, and Jimenez arrived, someone said, "Your shots being fired. You're under.
Oh,
Take cover, guys." So the state wrongly said that Adrian was aware that they were being fired on, that was Adrian's voice. Now they stipulated to the fact that no, that was Coronado's voice after that witness was already done and both people had rested.
all right. Now I'm caught up.
When Pargus was the first one I saw, I told him to come to me for cover because he has a bigger unit. But he deterred and went to the other area. I knew there were kids in the class. That's why we didn't fire and hit the kids. I'm responding because they are saying the guy is running to the school. I didn't respond to the accident. That's a PD traffic. I'm going over there because they are saying the guy's going to the school and has a gun. Yeah, that's why I'm going to the school. And so the question is, if Melody Flores is telling him where he is, he's in black, when did she tell him that?
JKD Buck, he is reading from the interview that Adrian Garcia gave to the Texas Rangers. I believe it was the day after this incident. And this interview was sort of an after incident debriefing. So he wasn't being interviewed as though he had dropped the ball. It was more like a narrative. This is what I did. This is what happened. This is what the scene was like. So they weren't looking at him as a suspect. He didn't have, union representation there. He didn't have his lawyer there. And neither did a lot of the other police officers. But do you think that they're going to have reps with them after an incident if Adrian gets found guilty? Do you think anyone's going to show up first on scene if Adrian's found guilty? You better hope that all the schools in Texas are actually, looked at this case and started locking their doors. But we know from the witness, from the defense yesterday, that there are still schools that are chronically unlocked in the state of Texas.
Do you really suppose that someone who risked her life to go tell the kids to get inside the door, that is that worried about those children, that turns to run, that when the police officer gets there, doesn't immediately say what she told you she said? He's over there, he's in the parking lot. Where? And she points. And then says, we've got to get in there. And isn't that consistent with what human beings do? Look at Gilbert Lamons. When he sees children in danger, just as Melody Flores sees kids in danger, What does he start saying? Get in there, get in there, get in there, get in there, get in there. Repeats it over and over and over again because of the urgency of the children being in danger. And Adrian Gonzalez decides to go to the back of his car, call Mariano Pargas because he's got a bigger unit, and says, I'm not going in until I get cover. We proved to you the children were in danger. And I know that was a horrible thing to have to experience. But each one of those children deserves to be released. And you needed to know that those 60 shots in rooms 111 and 112 before Adrian Gonzalez entered, those shots ended those kids' lives. This was over before he went in. A whole lot of blame for a whole lot of officers. This was over while he stood outside. And we anticipated that the defendant would say, I was confused, regardless of what he said in his statement. And so, certainly gunfire can be a confusing thing. But we brought you teachers that experienced that gunfire. And the teachers told you that experiencing that gunfire, they still put their kids first and they followed their training.
You had a teacher say he wasn't going to check the locked door.
And you
They
had
didn't-
teachers putting magnets on the locks and then not remove them as they hushed the kids into the classrooms.
Yeah.
Mm.
How much longer do we have to deal with this man? Oh God, he keeps talking and
Yeah,
talking.
you're welcome, Granny Smith.
Kids
You're
first.
welcome.
Follow the training. Melody Flores did it. Miss Deming in room 104 did it. Miss Ogburn in 102 did it. Miss Robin did it with her children. And Mercedes Salas said, not till I get my kids out. You can talk about confusion, but their priorities were where they needed to be. Children first.
If they only followed all the fucking protocol.
And then we talk about the defendant's evidence, or the defendant's case, let me say.
Oh God.
We started very early on that Monday, but he didn't have time because it was too far. It was 45 seconds over there. So we brought you evidence that somebody that covered almost that same distance was able to do it at a jog in about 11 seconds. It was further than that, given 15, 18 seconds, but it certainly wasn't 45.
You're expecting
under
police
fire.
officers to fucking jog? No. Even at responding, they still have to protect themselves, not jog in. Look,
Yeah, no.
Mr. Prosecutor, apply that into every other police interaction. That is your argument. Every other police interaction with every other criminal, every other situation, yeah, just jog there.
This is he just keeps talking and it gets dumber and dumber. All right, we're pushing him up
then-
to 1.25.
There was the representation.
Please do.
There were no shots fired
Thank
toward Melody Flores. There's no evidence of that. And so we brought you the evidence of eight casings on the side of the parking lot, the shot into room 24.
So, Nick,
But
this is a big thing that I think the defense didn't do enough. The entire state's case is predicated on those casings indicating where the shots were taken. However, reading the DOJ report, Uvalde was letting VIPs in and out of this unsecured crime scene during the investigation and beforehand. So we had random looky-loos going into the crime scene. It was unsecured. So the state's entire case falls apart because you cannot guarantee that those were not contaminated.
my assumption here is that they probably tried this pre-trial and
Probably.
unsuccessfully. Now, it wouldn't have stopped them from arguing it in trial, but maybe they thought it was enough to point out the absurdity on he's not on top of the shell casings. They are whom, with which the witness said, well, he might have held the gun upside down. And at that point, I was looking for that witness.
shot glass, yes.
That witness is one of these who needs to be caressed slightly over the cheek with a fucking lawn chair.
A gentle kiss.
Yeah. Knuckle kiss.
Well, those 8 shots were accidental discharge by a man bent on killing kids. He just
Did
made an
Adrian
accident
know
as
that
soon
when
as
he
got around
drove?
and fired those shots, not toward Melody Fullers, but toward that window. And so we brought you the casings. One picture shows 3 of the casings, which you remember the FBI agent said we had to go back several times, and so there's 2 more markers that are additional. There's 5 casings. There's 5 shots in the glass and 5 shots directly across up into the, not 5, but shots shrapnel up into the ceiling and down into the floor.
Okay, from a former theater kid, if you would like to look decisive and like authoritative, those shots were over there. You don't flap your hand. I mean, this is a whole lot of hand flapping for the state of Texas.
Yeah. I mean, doing jazz hand. I mean, it didn't work in this CNN defamation trial last year, where the guy allegedly got over 100 million in damages.
Well, this guy thinks his toupee looks real, so
Yeah.
why am I expecting any better?
So where are those 8 casings being fired? If you have those 5 taken care of, as well as in one room 104. Well, we have room 24. And so they tell you, well, I couldn't find room 111. So we brought you evidence that it was circular or almost oblong, saying that's the wrong angle. But more important than that, there's a piece of conduit running up the building. That bullet would have to pass through without leaving a mark.
I don't think you showed that.
Melody doesn't know what she's talking about, and so you don't trust Melody Flores. And if you have any hesitancy on Melody Flores, go back to the defendant's statement, where he says she told me where he was, what he was wearing, and then I heard the shots. We had a lot of information about slicing a pie and how long that must take. No way you have time. You got to get over to the side of the building and slice the pie. You can't do it quick. You have to do it slowly, so you don't put yourself in harm's way. There's no evidence Adrian Gonzalez got to a point where he could slice the pie. And we had
You do know you have
from their expert said slice the pie.
Isn't he supposed to be the one bringing all this evidence stuff in?
Yeah, that's kind of putting the evidence on the defense. No, you are supposed to prove that he stood there.
I'm surprised that the defense, when they directed the motion, the state was never able to accurately pinpoint precisely when Adrian parked. They have this entire timeline based on, well, I saw him drive past and I assumed he parked. What if he stayed in the car and said, hey, who are you? And she's like, I'm a teacher. Blah, 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 blah.
Yeah.
How about taking a quick peek? You have cover, you have concealment.
tell me you've never been in a firefight without telling me you've never been in a firefight. Just take a quick peek. Were you
There are
that guy
still-
in Starship Troopers that got unalived because he took his helmet off? Giblets.
Yeah. Yeah, he couldn't get to the building and see because AC unit. I mean, he's arguing that the sliced pie is a straight line. Just go over there. No, the sliced pie is wherever the shooter might be, which is not alongside the building. He could be in between cars. And the moment, poof.
Yeah, you don't do a quick looky-loo, please. Again, tell me you've never been in a force multiplier fight
Yeah.
without telling me you've never been on a force multiplier fight.
And I mean, it's 1 minute and 4 seconds, of which 30 to 35 seconds, there were other officers on the scene. So that leaves the 30 seconds. Okay, what to do? He has a frantic person claiming he shot at me. He's going inside the south door. No, he's not. Okay, let's dissect the information. Now, he is the prosecutor. He needs to convict because prosecutors are supposed to search for the truth. Bullshit. They need to win because they need to be re-elected or hired as special prosecutors.
Well, so I have a kind of tinfoily hat, but I feel like they're fighting so hard for Adrian to be responsible so that the school district is protected.
Yeah.
I think the school district stands to lose a lot of money with all the information that was brought out in this trial and the
Yeah.
DOJ.
Oh, yeah.
That they need Adrian to be guilty, so civil suits, basically they can say, well, we had officers.
Yeah, but you still didn't lock the
Can't see
fucking
you.
doors.
You just peek around from a safe position. Well, it wasn't really covered. Well, it's not covered from the south side, if the gunman's over there. Adrian can see that way. It's not covered from the west side, if the gunman's over there, he's not over there, which Adrian can see. But it is covered from the northwest side, where the gunman has fired 16 shots. While Melody Flores is telling me he's over there. Echo, Adrian did tell the Rangers that there was an echo. So from his spot where he's standing, he's got to find out where that shot's coming from. And he can see on the east side it's not coming there. He can see on the south side it's not coming there. He can see on all directions except behind the building where Melody Flores is telling me he is. That's where it's coming. Not only that, but when Coronado runs up and he hears those shots within 2 seconds, he's saying, shots fired, get in the building.
Yeah, maybe.
And Adrian Gonzalez knows which building to go to. And Paige knows which building to go to. And they go to the building where the shots are fired and have been firing for 3.5 minutes. Well, let's talk about the doors, the responsibility of the doors. The doors would have slowed him up. Yes, the doors would have slowed him up. He had an AR rifle that penetrates glass. The glass is right next to the doors. He could have weakened that glass within a matter of seconds. It would have slowed him up 2 or 3 seconds to go through that door. You look at rooms 111 and 112 and you see the shots there surrounded around the window. May have slowed him up another couple of seconds if the door was locked. But we're not talking about a couple of seconds. We're talking about 3.5.
No, you literally are talking about seconds. And if seconds are important and, for Adrian, then they should damn well be important for the school. The defense has never said, nor has anyone, that the doors being locked would have prevented him from getting in the school eventually. What they would have done was slow them down. And if you want to hold people to account, the school has some splaining to do.
Minutes. Number one. Number two, the charge of endangering a child means you have to be aware the child is in imminent danger when you fail to act. And that unlocking, that failing to act, failing to lock the doors did not happen as the gunman was firing guns. The children weren't in imminent danger, immediate, close at hand danger when those doors weren't locked. Their failure to
What?
act at that was not at the point where the children were in imminent danger.
Wait a minute, I missed that. We're
He-
going back.
Yeah. Listen to this piece of garbage.
God,
More.
Immediate, close at hand danger.
Go back in 10 seconds more.
okay.
As the gunman was firing the guns. The children weren't in imminent danger, immediate, close at hand danger when those doors weren't locked. Their failure to act at that point was not at the point where the children were in imminent danger, nor is there evidence they have a statutory duty to act. And in this case, let me say, there are adults we can be very disappointed in. There can be police officers we're very disappointed in. I don't know how you feel about everybody, all those people. I'm not proud. This is the case of the state of Texas versus Adrian Gonzalez and the facts against him. And is he going to be held accountable for his lack of action?
The moment
And so
he
we concentrated
tried the
on our
door
case, on
and
the fact-
discovered it was unlocked, that is the moment the school board, school administration, and some teachers' actions put the children in imminent danger. Had that been locked, yeah, he had to have forced himself in, which would have been noticeable to the three officers looking at him. So,
mean-
yeah, this is.
This is them covering the school. Uvalde knows they're going to be bankrupt. This is,
Yeah.
we got to find someone other than the school. And I love how he's waving away. We have a lot of people we're disappointed in. No, disappointing is if I found out an officer, I don't know, went joyriding with his, you know,
I'm very disappointed in the female cop stopping to put on a sports bra before she took 20 minutes to get to the fucking school. Yeah, I'm very disappointed. I'm very disappointed in the guy up in the corner who was actually dispatched there to just fuck around for 25 minutes. That's disappointment. Actively disable locks on doors? That's beyond disappointment.
yeah, it's, he's excusing everyone else's wrongdoings. We're disappointed.
Facts against Adrian Gonzalez. It's radio dispatch's fault because they didn't give significant enough information. They just said, wreck, man with gun, shots fired. They didn't say if he was shooting at the school or not. That's important information we should have known. But their expert got on the stand and said, wreck, man with a gun, what does that say? Not a lot. A man can be with a gun, but not be all that dangerous. But what about shots fired? His testimony was, then it gets real. What does that mean to a police officer, shots fired? Then it gets real. Then on your way over there, you've got time to know, I'm facing somebody over there, shots fired. It reduces the confusion by the preparation. Shots fired. This is real. I've been trained. Shots fired at a school. Not have nothing information at school. Shots fired. Rob Elementary, man with a gun. I've been trained. I may have to go in solo. It was the police administration's fault because they didn't assign a person to each school. I suppose that statement is really, if they had assigned somebody, as long as it wasn't Adrian Gonzalez, the outcome would have been different. The defendant's case, then we move to the other police officers, Page, Hill, Sauceda, Coronado. And they'll ask you to look through your court's charge and find where it says, evaluate the conduct of Page, Hill, Sauceda, or Coronado. You're here to decide one case. But we're glad to talk to you about these officers. Page, the funeral home tape alone shows you that he shows up 2.5 to 3 minutes after Adrian Gonzalez is there. That, along with the raw videotape, shows you that he entered the building within 30 seconds. He shows up, there's shots going on, he assesses the situation in 30 seconds. He's acting. He's acting.
With other cops around him.
Hill, you recall that it's Hill's responsibility because he was called to Old Carrizo Road. He goes to Old Carrizo Road. He arrives there after the gunman is already inside the school. After the 16 shots from outside have already been fired on the other side of the school.
Which is
Testimony was
closer
there
to
was
the
radio
shooter.
chat about setting up a perimeter.
We don't actually know
So he
when
sets
he
up a
arrived
perimeter.
at that fucking
Because
corner.
here's what officers do. They get dispatched and they act. And when they get there, they assess a new set of information and they act. And after he sets up the perimeter, then he joins other people. And yes, the testimony was 25 minutes before he goes in. But Ruby Gonzalez told you that once those hallways get full, it can become dangerous to overclutter that hallway. So you find other things to do.
What he's doing
Well,
is
there's a
he's
perimeter,
trying to
doesn't that count for
rebut the
Adrian too?
defense counter arguments
Adrian got
instead
the
of
call to set
proving
up
the
perimeter, he
fucking
goes
case.
there, so be it.
Sorry for cursing so much.
But then you gather additional
No,
information.
I've been,
And that is 16 shots being fired outside, 24 shots being fired in the hallway, 60 shots being fired in classrooms, and a teacher saying, he's over there, you gotta get him. And you respond after you get the additional information. Saucedo shows up 30 seconds after the gunman has started shooting. The gunman shooting into the glass, into the classrooms. That's before Saucedo gets there. Halfway up, you know it's when Saucedo gets there because the bag is dropped. And then shots are fired. 6 shots are fired from behind a long row of cars. You're talking about him having an instant in which the gunman, we know, is hurrying the last part of that trip. We know the gunman is not firing into the building at that point. He's firing somewhere else. They think they're taking shots. If it's behind the vehicles, there's school classrooms with glass windows. If it's to the south and west, there's a man in dark blue, or black. Permission to fire. Being careful.
okay, the state has now made foundational to their fact pattern that Saucedo did in fact want to take a shot at Adrian Gonzalez.
Yeah, I just peeked over at Court TV. They have 59% vote on not guilty. Court TV. The bastion of everything the state does is gospel. Wow. I'm
And then
gonna
getting in his
check.
car and acting and following his sergeant to the end of the corner where Coronado says, I believe that's Saucedo. Also, jogging. The gunman. He's acting. When Coronado arrived to the sound of, he said he was receiving gunfire. The man at the funeral home is telling him, I think he says 2 or 3 of the building. He's the officer that came that is used to these being bailouts, and maybe it's a road rage, and that's what he's used to doing, whereas a school officer is used to protecting the school grounds. And so he's thinking,
No, the school officer would still be under the impression that this was a bailout. His assessment of what this situation would be would not be dependent upon him being a school resource officer. Nick, how did this man pass the lot? I know the bar has logic parts, right? Like
Yeah.
Mr. James is, allergic to shellfish and can't sit next to Cletus or some. I know they have logic questions. How did this man pass?
This is a road rage, and the guy's shooting at us because he doesn't want us to get him. So he goes around to cut him off. But in going around to cut him off, he's acting. He's acting to stop the shooter. You may not like his decision, you may not be proud of his decision, but he's acting. This is a failure to act case. And you know that he's acting because he jogs, he's looking for the gunman. And when he hears shots fired,
Facts not in evidence that that was a jog. I speak as
Yeah.
a former fluffy person.
Yeah,
That
and
was a waddle.
I am fluffy. That was a waddle, and now you're talking about a portion of time when he wobbled and he had shots, and I hate to say it, but out of these 19 dead kids, almost all of them are already dead.
Yes, the first bursts of fire were within the first minute or 2 minutes that he got into the school.
Yeah,
By the time they were trying to engage him in the hallway, those children had already been shot.
yeah, and his action was they heard shots, and they chose all three of them to drive around the school instead of one of us has to cover the front door. Just in case he runs out of that again. Maybe he'll see. No, oh hell no. Oh hell no!
he acts within 2 seconds. Get in the building, shots fired, and he goes in. He acts. And then the defense brought you evidence of the challenges that Adrian was facing. We start with tunnel vision. That's the whole issue about whether or not Adrian Gonzalez saw the gunman in the parking lot. We have no trouble with the concept that he had tunnel vision and focused on the lady in peach. This charge does not start with Adrian Gonzalez arriving at Robb Elementary. The charge starts specifically with, after hearing shots fired, after Melody Flores, witness number 1, which you can conclude now is Melody Flores, told him.
Oh,
Should we be
wha-
11 days in, and should the jury be guessing who witness 1 is at this point?
okay. So, but now, this might be good because now he said after. All of a sudden, now you're down another 10, 15, 20 seconds of their
Yeah.
timeline, which was 1 minute and 4 seconds. Now you're at the point where the other cops already entered the scene.
The general location of the shooter, and then having time to act. That's when the case starts. So he has tunnel vision. Okay. Auditory exclusion, perhaps he didn't hear the shots. Then why would you tell the Rangers when Melody Flores told me where he was, I heard the shots? How does that happen? This was really complicated. Complicated set of facts I have to decide on. Complication, the training is you hear shots, you go to the gunfire. He heard shots and Melody Flores was pointing where to go to the gunfire. There's nothing complicated about that. He's wearing black. He's over in the teacher's parking lot. Go to the gunfire. Perimeter. Why doesn't Adrian get to set up the perimeter if Hill gets to? Why didn't Adrian tell the Rangers? I heard I was supposed to set up the perimeter. That's why I set up the perimeter. That isn't what he said. He said, I waited for cover before I was going in. And finally, this is the issue of stress. And this is my closing remark. I'm sure you're tired of listening to me. That was a dark day. 29 families, it was extremely dark, and they still wait justice. And I can't let that darkness. But I can say this, there were some bright spots. In that stress, teachers put their kids first. In that stress, kids made ways to try to defend each other. In that stress, kids comforted teachers. In that stress, kids came first. Adrian Gonzalez had a duty to put the kids first. And he called for cover.
Thank God that's over.
Yeah, they still have
Procedural.
45
Yes, sir,
minutes
please.
for rebuttal closing.
Nick, just let me be happy the bad man's done for 5 minutes.
Yeah. Now the defense has their hour and a half. I'm not sure they might decide to use it all, or they can decide to do everything that guy said is bullshit.
Please, just do that and sit down.
Yeah.
Ooh, Yukon Cornelius is ready to go. Dueling poster boards? Oh my God.
Yeah. One thing I hope he will say is, if Melody Flores is witness number 1, why was she excluded from the critical timeline?
Yeah. I think that because, again, the state failed to put in his critical timeline, and Melody was so disjointed that even her normal speech, like just asking her, what do you do for the day? Well, I like all this stuff. She isn't coherent even on normal questions.
The monster who hurt those kids is dead. That monster is dead. And we told you from the beginning. And it is one of the worst things that ever happened. And I told you, the first time I stood up here and talked to you, I told you that you were not going to be the same person when you come out of this. And nor should you be. Nor should any of us. Witnessing horror, the tragedy, the loss, it's immeasurable. It's immeasurable. It's unthinkable. That loss is unthinkable. Their loss, it's unthinkable for any of us. You know, I told you guys that I have a 4-year-old and 1-year-old. And, you know, we told you we're from San Antonio. And obviously, you know, I want to go back and see him on the weekends after the first week. I went back. The first thing I did was my 4-year-old came downstairs and I hugged him. Right? I hugged him. Started crying. His hair, you know, trying to, so he didn't see it. He said, "You sad, Daddy?" I said, "No, I'm happy. I'm holding him." Because I know what a privilege, doing this case, I know what a privilege it is to hold that child. I do. Right? I know, I can just imagine what it's like to not be able to do that. And I can imagine the pain, and I can imagine the anger. I can imagine wanting to put somebody in that chair because I can't put the monster that did that to my child in that chair. I can imagine that. And I can imagine putting pressure. And I can imagine them responding to the pressure. And I can imagine them putting him in that chair. Him and only him. In that chair. To try to pay for the pain. To try to somehow this can cover the immeasurable and the immense loss. And so after I saw him on Friday, we have to come back here that Sunday, the first week. And Gary, he comes and picks me up. That's kind of what we've been doing. My son comes down and he says, "Are you going to go help that man?" That's what we told him was the reason I'm not here. I said, "Yeah, I'm going to go help that man." Adrian Gonzalez. Because he needs my help. He needs our help. Because they, the government, the power of the state, has decided that he has to pay for the failures of that day, for the mistakes that were made that day, and for all the pain that they feel. And it's not right. Because the person that they plucked out and put in that chair, that person showed, we showed throughout this trial, that person was acting. He was acting. He was trying. And what I hear from the prosecutor, what I hear from the state, and what you've heard this entire time, what you've heard is that they will massage all the facts, they'll twist them all into a pretzel. That every one of these officers is fine, he's not. They'll twist it. Well, look who acted. They acted. Well, Adrian acted. Well, he didn't act the right way. They acted. Well, they didn't act the right way. But yeah, but he didn't act the right way, and he didn't know exactly what was going on, and he remained. Well, yeah, but Adrian remained in the hallway. Adrian remained in the hallway after he got shot at. Well, yeah, he remained in danger at that point, but before that point, he remained, and he didn't know what was going on. Every fact that they've tried to bring, they twisted it around. I'm going to show you. You're going to watch. I'm going to show you what they've done to twist this thing from the beginning to the end. But ultimately, what we're talking about is we're talking about duty, we're talking about burden, and all of those things. And I don't want one thing that I'm saying right now to make you believe that he doesn't believe that he has a duty to stop something that he knows is going on. Of course he does. He knows that. He was trying to do it. He started trying to do his duty. You look at some of these other people, no. They're not trying to do their duty. They're trying to stay back. And one of the things that the prosecutor said, he said, what you do here will tell law enforcement, give them how they respond. I'll tell you what, I agree with that, but not in the way that he's saying it. Because the way he wants you to believe it is what your verdict says is that next time, these officers will make the right choice, the right decision. They will respond appropriately. They will be perfect. But the problem is that the issues here are not that Adrian failed to respond. They're not that he was intending not to engage. So you're not going to fix any of that. Because I'll tell you, and I kind of hope it never happens again. I think we all know that it probably will. But those officers, what your verdict says is not going to make them perfect the next time. It's not going to make them not make mistakes. It's not going to make them not interpret things differently, strangely, weirdly, based on their own experiences. That's not what it's going to do. But I'll tell you what it would do. If you convict them, they're all going to be Randy Hill on that perimeter. There's nobody going in. What do? You went in. You convict him. What does it tell?
I say he listened to us too. Yeah, I would say with 100% certainty, he got it from us.
Yeah, and I think this is really good. I was a little leery when he started out with the personal story, but I think he's really humanizing all the feelings that these jurors are having to deal with. This is an incredibly sad case. I feel angry. I feel frustrated. I want to punish someone, but what do I do? And is punishing Adrian right? He is kind of putting those into context because the jury has had to see all the unvarnished, unfiltered things. And he's like, I get it. I get wanting to do something.
Yeah. And I believe he's correct. If Adrian is convicted, every cop will turn into Mr. Hill or Mr. Susado and let's drive around. Let's not engage. Yeah.
She's going to tell him, I'm not getting in that crowd. I'm not getting in that chair. If I see somebody running towards the school, I'm not going after them because if I'm mistaken and it takes me to the other side of the building from where the shooter is and then I can't understand or know where the shooter is, I can go to prison. I can get prosecuted. So what you tell police officers is don't go in, don't react, don't respond, stay on the perimeter because Randy Hill isn't sitting in that chair. He's not. Adrian Gonzalez is here. Randy Hill is not. None of those officers are in that chair. That's what you're going to tell them. You're going to tell them, don't do it. And you can't tell them that. It's like, I agree with them. You can't tell them that. We cannot have law enforcement feel that way. Feel like if they're not perfect, if they don't make a perfect decision. And that's where they go. And their family goes right there. There's nothing that's going to bring these kids back. There's nothing ever is going to solve that pain. Nothing, not that. Because one of the things that Bill said to you is he said, those kids deserve to be remembered, and they do. But you do not honor their memory by doing an injustice in their name. You don't.
That
Yeah.
right there. And that's what Bill has been totally leaning on. Those kids deserve justice. It doesn't matter who we charge. Those parents deserve to see someone in shackles.
Yeah. And having Adrian charged, I don't know anything about the police chief, what evidence they have against him, but by not even having, to my knowledge, none on the school board or school administration has even been reprimanded for leaving the fucking doors open, making the classrooms into a fucking shooting range. None of them reprimanded.
Boosting a little. I've already got the court boosted on 2 boosters.
That does not honor those children. By doing an injustice, by doing what they want you to do, by letting him massage the facts, by letting the pretzel go all the way around and miss everybody else, but keeps going right back to him, because that's what they need. We talk about the charge. If I can get it up. The duty. So remember this about what the court has read to you. And remember, I'm not saying he doesn't have a duty. Of course he does. But just like every officer, just like the officers in San Antonio, they all had the duty. But and it may have sounded flippant when we compared it. We said, look, you're in San Antonio. You hear there's a school shooting, right? You didn't stop it. Well, no, because it's not happening in the presence. And the reason we're asking that question is because the law is specific about it. A person, they have a duty to prevent an offense against a person about to be committed in his presence. So the first thing you have to figure out is that in his presence? You know, and the judge told you, you know, use common meanings, but he is here, and he never, they're not even disputing, he never saw the shooter, ever. He is never in the presence of the shooter. Now what Bill may say is, well, he didn't go to the presence. But that's not what this law says. Law doesn't say you have to go and find yourself and make yourself be in the presence, and I'm not trying to make any excuse about that. But the law is the law is the law. This isn't about you have to go seek it out and make it happen in your presence. The law is saying if it's happening right there, there's a duty. Of course there is. He was doing his duty. He was running to the danger. He was driving right in there. If that was the gunman, and God, I wish it was, he would have ran him right over. That's what he was doing. He's going 50 miles an hour at that person. Now, what I'm glad is he didn't run the person over because he realized it's Melody Flores. He realized it's a coach is what he thought, teacher's aide. But he realized who it was after it's already too late, but he's here. And from this point, that shooter is never in his presence, ever. There's never a time. The only time that he gets close is when he goes, one of the first 5 people to go up that hallway. That is a hallway of death. Anyone going into that hallway knows, anyone knows, any police officer knows, that those rifle rounds start coming that way as they're coming up the hallway, it's death. They don't have any equipment. They don't have anything to block it. It's death. He went in that hallway of death. See, and I thought about it, because, you know, there's no way I can tell you about how they feel. But I thought about it as a parent. As a parent with kids there, if I knew that while my kid was in that classroom, somebody was going up that hallway, risking death to try to get to him, I'd appreciate it. I would. I mean, they're not perfect. But the person who did it, the monster, is dead. But he went up. A lot of people there didn't. A lot of people didn't enter that building until it was the room was surrounded on all sides by officers with rifles. Not one person on the side that he went in had one. Not one person had an AR. Not one person had a rifle. And they went in. Donald Page went in. Coronado went in. Chief Arredondo went in. Those people all went in and risked certain death. And the only time that he could have even been close to being in the presence of the shooter is when the shooter shot at him and Page through the wall. And you heard that testimony that there's gunshots going through the wall that they have to back up because not only can they not get to the door at all, they cannot get to the door. Joe Vasquez told you, that door, you're going to die at the door. You will die at the door. And I know that what the prosecution's saying is you should. Your job is to die at the door. But there was a lot of people out there. And if that's the training, die at the door, then everybody out there didn't follow it. Everybody out there waited until there was shield. Everybody out there, Joe Vasquez included. Everybody. And you remember what Joe said. He said, you know, thought his daughter could be in there. And he still waits 50 minutes for shields, for a plan, for BORTAC. So that's what I'm saying. They're twisting it around and they're saying, well, his job, every shot was noticed that Adrian had to go in and be the person to die at the door. To be the person that tried to breach, solo entry with nothing. But nobody else did that. So is that the training? right? Like, that's one of the things that you have the right to go, because that's count 2, disregarding his training. Is that the training? Because if that is the training, and all these officers have been trained, and not one of them does it, but only one of them sits there, right? Like, you have to twist it. Every time, for every fact, has to be twisted around. That no other officer, I mean, I'm assuming, I mean, they made a point. Everybody's trained an active shooter. But that's why we pointed out that, well, now it's become a barricaded subject. And that training's different than active shooter. Now, some people are treating it like a hostage situation. And that's different than active shooter. And so the point is with this training is this training was never meant to be twisted and used like this. You think that anybody that's put it on police training is going, yeah, and if you don't follow this, you're going to prison? I mean, that's not what they're doing. They're trying to give the best possible tactics and strategies to get to the best possible outcome. That's the point. But go back to the duty. If you find right there, you know, honestly, he was never in the shooter's presence. Never was in his presence. Because that law, do not let them argue that that law means that he has to go put himself in the presence. That law says it has to be in his presence. That's what that says. And if that's there, and you say that wasn't in his presence, then it doesn't apply. Under 605, he has a duty to prevent the threat to do injury if within his power. So they have to prove to you beyond a reasonable doubt that it's within his power. Because what they're not talking about is, no, this is saying you have the duty to go and follow the gunfire. That's not what this says. It doesn't say you have a duty to follow the gunfire. What it says is if it's within his power. So all of the officers before the breach, all the officers that even, I mean, and I don't have anything bad to say about Joe Vasquez. That man went in there. He went in there and he was willing to put his life on the line. But going in there like that in that room, it's not a whole lot different than going up that hallway, the first people to go up there, without any protection, without any rifle rated anything, without any fire, without any rifles, without anything. But what that's telling you is that the reason that they waited is because it was within none of their power to get in that room. It was within none of their power to do that. It was not within his power to get in there and stop it, and it was not within any of those other guys until they got the right equipment. And then they went in, and it was within their power. But if they haven't proven to you beyond a reasonable doubt that Adrian could have done something to prevent, if beyond a reasonable doubt, then that doesn't apply. And then, of course, the education code just says he protects the safety and welfare of people in his jurisdiction. Well, of course. But that's not a duty. I don't even understand why it's there. It's not a duty to say, well, yes, and if you violate it, you go to prison. If you violate it, you're a convicted felon. If you violate it, you're going to be on trial. That's just telling police officers, and especially those who work at schools, that your duty is to do that. Of course it is. That's your job. Of course it is. But what we're talking about is we're talking about a man who is trying to do that. He is not trying to do that. He's not going, I'm not protecting anybody. Oh, shooter. And then drive off the other way. He doesn't drive around the building. He doesn't drive away from the gunfire. He's still trying to figure this out, because we're talking about 1 minute and 48 seconds under their indictment. He keeps saying 3 minutes, but it's 1 minute and 48 seconds. I showed you this on board hour. When we talk about beyond a reasonable doubt, possibly, probably, guilt likely, strong belief. If you have a strong belief that he had a duty, it's not guilty. Right there. That's why I'm talking about duty first, because as the prosecutor explained, if there's not a duty, then there's not. And not one of this is to be interpreted as me saying that he doesn't have a duty. We all have a duty to each other. And he's a police officer, and he's going to do what he can. But when we're talking about criminal charges, if you even have been to, well, it's likely that he does have that duty. It's likely that it was within his power. It's likely that it was within his presence. I have a strong belief it was in his presence. I have a strong belief that it was within his power. That's not guilty. It's a verdict of not guilty right there. That's the first consideration. But going to the indictment, after hearing gunshots and after being advised of the general location of the shooter, and Nico's going to talk to you a lot more about this, like, it's convenient the way they're twisting it. It's convenient the way they're saying, well, of course, he was advised. She told him, 1, 2, 3, and told him exactly where it was, and she pointed over, she's over here, pointed over there, and he knew. That's how they're presenting it to you. But that's not how we know that that's not how it happened. We know, we have to know, because she is frantic. She is very unclear about a lot of things. And so if you have a reasonable doubt that he was advised of the general location of the shooter, that's not guilty. If you have a reasonable doubt that he had time to respond to the shooter. Clicker slow on the uptake. Right, having time to respond to the shooter. If you have a reasonable doubt as to that, it's not guilty. Right, because what we established, and you know, even now when he's reading Adrian's statement, shots fired, or she told me where it was, shots fired, I radioed it out. He's compressing time in his interview. We're going to talk about that. He's compressing that time. The way he's telling it, she tells him, da-da-da, and then he communicates it on the radio. We know that that's not what happened. We know that from the time of shots fired to the time he communicates it on the radio is a longer period of time, which is accounted for by the fact that he is trying to get the information out of her. Once he does, he communicates it. Once he communicates it, we told you, it's a second after this monster's already gotten in. Not an unlocked door, but it's already gotten in that door. When he communicates this out, the guy's already there. So having time to respond. Once he finally figures out what it is, does he have time to respond? And if he does respond, we were showing you, if he does respond over here, he's responding to something that's not even there anymore. He's doing basically what Coronado does, which is go completely away from where they saw him go in and go all the way around the building. So if there's a reasonable doubt as to having time to respond, that's not guilty. Any reasonable doubt as to any of these things, these are all elements that they have to prove to you beyond a reasonable doubt. And if there's any reasonable doubt as to any of these things, if there's a reasonable doubt as to Melody Flores and what she said, that doesn't say anything about her. That woman was traumatized. Of course she's going to be confused. Of course she's going to say it's a handgun when it's a rifle. Of course she's going to describe a completely different police car. Of course she's going to do those things because she's traumatized. But the reason we point those things out is they want him to be perfect, but they have to be perfect. They have to convince you perfectly, almost, beyond a reasonable doubt of their evidence. And that evidence rests on what did Melody Flores say and when did she say it? And they did not prove that. They did not prove it because even when she testified, and Nico's going to go over it, she agreed that she was not just saying clearly, hi, this is what's happening, but this is where it is. She was saying a lot of different things. And it goes back to that chart. Anywhere you are, if you're suspected, if he's possibly guilty, if he's probably guilty, I told you at Bordire, I mean, you know, most people get convicted at that probably. Because jurors go, well, he's probably guilty, so they convict him. But that's not what the standard is. That's not what the law says. The law says it has to be beyond a reasonable doubt. It's the only way that our Constitution works. It's the only way our system of justice works. Now let's talk about this. Let's talk about Ranger Hill. Look at this. I froze it on this animation that we did. Right at the point that Adrian's passing that spot. And that's where he has the shooter. He says it's approximate. Well, guess what? Approximate's not beyond a reasonable doubt. Their whole case is based on approximate guesses, speculation. We don't know. We're just really mad. We're upset that we have to put somebody here. Somebody's got to go in that chair because the guy who actually did this thing, the monster who did this, cannot go in that chair. He's dead. And good riddance. Good riddance. The devastation and the destruction he caused is unlike almost anything that has happened to us as a country, as a people, and definitely in the state of Texas. The devastation that he caused. Children that young and that many. Good riddance. But that's not him. But they have to have somebody. So what do? They give you an animation. It looks like that. Which, as we know, we had to bring a witness. We had to bring Claudia to tell you and to show you. Look, you'll see him. He's walking right there. And you see him walking in between those cars, and he stays there. Now, in a few seconds, you're going to see Adrian's car drive by. His head kind of popped down when it happens. he's going right there. You see the white car is flashing right through. That's Adrian driving by him between the cars. So what would an honest rendition of what you just saw, what Claudia testified, what does an honest rendition of that look like? It looks like that. That's what that animation should have looked like. Because we have actual proof. And Ranger Hill can't act like he didn't know that existed.
They took Dilbert, Texas Rangers, and remember when Dilbert, the Texas Ranger, said he saw the puff of smoke?
Yeah.
Well, that puff of smoke was when the shooter was in between cars. How did he know? How did he see the puff of smoke and not the shooter in between cars?
Yeah.
Because he's a lying sack of shit who knew, oh, we are going for a conviction. I have to alter things despite evidence. Hi, Tammy.
Yeah, this is egregious, in my opinion, how badly the state represented
Yeah.
the evidence.
Now, I went
Especially
through
knowing-
this. Yeah, I went through this timeline with Sean. I have an entire separate video about how shit this and we went through it as well. I don't know how many other times and how many more times and in how many ways you can tell Dilbert, Texas Ranger, to go fuck himself.
Yeah, this was entirely meant to get a conviction.
Yeah.
And not
And it's
show
great
the
that the
truth.
defense is showing what actually happened. Not only because, hey, we show you the truth. Look at what the state does. They're trying
Yeah.
to falsify evidence, in my opinion.
This did, he told you about the puff of smoke. That's the same video he's looking at. He knows that this guy's between the cars. But he told y'all, they sponsored it, that he was here. Why are they doing that? Because they're willing to twist things. They're willing to twist things for you guys in order for you to do their bidding. But those kids aren't honored by an injustice in their name. It's not honored by a conviction in their name.
And traced the window going out over in 111. Melody Flores is still urging that humans always to go in. She sees the shot come through the window. Adrian Gonzalez tells the police that she's the shot go through the window. Adrian Gonzalez gets on the radio and says, guys, I think he's made it in the building.
See, that's what they told you at the beginning. They told you that.
Wow.
Oh my God.
This is what the prosecutor said. Fuck him.
Oh my God, Cornel Union. Look, I'm gonna have to actually figure out this man's name, but Suspenders, I may love you right now. I have a totally lawful crush on you for law.
I'm surprised that he is allowed to show it because prosecutor's word is not evidence. I'm
But we're
surprised.
gonna,
Yep, but I'll take it.
we're gonna watch it again.
Yep.
Melody Flores is still urging Adrian Gonzalez to go in. She sees the shot come through the window. Adrian Gonzalez tells the police that she's the shot go through the window. Adrian Gonzalez gets on the radio and says, guys, I think he's made it in the building.
See, that's what they told you at the beginning. They told you that Adrian Gonzalez got on the radio and said, guys, I think he's made it in the building. Why are they telling you that? Because they want you to believe that he had that knowledge early, that he knew that he was in the building. What else did he say? In the opening statement to you, that Melody Flores saw the gunshot go through the window. When she testified, she said, I didn't see that. Why is it important? It's because Coronado, we've talked about it, and I feel like it keeps going into a memory hole every time it goes back over here. Right here, Coronado says, guys, I think he made it in the building. He established that. He said, he's the guy on the radio, he's the guy that thinks. Even Ranger Hill said, Coronado is the one who said that. Why did he say that? Because these three saw him do it. Because these three had line of sight. And he's radioing that around. And one thing we were clear to point out is that a gunshot did go off at the exact same time as that transmission. Why is that important? Because we don't know who heard that or who didn't. We don't know who heard Coronado go out and say that he's in the building. But We know that Coronado knew that, or said that. And so that's the knowledge he has when he's driving around. Why is that important? Because prosecution, what have they tried to make you think? Coronado knew immediately that the gunfire was coming from the building. Coronado knew immediately that. Look at Coronado. He knew it immediately. Of course he did. He saw him move the building on the side. He knew it from here. Once he came around here.
Object to that. That's not admitted into evidence. There's no evidence that Coronado saw the shooter. There's no testimony of that or anything like that. So now he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what the lawyers say is not evidence. If the evidence, based upon your recollection, differs, rely on your own. You may proceed.
Well, and I can understand why they're trying to fight against that, because look, this is, what I'm saying is we know that he radioed, I think he's in the building. When he's on this side of the building going to the other side, we know why. He testified, I thought he was going through the building, which implies that he knows that he went in to the building. But they keep fighting against that because this, knowing that he's gone into the building on this side, all their training, what does it say? The gunfire. Even Ranger Hill they're twisting everything. They're twisting it all around. Ranger Hill said, well, yes, going to the gunfire is going all the way around here to the other side of the building, from where you saw him enter and from where you heard and saw him shooting into the building. So that to them is going to the gunfire. That to them is following their training, exactly how they're supposed to. That to them is working to distract, delay, all the things they've charged him with. Well, they're not charged because they did that, even though they watched this happen. Had to have. And then Mike Whitskill. Now, I thought this was interesting. Mike Whitskill, I mean, he's an interesting guy. He said, I'm here as an expert witness in training, right? He didn't have any opinion. This is the interesting thing. The state had every opportunity to have Mike Whitskill go, I trained this guy. And I've seen all this stuff that you've given. And I reviewed all of these things. And Adrian Gonzalez did not follow the training that I had. They had every opportunity to do that, and they didn't. They didn't ask him. He said, I didn't review anything. I don't have any opinion about whether or not Adrian Gonzalez followed his training. In fact, you don't have any opinion at all. You don't have any real statement from anybody about whether or not he followed his training. And the things that you have from the officers are always with a caveat. Yes, you run to the gunfire if you know where it's coming from. If you don't know where it's coming from, you take cover and assess until you know where it is coming from. That's the first thing. You run towards the gunfire if you know where it's coming from. You look at their active shooter trainings. All the active shooter trainings involve them seeing the shooter and then going after the shooter, which makes sense. But they are prosecuting a person that they will have to admit, and they have admitted, and they've stipulated and never contested that Adrian never saw the shooter. I mean, he talked about the death by PowerPoint. In Adrian's 40-hour class that they were talking about, the 40-hour class he took, he said, look, we do 75-25, the practical versus the death by PowerPoint. I'll point out that, and you'll see that in the training that the prosecution mentioned about, well, Adrian taught a training. He facilitated a training. He did. There was somebody else who wrote the materials. There was somebody else who did it. And that's really what they kind of do. They have to facilitate for each other so that they can get their training hours. But in these trainings that are happening, in the trainings that are going on, all of the trainings are training them to come in, have a rifle, come in, go in and be prepared to come in and do those things, and mainly to come in and see the shooter. Mainly to come in and know where the shots and the shooter is happening. And what they have done is they have just said, well, we don't care. Yeah, he said he didn't know where the shooter was. We don't believe him. We believe everybody else. Everybody else gets a pass. Everybody else. Randy Hill gets a pass. Saucedo gets a pass. Well, yeah. Saucedo said, I think I see him, permission to shoot. Well, we don't believe he said that. Or if he did say that, he had kids behind him, so he shouldn't shoot. That's crazy. That's crazy. Talking about this backdrop, that's crazy. And if that's the case, these officers are being overtrained on backdrop, because you do not fail to shoot a mass murderer of children because there's a backdrop where you could potentially shoot a child. You don't do that. You have to take that shot. And so if that's what they're saying, well, no, Sauceda has a reason why, because there's this backdrop. But then we pointed out, well, if Adrian did what they were asking him to do and came around here, we know now that by the time he transmitted, the guy's in the school, so he would have come around and nobody'd be there. Even, thank you. But even if he came around and somebody was there, shooting back here that's his backdrop too. But nope, not for him. No excuse we make for every other person there applies to him. And I think that there's something fundamental in each one of us. I think it's fundamental in each one of you that that's not fair. I think it's fundamental that that's not how justice is supposed to be done. It's not. It is not fair. It's not how justice is done, that they can do that and interpret every fact against him, but for everybody else, similarly situated or better situated. He agrees it takes 10,000 hours of practice to reach expertise. I mean, these are not experts. Adrian is not a SWAT expert. He is not an active shooter expert, right? He is doing the best he can, and this was obviously the worst situation of his or any of their law enforcement lives. I mean, it's just like 5 years to be one. I mean, the training is so extensive, and it's much, much more than Mike Whitskill gave 40 hours on that day. And then they talk about, well, you stop the killing, stop the dying. They never tell you how in these trainings. They never say how. They never say, how do you do it? How do you do it if it's just you and a gun, and they have a rifle and you're in an open field? They don't say how. They just say do it. Go in, win the game. Now, this is what in his instructor course, CME does not endorse nor encourage going it alone. See, what I'm saying is that these are sending mixed messages to the people who are being trained. They're reading this. They're seeing it. And then when you're talking about beyond...
I think it's really good to put this in because the state kind of glossed over this, but there were contradictory instructions.
Yeah. Yeah, I agree.
reasonable doubt.
Oh, sorry. I'm used to you having control of the button in the morning, so I'm like, oh, okay, you start. Oh, wait, no, it's me.
On count 2, did he follow his training? It's like, even in the training, they're telling you, well, you should go in, but we don't endorse, we don't encourage it. Because having greater numbers significantly improves a first responder's odds for success. Now, what does that mean, odds for success? Because what they keep saying is that there's a continuum of life scale, and there's a priority of life scale, right? And then proof success. This is not saying odds for success meaning odds that I stay alive as an officer. Odds for success in being able to protect civilians. Odds for success in being able to actually do this. Because if you try to just run in and you don't have any of that, that shooter, remember the shield comes in when they finally came in, pop, 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 he's putting it right on the shield. The guy in the back of the stick, he comes in, shot in the head. That guy was ready. And anybody who approached that door was dead at the door. They were dead at that door. So what they're saying is the numbers improve the first responders' odds for success in saving lives because a dead police officer is protecting no one.
I like this reframing because it's taking the cowardice angle out of it and it's framing it as you want this man or this person stopped. You have a better chance of stopping him with more than one person.
Yeah. And of course, the first group of officers after these first ones should have brought shields and everything, and it would have been over in less than 10 minutes. But they fucked around for over an hour. But these first responders, especially Adrian, he didn't see the shooter. And once, okay, shots fired, went in, even though they hadn't. Because what we saw on that are just this few officers. While they are running around and when they enter the building, this road up there is filled with cop cars. Because people showed up and did nothing.
Also,
except being in the way.
Notice the fundamental different people that the state and the defense are talking to.
Yeah.
The state, in their closing, thought about what the defense was going to think. The defense thought about what is the jury wondering about? They have to be noticing this double standard. Let's point it out.
Yeah.
What do we think that the jury needs to know? So they approached it like that. The state approached it, well, we think that the defense is going to say this. We think the defense is going to say that. It was not, we've proven this, is we're going to disprove what the defense has proven.
Yeah, they are trying to make it into a defense case where guilty until proven innocent. And everybody please think of the children.
Yeah.
It's the prosecution here is pissing me off,
Yes.
and has done from day two at least.
Yeah.
And that's what his training says. That's the person they brought you to say what his training was. That's what the training says. So they're sending mixed messages to these officers, and then if you better read the mixed message the right way, or the way they want you to read it, otherwise you're in this chair. It's not right. We saw the training pictures. This is how they're training to respond to active shooter. You got two people, you got rifles, they're coming in together, they're coming in different ways. That's how they're training. But that's not how it was. And we said in those hundreds of pictures, they didn't bring you one picture where they're coming in with all they got is a gun. All they got is a handgun. Not one in the hundreds that they took at that training. Because they're training these officers to have the right equipment. Adrian didn't, because the school district didn't buy it. Bailouts, we talked about it. Why is it important?
We haven't been made aware that I wonder if he can get away with saying that, or if that was something that was stipulated, because we haven't really talked about the schools if it was their job to provide equipment, or if it was the police force. 'Cause
Yeah.
I don't.
Yeah, I'm not sure the economic responsibility for the school resource officer.
My guess, he wouldn't have said it if it wasn't true.
Yeah. So the same administration that handed out magnets to teachers because it's a hassle to lock the doors are the same people who more or less told their school resource officers, you're handgun alone.
Pretty much.
Because everybody is responding strangely to this thing because of this wreck. They all think, they're going, well, it's okay that Coronado and them thought, well, this guy's running through the school because it's a bailout and he's just trying to get away from us. But it's not okay that Adrian thought that that could happen. It's not okay if Adrian's standing here going, well, these guys are here and I'm here and I don't know where these shots are coming from, but he's probably trying to go here. I still have a whole school down here. It's not okay if Adrian thought bailout, no, he didn't follow his training. What Adrian said, he cooperated every time. Remember, this is a day later, and you know he's experiencing time compression. You know he's doing that because he's saying, I hear the shots, she's telling me I radio it out. That's not how it happened. So he's going through the same problems that we've talked about in all the other witnesses having to recount and recall what happened. He's having that same issue. He drove to the danger, and Nico will talk more about it. And then hindsight bias. And here's the thing that they keep trying to get him on. They go, because hindsight bias for Adrian is, when he's telling the story about what happened, he says, yes, it was a female, it was a coach. Because he now knows that that's the truth. At the time, though, he did not know that. At the time, he didn't think it was a woman. He thought it was the shooter at the time. But when he's telling the story, he's now telling it in a way, using the knowledge that he has, and he's explaining the story. And the same thing goes for when he's talking about what Melody Flores told him. When he's talking about what he understood, he did eventually understand what she was communicating and communicated it out. But in hindsight bias, he's not going through with the ranger, and the ranger's not asking, was she clear about it? Do we know did you know beyond a reasonable doubt when you got out of the car that she said that he's over there and you knew exactly where it was? He didn't follow up with any of that. So what Adrian's doing at the time of interview is he's skipping all that stuff. And he's getting to, I figured out what she was trying to say, and I communicated it out on the radio. He skipped it all, because nobody's asking him. Because when they interviewed him, they're not prosecuting him. They don't think he did anything wrong. Nobody does. Nobody does. Until years later, after all of this, they had somebody's got to go in that chair. So, ultimately, it's the same thing I said from the beginning. You know, I told my kid, and so I'm here. I'm here, I'm helping this man. But I can't be the only one, and Nico can't be the only one, and Gary can't be the only one. He needs your help too. Y'all are all citizens, and he needs you. He needs you to look at these facts as you have. And y'all have been very attentive, and y'all have to see very horrible things and hear horrible things. A lot of those things didn't have anything to do with those 3 minutes. Why did they bring it? You know why they brought it. You know why they tried to do it. The horror to make you so angry with him that you convicted. They played on your emotions. They presented all that in front of them. They're trying to do all of that, but they're not really going to what Adrian was experiencing and thinking and feeling on that day. But the one thing you do know, he went up that hallway. The one thing you do know, he went after somebody he thought was the gunman. That man didn't just stand by. He acted, except they just ignore all of his actions because they're trying to pretzel it, massage it, get it in there, do anything that they can to get the conviction. It's the most horrible thing, one of the most horrible things ever. One of the most horrible things that's ever happened in this state. But those kids are not served. The memory of those children, that I agree should be honored, is not honored by an injustice in their name. It's not. And so we're asking you to find them that guilty.
All right, ladies and gentlemen of the jury, we had discussed prior to beginning the argument to take a break at some point, and everybody agreed this would be a good time to do it. So take 10 minutes, and we will resume the arguments. Do it as quickly as you can. We'll be in recess for 10 minutes. Remember my instructions, do not discuss the case.
I think we might be far enough behind that we can skip through the entire break. I'm an unintentional genius.
And now it's Nico. It's Nico time.
Suave.
Okay, be seated in the courtroom, please. All right, members of the jury, when we recessed, the defense was in its closing argument. You may proceed.
Thank you, Court Judge. Closing counsel. I think what we're all struggling with is how could one person do such a horrific and evil act to those children? And it's real. I mean, we're all thinking it. We're not immune from it. Everyone's thinking that. And the issue is that generates emotion. This has been an emotional trial. I can only imagine what it is to the families, and I'm going to talk about that in a second. I know it's been emotional for you. We've been watching you, rightfully so. It's been emotional to you. It's been emotional to us as well. Do you not think that burly man, when he goes home and he gave you that story about his son, that he's not digging his face in his chest, weeping? I have permission to say this because he did. Weeping. Do you not think that Gary, when he's doing FaceTime with his twins, that he stays on a little bit longer or lets them call past their bedtime so he can talk to them, never knowing if that's that last time? Do you not think that Michelle doesn't rush home to go to her granddaughter's games? Because she does. It's emotional for all of us. Or Joseph, and he gets away and disappears at the house that we're staying in because he wants to talk to his children, making sure they're okay. I shared with you in jury selection the journey my parents went on and my family went on with the murder of my brother in our driveway. Do you not think that when I close my eyes that I don't rethink picking up my mom off the ground in our driveway, loading my brother's body on the gurney after they finished the investigation and helping my pop wash off my brother's blood in our driveway? There's nothing like a mama's cry. Nothing like a mom's cry. You can't explain it. Nothing compares to it. And that's real. And we don't ignore that. It's never been us against the family. It's never been Adrian against the family. It's been a pursuit for truth. Remember the totality of the circumstances? It's a pursuit for truth. And because this has been so emotional, the only way that can be dealt with in a justice system is through a jury trial. I love a jury trial. I love the justice system. Thomas Jefferson, as we talked about in jury selection, we talked about Thomas Jefferson. This has a little bit of a delay. I consider trial by jury as the only anchor ever yet imagined by man, by which the government can be held to the principles of its Constitution. One of our founding fathers believed that. I do. In a system of the people, by the people, and for the people, you're the equalizer. You're the one that has the final say. With all due respect to the judge, who I respect very much, not him, not the bailiffs, Not the government for sure, not even the defense, it's you, it's the people. And that's why I love a jury trial. And it deals with the emotion. It's the only way to balance this emotion and reason. And I say this respectfully as I can. They're trying to hijack your emotion to circumvent your reason. That's what they're trying to do. But they're your emotions, but they're being hijacked. And we know that. So how do you deal with that? Because in a world where we don't agree on anything, we definitely don't agree on politics. We don't agree on worldview and religion. We don't agree on definitions. Most people agree, no matter where you're at, most people agree that we don't want innocent people convicted and punished. Most people agree on that. And the only way we do that is through the justice system. And the representative of that is Lady Justice. She represents the justice system. Not Lady Liberty, it's Lady Justice. And this comes back from the Greek times, the Roman times, where there was a polytheistic society and there was Greek gods, and she was the god. I don't believe in Greek gods or goddesses, but she was the goddess of order. The justice system is supposed to bring order to a society. And everything means something on this symbol, right? The blindfold means something. She doesn't look at politics. She doesn't look on whether you're a Hindu or Buddhist or Islamic or atheist or agnostic or that I'm a Christian. She doesn't look at any of that stuff. What she does is she tries to get the facts and the law and merge them together to reach this elusive concept called justice. The sword. The sword represents strength. The justice system has to be strong. There's something called the death penalty and life imprisonment. That's in the justice system. So the justice system should have a sword aspect to it. And then her foot's on a book, because you have to have a command of the law, right? You have to know the law and have a commandment to dispense it properly. And her foot is on the book as she controls the law. And regardless of your religion or your worldview, the universal symbol of a serpent is evil. And the justice system should smash out evil in a society, true evil in a society. But yet she has those scales. And these scales are important. These scales say, I don't care about those cameras. These scales say, I don't care about the false narrative that's been out there. These scales say, I don't care about all the resources of the government. The scales even say, it doesn't even matter what the judge thinks. The scales says is we have to balance all that out, look at everything, and come find this concept called justice. And I love it. I love her. I loved her when I was a DA myself in Bexar County, as we talked about, when I made death penalty decisions. When Jason and I were prosecuting murders, I loved it. I love it as a defense attorney, sitting at that table, either defending people innocent like Adrian of an allegation by the government with all the resources. I love it. And in a world that has this dichotomy and this battle, the justice system brings us all together with a blindfold, not made of mesh, and not lifted up when it's convenient. Stays on the whole time. And so this is the point, though. This is the point in a trial, in a jury trial. This is the point in our justice system where Lady Justice takes the scales and she hands them to you. And now you have it. And that's what we're arguing to you. And that's what we've presented to you. And so all of this gets me to a point of where I'm in a dilemma. Let me tell you what my dilemma is. My dilemma is that I'm a passionate person, if you haven't noticed. And my passion, I think, can be a strength, but can also be a weakness. And so I wonder to myself, if I look like I haven't slept, it's because I haven't. Did I do too much? Was I too passionate? Was I too aggressive? Or did I not do enough? Did I not ask the right questions? Should I have gone even harder? And I struggle with that. But my dilemma is I can't apologize for it. And I won't be fake. And I won't tell you something that I don't believe. I haven't done that since jury selection. I won't start now. And so I can't apologize for it. And because I can't apologize for it, all I can do is ask you for grace. Just extend some grace to me. So if I've done anything, if Jason's done anything, if Gary's done anything to offend you, please, you don't have to nod, but please hold it against me or Jason or Gary, not against Adrian, okay? So that's what I'm asking you to do for us. And so we have to look at things, because what came up during the trial, and at the beginning when I told you, is there was a concept called totality of the circumstances, right? This case, ultimately, we're going to consider everything, allegedly. We want you to consider everything. But this case boils down, truly, to 1 minute and 48 seconds. Not 3.5 minutes, not 77 minutes, to 1 minute and 48 seconds. And it came up during the trial. And so Jason talked to, how do we know that? I'm not making that up. I'm going to their charging document. I'm going to their instrument that they charged Adrian. It goes up until after the shooter entered the room, 111 and 112. Until after the active shooter shot at one or more.
I
one
thought it
child or
was up
children in
until
room
he
111. So it's
entered,
until, it's from.
I thought it was up until he entered the school building. But
Yeah,
it is
that's what-
actually after he entered room 111 and 112. That's insane. He got through 2 unlocked doors, which the school itself left open that should have been locked.
Yeah. And yes, Callie, we are on defense closing. Suspenders was on for the first 45 minutes, and I believe Nico is going to be going over the timeline, or at least that's how it was split in the opening. And then we've got 45 minutes that will play at double speed for the state's rebuttal. I mean, allegedly, we'll probably listen.
When Adrian showed up at the scene, as the shooter is there, and until that shooter goes into those rooms and does what he did to those children. So we have times on that. That's what I'm saying. We have times. We know. Remember this? It's over here, but we took a picture of it. So Adrian parks. It's not contested. Adrian parks at 11:31:55. He parks. We'll talk about what he was responding to and how other people responded and how Adrian responded as he's going to what he thought was the danger. And we'll talk about shots fired. That's true. He calls shots fired because he hears them himself. But he parks at 11:31:55. He's not at 11:31:55 knows what's going on. At 11:31:55, he doesn't have a full concept of what's happening. He just parks at 11:31:55. And the shooter enters the building at 11:32:58. That's a minute and 3 seconds. And then some time goes by, 22 seconds later, he's shooting at those doors, and then 20 seconds later, he's in. If you add it all up, it's a minute and 48 seconds. That's what their indictment says. It's not 3.5 minutes. It's a minute and 48 seconds. Parked, enter the building. That's it. And then there's 22 seconds later, and then he enters again. 11:33:43. This is when he enters room 111. This is where we get the extra 45 seconds, and that's why I say a minute and 48 seconds. I'm going by facts that you've heard. They're charging in that no one's making things up on our side, okay?
Hidden shade. Nobody's making shit up on our side.
It held down on purpose. I'm trying. Give me 1 second, guys. Okay. Okay, so here's what the government wants you to compare Adrian's actions to others. So let's do that. And that's all we were doing during the trial. We were asking questions. We got permission. I mean, Mr. Espinosa sat to your right, and then Mr. Starbeck over your right shoulder, sir. And we asked everybody permission. For where you were sitting, Mr. Peña was between you two. And we remember in jury selection, we talked about that. And we got permission from you to be able to ask tough questions. Even about sensitive matters. We did. And everyone said yes. So let's compare some actions. We're going to compare the actions of Mendoza, Saucedo, Coronado, and eventually Hill. And yes, they could figure that out during trial, so of course we're going to talk about it. So just to lay that down, you guys know this already. So here's an aerial view. We can't even see Adrian's car. It's so much to the southeast side. But Coronado, Mendoza, Saucedo are on this side, a little bit outside of it. You've seen this picture multiple times. This is the scene. Here's a better view. We can see Adrian's car way over here. He's driving into the eye of the storm. Many witnesses said that. He drives all the way to the back. And then we had those 3 officers still at the corner. Here's the west door, and here's where the shooter was shooting. We have evidence of that, and then he enters this door at 11:32:48. So let's compare. Adrian and Officer Mendoza. Adrian drove into danger. Officer Mendoza stayed away at the perimeter. Adrian had no line of sight, not contested. Christina's not going to come up here and tell you that he had line of sight. Mendoza was the same side. He was on the same side as the shooter. Adrian was alone. Mendoza had backup. Adrian was one of the first 5 in the building. Remember, we're going to talk about that first 5. Because Joe, remember Joe Vasquez and others talked about that first 5 and what they did and what they potentially prevented. Mendoza enters the east door at 11. The east door, even though he's on the west side, the east door at 11:42:48. But before that, he drives away, not towards the gunfire. When he's facing the door, when he's looking, when he has backup, and someone has an AR-15, we're going to talk about Saucedo next. He drives away, not towards the gunfire. Remember that pretzel that Jason's talking about? There's one of them. Let's do some more comparisons, because they're going to compare Adrian to everybody else. Adrian and Officer Saucedo. Adrian drove into danger. Officer Saucedo stayed away at the perimeter. Adrian, no line of sight. Saucedo saw the shooter, and we're going to look at the video in a second, and asked to shoot. Adrian, alone. Saucedo, God bless you, has backup. Adrian has a handgun only. Saucedo has an AR-15 rifle. Adrian, one of the first 5 in the building. Saucedo never goes in the building. After having line of sight, opportunity and ability to do something, and he doesn't. He never goes in the building. And he also drives away, not towards the gunfire. But let's look at this. This is the dashboard of Coronado. Here's the sergeant. Mendoza's here. They set up perimeter. They're acting as if they're being shot at, but there's no evidence. There's no defects. There's no objective evidence they got shot at. Here's Saucedo. There's a long rifle. Watch his behavior. Watch him aim. And watch him do this point. He's there. He's there. There he is. He had aimed him. He saw him. He's pointing at him. He's there. And then they saw him walk into the building, so they leave. We're coming back to this video.
There's no evidence that's a misstatement of the facts, Your Honor.
No, it's not,
And I'm
Judge.
going to object, so I want it on the record that he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what they say in argument's not evidence. If it differs from your own recollection or rely on your own, you may proceed.
It's in evidence, guys. I asked questions. I was very specific about questions. I gave people opportunities to talk. I wasn't trying to be a bulldog on anybody. Maybe you can think I was on Ranger Hill. We'll talk about that in a second. But we're just asking. We were just asking questions, specific questions, not general ones. Okay. So let's talk about Officer Coronado, Sergeant Coronado. Adrian drove into danger. Sarge stayed away at the perimeter. Adrian, no line of sight. Sarge, same side as the shooter. Adrian, alone. Coronado has backup. Adrian, frantic witness he was dealing with. Coronado, frantic witness he was dealing with Claudia. Remember that? We're gonna look at the video again, and you'll see it. Adrian, unfortunately, and again, we're not ragging on her, okay? You saw me cross her. But she was wrong, and we'll talk about so many things that she was inaccurate about. A frantic witness that was wrong and inaccurate because she was on the wrong side of this issue. But the frantic witness, Claudia, the sergeant, on the same side, was accurate. Because you know why? Because she said, he went in the building. He went in the building. And you see the video yourself that they're acting like they knew he went in the building. Because you don't go from this, thinking you're being shot at, to this unless you know that the danger's gone and they're in the building. You saw the video yourself, and we're going to watch it again. Sergeant Coronado unfortunately drives away, not towards the gunfire. So now we're going to watch it again, but now we're going to focus on Sergeant Coronado, okay? This is him again. We already looked at Saucedo's behavior. Look who he's talking to. He's yelling at somebody. That's Claudia. You go inside. Okay. What? They're talking. She testified. I told them he went in the building. And guess what? He acts like he knew he went in the building. Because you don't go from ducking like that to watch his car drive off. Watch all of them. They all know he went in the building. They don't believe what they're trying to prosecute. There's no way. Our defense is not, well, if you're going to prosecute Adrian and prosecute other people, they don't believe it themselves. You can't. I'm going to go through a list in a little while of all the things that they're going to have to, Christina, with all due respect, is going to have to come up here and tell you to ignore to get to the man at the bottom of the totem.
oh, they are hammering on Christina, and she deserves it and more.
Yes, and thank you for becoming a member of the Church of Mo. Welcome. We have dark chocolate, sarcasm, and emotional support snacks. I do like this, and I like the way they're responding to the objection because it totally fits in with their narrative. Look, I know the state needs to lie about this. The state needs you to believe this, but you know what your eyes saw.
Yeah.
I love he's like, look, I wouldn't want to be to Christina. See you next.
Court reporter
I'm gonna show you
mostly
that
has
list,
the
and I'll be
same
right.
resting bitch face, but once in a while she looks up. What?
She's had the resting confused face. Now, sometimes it turns into, did I take Quaaludes? Like, that's the level of confused she is. She's
And once in a while she looks at the prosecutor asking question and goes, "What? Did you
Yeah.
really say that?"
Humbly, but I'll be right. Where's Randy Hill? I know it bothers them because he's the one dispatched. Why didn't they call him? Why didn't they call Saucedo? So we can ask them questions and bring you answers. The government has all the resources, all the rangers, this whole road. They have the whole government of Texas and all the resources to bring you evidence. And we expect that of them. Where's Randy Hill? Where's Mendoza? Where's Saucedo? None of them. The only reason why they brought Coronado is because they wanted that video in.
Yeah.
He's dispatched at 11:29:36, 3 minutes before the shooter enters into the building. What was 911 told? That is another aspect of the bill, and Bill's right. I mean, he could hear. He's an intelligent man, and tremendous respect for him. But he heard our questions.
Nico, you don't have to lie, sweetheart. No one believes you.
Yeah, not a single person believes that Gilbert, Texas Rangers. No.
Look, y'all, I would have sold my soul for $1 if someone had said, facts not in evidence, objection. This man has shown no
defense
signs of
objects to their own.
And the reason I can't be a lawyer is because I'd be that person objecting.
I mean, that's a factor. If we're looking at the totality, what were they told? What information did they all have? Someone shooting a gun. This is what Mr. Limon is told, dispatch. They just shot at us. He's shooting at the school. That wasn't relayed to anybody. He's jumping into the schoolyard. Wasn't relayed to anybody. He's just jumped over the fence. Still wasn't relayed to anybody. He's running towards the school. Nobody knew that, but that nobody knew that includes Adrian. That includes Adrian. He's wearing black. No one knew that. That would have been helpful to know. But we know for sure, and I know Ranger Hill's here. He can come sit right here if he wants to. I asked him, you don't know, I know when he showed up on the scene. You do? It wasn't in your critical timeline. Well, it's in a different timeline that he gave to them, didn't give to us. Interesting. But so in his critical timeline that he didn't review for 3 years before he sat in front of you and testified to this, he said that that's all that's in his critical timeline, not when Randy Hill supposedly showed up, because Randy Hill didn't check in at location. Let me know what's going on. Nothing. No communication. So all we have in the first critical timeline is this. Randy Hill at 11:33:32. Just standing there. Setting up. Did you hear how difficult it was for him to try to make up an excuse for what Randy Hill's behavior was? Did you hear how difficult it was? Because you couldn't objectively do it. Not based off Nico's standards or Jason's standards, just training standards, tactics. I asked them tactical questions. How does this make sense? Well, he was just there momentarily. Where's that? I don't understand where you're getting this from. What we know for sure is that Sergeant Coronado is driving around the school, and there's Randy Hill. He's already out of his car. He's been there for a little while. I don't know how much it is. The ranger thought he knew. I don't know how. But there he is, setting up perimeter. When nobody's asked him to set up perimeter. Oh, they said there's a dispatch, again, that we didn't get from an unknown person. Remember that exchange?
Your Honor,
figure it out.
again, I'm gonna object. This is misleading the jury, and he's having them believe that we did not turn over everything to him.
Ma'am.
No. Asshat. You didn't show it in the trial.
Also, lady lawyer, because I now know that she's going to be doing the rebuttal. I'm going to go full no tie Bronca. Lady lawyers, if you're wearing your hair down, it's called a brush. It's called get the back of your head. And for the love of God, whoever did your hair hates you, because those highlights, I hope you didn't pay for them. Those are bad.
I mean, it's
Okay, but we'll,
Remember that exchange?
Not even an
I
instruction,
was just asking
just
questions based
overruled.
off the evidence that we were looking at. I let him, what are you looking at, so I can ask you about what you have in front of you. There was no trick question, no gotcha. I told him I'm not gonna question your character, but I will question your opinions. I'm gonna question your investigation. He knew that. He knew that. He's coming before you after 3 years of all of this and the resources, 3 years, and that's what they brought you? That's the mortar to their case, Ranger Hill? Bringing it all together in this critical timeline? Well, where's Randy Hill? We all want to hear from Randy Hill. And then we have a hero, a true hero, Joe Vasquez. You heard about Joe. I mean, he gave me permission to call him Joe. He called me whatever he wants to, but we went through scenarios. We went through breaching. We talked about when you breach an outward swinging door versus inward swinging door. Well, what did Joe tell us? At 11:56:28, he linked up with Lieutenant Canales, who briefed him. Very different when you're being briefed by fellow cops after the situation has already been assessed. Very different, but they want to conflate that to Adrian. Well, they did that. They listened to instructions. They moved in. You have 27 officers around you. Everybody has guns and helmets and vests on and AR-15s and said, here's what's going on. And oh, yeah, of course they're going to listen. That wasn't Adrian. I asked if he wanted me to make entry. He didn't do. He asked. He understands there's an order. He understands the danger of it. We talked about the danger of it and fatal funnels, and there was 2 of them. There was the hallway, and then there was the actual doorway. We talked about that. Response, no, we're trying to negotiate because we've been fired at. That's what he was told. Waited with Canales for negotiating team and the TAC team. So a true hero. I hope you like Joe, because I like Joe. I mean, he waited. There was still sporadic shooting at times. We look at the timelines, the critical timeline that's kind of complete. But he waited with Canales for the negotiation and the TAC team. Should Joe be sitting in that chair? Is Joe a coward? Are board TAC a coward? Are all the other officers cowards? Eventually, board TAC showed up. It was a bit of a blur. He doesn't remember. A lot was going on. Then they had a planning. They planned the entry. How long did you wait there? I asked them that. They entered at 12:50:01, almost an hour after he arrived. So Joe Vasquez is a real hero. He thought his daughter was in there.
Joe Vasquez was the officer who accompanied the border tactical team into the room and dispatched with the shooter. Also, Nico, sweetie, your ADHD is showing just a scotch. Let's stay on focus.
Yeah. Don't go all squirrel here.
Yeah, I'm loving it, but fight against the squirrels.
Could have been in there because she went to school there. But he still waited an hour because he knows there's a pecking order. He knows there's a way. He understands fatal funnels. He said you're going to die at the door. That's what he said. We got that from Joe, not from us. And he waited because they were planning entry. Part of their training too. Waited 15 minutes, over 50 minutes. But board TAC was rehearsing and opening the door. And again, I'm not saying that's good or bad. That's what part of their training, because an open, outward swinging doors is difficult and it's dangerous. But they had the equipment at that time. Adrian didn't. The first 5 didn't. Taking cover is reasonable. Then we asked them about Adrian's behavior, because they didn't bring an expert, so we had to ask somebody, and we're going to ask somebody who's in law enforcement. Well, taking cover is reasonable if you don't know where the shots are coming from. From Joe, their witness. Containment. Remember I asked about containment? We talked about that. And he said, if those first 5 officers, we call them the first 5, if the first 5 hadn't contained the shooter, he could have done the same thing to the whole school. Think about that. When he didn't contain, he didn't do anything to distract or detain or to impede. That first 5 group held them in 111 and 112. And let me submit to you humbly. If it wasn't for that first 5, that person responsible, because I know I've called him an animal, and I know I've called him a monster, because he is. You know, you get the point. But if it wasn't for that first 5, what would have stopped him from finishing off those precious babies in 112? Was it a distraction? He knew there was talking, there's negotiating, he's waiting for them. He wants to be a cop killer too. I mean, he wants to be a cop killer, so he's distracted. He's done he's done what he's done in 111. He did what he did in 112. But what would have stopped him to finish everybody off? The 5 outside, knowing that they could breach at any time. He doesn't know what they're doing. And he was waiting in that closet. He knows that closet, remember? 111 was his home room. He was going to 111. He went to school there. 111 was his home room. He knew that room. But even Joe Vasquez said, if those first 5 hadn't contained the shooter, and by the way, and I know it bothers them, Adrian's part of that first 5. And not that 3.5 minutes that Christina's going to come up and argue, that minute and 48 seconds with no line of sight. Talking to the guy on the stick. He was talking to the guy on the stick. Remember that stick is the stack when they're breaching behind the shield? He said he couldn't hear me because I realized I was wearing a gas mask. He himself was experiencing perception distortion. He didn't even realize he had a gas mask on. There was no gas, but he put it on, and he couldn't hear, and he's talking like, oh, what am I doing with this gas mask on? And so he took it off to talk, but he didn't realize it at the time. But everybody, it's okay for everybody else except for Adrian, because he's the man on the bottom on the totem pole. He's easy pickings. Except for you guys, to settle that. Now let's talk about Mel Flores. Look, I mean, if you couldn't tell that I had an affinity for her because she's a special ed teacher, then you weren't paying attention. I have a special needs son, and I told her that, and I appreciate that. And it takes a special person to spend 25 years teaching and taking care of and nurturing and stewarding special needs children. No one is attacking her character. But she came in almost 7 days after the event. She admitted she's watching these cameras and reading the stories and listening to talk, and that's huge, that's normal. She wasn't given an order by the judge or anybody else not to talk to anybody, but that was influencing her talk. And so, but she's witness 1. She's in their indictment. The training and then witness 1, based off what she said. She thought the shooter had a handgun. She was sure of it, but he didn't have a handgun. Did not see the windows break on the east side of the building. I could not see from where I was, but Bill, in opening statements, expected you to say that she did. Why? Because that puts Adrian in a disadvantaged position. But then the truth came out during cross-examination, right? Remember we talked about that in jury selection? The greatest vehicle ever invented to find the truth, I was taught, is cross-examination. It's in Proverbs as well. Because we had to, and we asked you, and you know, I told you that direct examination for the government was going to be like a waltz, and then cross-examination was going to be like a dental visit, pulling teeth, and I think you saw that. It wasn't our intent. We can't control the way the witnesses respond, but some of them were very honest. State Exhibit 921 identifies the wrong PD. She identified the wrong PD vehicle. She identified Sergeant Page's vehicle. She ID'd Donald Page. Khaki pants, Adrian didn't have khaki pants on. Full beard, Adrian didn't have a full beard. You saw the interview. Short sleeves, white short sleeve shirt. Adrian wasn't wearing white short sleeve shirt. We believe she saw Sergeant Page, but she also testified that she was frantic. Yes, I was. Let me submit to you respectfully. Again, this is nothing against Ms. Flores. God bless her. Let me submit to you that you heard the 911 call from Mr. Limones. You heard Amy Marin's 911 call. Understandably, it's frantic in the background. You heard Claudia in the background of Mr. Limones' 911 call. Ms. Flores was more like that. Adrian's dealing with that type of franticness. Understandably, again, it's not a criticism, it's just an observation. He was pacing. Remember we talked about that? Assessing because you're shouting, yes, there's shouting, south entrance, west entrance, shots fired, and we'll talk about when he transmits something in a second at 11:32:59. She was with Adrian from 2 to 7 minutes. You can't cherry pick what you want to believe from her, Christina. You just can't do that. And you shouldn't do that. It's not right. It's not fair. I mean, so we know it couldn't have been 7 minutes because the timelines don't work out.
Okay, I don't know that I've ever seen a defense attorney kind of address the state attorney that is going to be coming up after them. Like, okay, Christina, you really can't do this.
Yeah,
It's
and it's not like that is stated. We think the defense is going to ask this and then do this straw man argument. They are actually saying this is what you have to prove with beyond a reasonable doubt.
and it is pissing her off, and she is going to come up there unglued
Yeah, and
and
we
shrieking.
already seen how easy she is to be riled up.
Oh, he is baiting the shit out of her.
He's baiting her.
Which means that he's baiting me to go full no tie Bronca and take the right to vote away from all of us.
Yeah, yeah. But I'm very, very confident in that they have listened to us too throughout this trial to get pointers and tips and everything. Yeah.
I'm glad there's no testimony. JKD made me laugh, and I muted it before, and I was like, daggone it. It's going to look like I'm a total a-hole.
The stuff that we do know, it couldn't have been 7 minutes. But even if it's 2 minutes, it covers the 1 minute 48 seconds that Adrian had no eyesight on the shooter. He had no opportunity. He didn't have the ability. He's with her. She's a victim / witness at the time, yelling, frantic, giving instructions. He's taking shots. He's looking around. He's taking cover. See, it's okay for everyone else to take cover but Adrian. For a minute, he can't take cover for a minute to observe, orient, decide, and then act. Remember their training? But she's going to have to come up here and tell you it's okay for Coronado, for Saucedo, and for Mendoza to take cover, and then run from the shooting, run from the gunfire. Make a note, run from the gunfire, not run to the gunfire.
I'm going to object to the sidebar comment.
Sustained.
So she's going to have to argue that to you. And I don't know how you do it in good conscience. I just don't know how you do that. But 2 to 7 minutes, it's a big deal. That's a big deal because it came out in evidence, and you should consider that. And the reason why it's in the big deal, I want to say this because I asked Ranger Hill. I said, well, why isn't that in your timeline? Why didn't you know that information? I go, would that have been important? And he said, yes, it would have been important. So good for you for answering that way because it's true. It would have been important for him to assess critical, important, his definition, important timeline, 2 to 7 minutes with a witness / potential victim. It matters in your assessment of someone's behavior and what they didn't do and what they were actually doing. Excuse me. Shots being fired while with Adrian Gonzalez. Yes, while they're together. So now he has somebody he has to protect as well. And himself and her, and think about it. He has no idea that this person's going, he doesn't know that. There's no evidence that he knew he was going in the building. He's going in the building, Adrian. There's no evidence of that. He couldn't even see this guy. And we said pacing could be taking cover. She says, I'm sure. Said the shooter went in the south door but pointed to the west side. Yes, I did. And then in her interview, the investigator, the ranger, had to say he did not go in the south side. Oh, I really thought he did. And she was honest about it. I really thought she was mistaken. She just was inaccurate. At the time, he thought the shooter went in the south door, yes. Told him the 4th grade building. He said, what building? He doesn't even know that. He's not part of that. He's assigned to the high school. He didn't even know which building you're talking about. Yes, I just wasn't listening, she said, because there was a lot going on for her. That's understandable. Then said he's on the west side of the building. Yes. So south side entrance, west side building. Yes. Dialogue between you two was 2 to 7 minutes. Yes. So here we go. Adrian with her 2 to 7 minutes. Shots being fired while with Adrian. Yes. You say pacing could have been taking cover. Yes. Said shooter went in the south. Yes. At the time you thought the shooter went in the south door. I did. Yes. Told him 4th grade building. He said what building? Yes. So there's confusion there. Not knowing, not confusion like he's confused. He's trying to figure things out. He doesn't even know where she doesn't even know where she's directing him to. And again, there's a lot going on for her. Dialogue, yes. I just wasn't listening. Now we have Ranger Nick Hill. And I'm sorry, Christine, I didn't mean to be disrespectful to you. I apologize. I'm going to temper myself. I really believe, with all due respect, Ranger, I really do believe that Thomas Jefferson was talking about someone like Ranger Hill. And I'm saying that with him in the room. I consider trial by jury, you, as the only anchor ever yet imagined by man, by which the government, including him, the government, can be held to the principles of its constitution, and one of those principles is due process. You know what due process means? It means fundamental fair play. fundamental fair play. Everybody gets it. Remember that blindfold? We don't do this. Doesn't apply to you, can apply to you, doesn't apply to you, sir, applies to you, ma'am. It doesn't work that way. That's not how Lady Justice operates. That's why she's so beautiful. She wears that blindfold at all time. I'm not gonna go over all of Ranger Hill's testimony and our back and forth, and again, if I offended you by my question of him, please hold it against me. I can only ask you to do that and extend some grace to me. But like Jason said, this was his presentation to you, in good conscience. This was, and if you had not known any better, if we didn't ask questions, if we didn't push back, you would think that the shooter was right there and the angels just drove right by him. That's it. And then he placed the shooter where the shells were, and then we went through the whole ejection thing, remember that? And it was at versus towards, and can you look at two people, and how many fingers am I holding up? We went through a whole bunch of stuff, and I just asking pretty simple questions. But that's how you presented it to you, and that's not the facts. Jason told you. We know that because we have some video, grainy, yes, but we have video. But more importantly, we have Claudia, who he interviewed. He didn't review someone else's interview, he interviewed her. And not only does she, but also Mr. Limones and even Amy Marin loses the shooter in between cars. He's in between cars. That's where he should have been if he was going to present that to you, this animation. But the government sponsored him anyway. Now, whether they knew or didn't realize it, I don't know. I'm not inside their minds, and that's between them. But they sponsored him anyway. So what is Christina going to come here and say to you? 3 minutes. She'll say 3.5 maybe. Okay, because Bill kind of gave you the heads up on that. Didn't follow training. Well, Jason went over the training, so I asked him a lot of questions. I talked about tactics with him. He was a very, very nice man. He agreed. Just my opinion. I'm one opinion of many. There's different. These are suggestions. And I said, I understand. Thank you, sir. Very respectful. Didn't follow training. Then we showed you the training. We don't recommend going in alone. But we're not even saying Adrian made that conscious decision, by the way. We're talking about 1 minute 48 seconds. Had an opportunity, best opportunity. I mean, Ranger Hill, over the 3 in the corner, said that Adrian had a better opportunity to stop that shooter than Coronado, Saucedo, and Mendoza. You're the judge of the credibility. That's why you're here. That's why I love the jury section, the jury trial. And here's what they're going to do. They didn't say it, but they're saying it. They're trying to feed you a coward sandwich. They want you to eat a big coward sandwich and say that Adrian's the one that gave it to you. The problem is...
Did anyone have coward sandwich on their bingo card?
It is wrapped around 2 slices of bread of bravery.
They should have had a
this
picture
coward
of
sandwich.
Gordon Ramsay. What is this? And then the face of one of the other cops. What is this? A coward sandwich. Folks, you have folks who have ability to do memes. You know what to do.
I just feel like the court reporter is like, just a normal day. It's all normal.
I'm looking at you, JK Buck.
But you have bravery and bravery around it. The bravery of driving into trouble, thinking there was a shooter. Only one, didn't set up perimeter, goes into the trouble, into the eye of the storm. And then he's one of the first 5 that goes in the building. Takes rounds, well, Martinez does, takes rounds, and you saw the video. Adrian has his weapon out, he doesn't move. Page is there, he's in the fatal funnel. All that shooter needed to do was turn this way and start shooting at them. He didn't run away. He only went outside when his radio didn't break. Because the radios don't work inside of schools, which is interesting. And so then he had to go outside to call for SWAT. Call for cover. Everybody's doing that. It's for the cover for the situation, not for him. That wasn't accurate. And then what Bill told you in opening is that Adrian, if you listen to Bill's opening, and again, this is respectfully, you would think that Adrian showed up and just stayed there and stood there. If you remember opening, I don't know if you do or don't, but that he just stood there and didn't do anything. And the evidence didn't play that out. The only thing Adrian remained in, he remained in danger. He went into the danger and remained. And once he figured things out, he went further into danger and remained. That's the only thing he remained in. And they're going to ask you to send the message. Jason couldn't help himself. He had to talk about it, and I understand. The problem is the message that will be sent is be Officer Hill. Set up perimeter even though you're not asked to set up perimeter. Don't go in. Don't go into the eye of the storm. Don't even, wait 30 minutes. Stand back. Don't do anything because I don't want to be sitting in that chair. That's the message that will be sent. Not just to Uvalde County, but also to Nueces County, Bexar County, because people are watching. And that's the message that would be sent. That's not the message that needs to be sent. They need training. They need good training. They need proper training. They need resources. They need help from those schools to work with them in conjunction. And we'll talk about doors being locked here in a second. And they're all working synergistically together to protect the most precious thing we have in our community, and that's our children. No doubt about that. But to pick the man lowest on the totem pole and drag him into court and to come before you, there's a lot of things they're going to have to ask you to ignore. They're going to have to ask you to ignore inaccurate dispatch. They have to. I'm not saying it's their fault, but they're going to have to ask you to ignore it. They're going to have to ask you to ignore that Andrea drove into danger. Remember that sandwich? They're going to say, yeah, okay, the bread is fine, but the coward sandwich is full in the middle. And then, yeah, I understand the bread at the end is bravery, but we just want you to focus on what's in the middle. It's like an Oreo where you take off the up top. They want you to have the coward cream in the middle. Remained in...
Phrasing, Nick. Come on, coward cream. Also, I really want an Oreo now. But I'm also horrified I want an Oreo now, so I don't know what to do with this fact. Make sure your coward cream is not double stuffed. Good God. Look, he's throwing out soft pitches, and I have the humor of a 12-year-old. It's entrapment.
Danger. They're going to have to ask you to ignore that he remained in danger, that he had no line of sight. They're going to have to ask you to ignore that. He never had a line of sight, but other officers did, not him. They're going to have to ask you to ignore that it was truly, because I looked at the indictment and we're looking at the facts, it's truly 1 minute and 48 seconds. They're going to have to ask you to ignore that. She's going to argue something different, and give her your attention, please. They're going to have to ask you to ignore that. They're going to have to ask you to ignore Mendoza, who showed up 27, 28 seconds after Adrian. That's it. That's the difference. He was there too, before the shooter made it in, with line of sight, with backup, with guns, with superior weapons. They're going to have to ask you to ignore Salcedo. Line of sight, never goes in, drives away. You saw the video yourself on the dash cam. They're going to have to ask you to ignore Sergeant Coronado. They're going to have to ask you to ignore Randy Hill. They're going to have to ask you to ignore building doors being unlocked. Everybody, Wixel, all of them, all the Rangers said if those doors were locked, it would have made a difference. Since time is of the essence, those doors being locked would have made a difference because you had 3 officers on that side. You had 3 officers on...
Wait a minute. E.W.K. Ickerman? Tell me if I'm not pronouncing that correct, but they have a body cam on Randy Hill?
And didn't show it? Yeah, that is extremely telling that the state never showed Randy Hill body cam. Now, why didn't the defense do it? They don't need it. They have to... He's doing fuck all over there. And then have the jury make the assumption themselves.
Yeah.
It's like when the defense never called Trooper Proctor to read from the texts in the second trial. They didn't have to, because the inference of the big bad bully was worse than having him on the stand.
Yeah.
On the side, on the west side, one with an AR-15, getting instruction from Claudia. He's going in the building. They're right there. And if you would have been locked out, you don't think that would have made a difference? But they have to ask you to ignore that. I don't know what you do with the school board on that. That's not what this trial's about. But you have to ignore that. They're going to have to ask you to ignore that. But it's not that important. It's more about Adrian. The classroom door is being unlocked. I'm sorry for what Mr. Reyes went through, but that door was unlocked, and it should have been locked. That would have made a difference, a key difference. You know what really made a difference? If that door was unlocked and those 3 officers in the corner followed the gunfire and made it in the west door, not drive around for whatever reason. You can talk about I want to hear the excuse. Made it, and then the shooter's in the fatal funnel. This door's locked, even if he got into the school. The classroom door's locked. And he starts shooting at the door, but then here's these 3 officers following their training, cutting the pie, getting with him, and then he's in the fatal funnel. That would have changed things. We can what if it all day long, but they're what ifing it, and they're asking you to make presumptions and speculate with Adrian. But they don't want to do it with anybody else. This is the hardest part of my job. Because I have to sit down and I can't talk anymore. It's not that I like talking, I just have a lot to say. I get it. You can ignore me, you can say I'm full of it, it's fine. You can tell me after. But because the state has, the government has this burden that Jason went over, the highest burden in our justice system, the burden that the government has to prove to take away someone's liberty and change the course of their family's lives and that person's lives. And it's a burden that we all agreed was appropriate for the government with all their resources to have. They get to go first, and they get to go last. They gave us that sandwich. They gave us the burden of proof sandwich, okay? It's the other way around. And so I have to sit down and I can't talk. And please give Christina your attention. And she's gonna make arguments to you. And you're gonna see me in the corner, and I'm not gonna be looking at her, but it's not to be disrespectful. I wanna give her a heads up. It's because I get frustrated because I wanna talk, and I got an answer, and I got a question, and I have an argument. That's just my personality, for good or bad. That's just the way God wired me, okay? But I'm gonna be looking down and be writing notes, and my legs are gonna be going 100 miles an hour. I already know. But you can ask yourself, not just what would Nico, Jason, or Gary say, but what did the evidence show, right? And I promise you, I'm gonna do my best not to object during her closing. I will, I'll try. She can do it, I'm not offended by it. I'll do my best not to object, but listen to her, okay? And we're gonna ask you now, I'm asking you to apply this burden. The burden that's the highest in our justice system. The burden that says not sure is not guilty. The burden that says, no, you can't take the person from the bottom of the totem pole and move them up and ignore all these things. You can't ask me to ignore all those things. Government, you can't. You can't ask me to ignore all those things and apply this high burden. The judge told you in the charge that if you have a doubt and it's reasonable, a doubt, one doubt, and it's reasonable, it's a not guilty. Just one doubt. Did they eliminate every doubt from your mind? I hope that's not the standard. If it did, then I'll deal with it. It'll be horrible, but I'll deal with it. But that would shock me. Because that can't be the standard. That can't be the standard. That can't be the message. Because she's going to come up and say, send a message. Well, but send a message also to the government. Send a message that, like Bill said in his closing, so we concentrated our case on the facts around Adrian Gonzalez. Send a message you can't do that. You can't pick and choose. You've been given authority to steward well. People in our community say, steward this well, government. The huge responsibility. This is not how you steward it well. And if you apply the burden by law, if you buy the facts objectively, if you can acknowledge two things at one time, if you can acknowledge that families have been destroyed, because she's going to make an emotional plea to you. Everyone's cried, and you'll probably cry again. It doesn't take away something that my family's gone through or what they've gone through. If you apply them objectively and do what our founding fathers expected juries to do, we're asking you now, and we're hoping that you'll pick a foreman or foreperson, forewoman, and do a quick verdict, and a quick verdict of not guilty. Because the evidence has shown he's not guilty, folks. Thank you, and God bless you.
State.
Thank you, Judge.
Brace yourselves. I'm going up to 1.25.
I just wanted to, just a quick note that the judge is going to decide the punishment. I think that was made clear to y'all, but I don't know if it was confusing here with the closing statement. So I guess I'll kind of address quickly the idea that I bowed to political pressure. There's no evidence in this case that I bowed to political pressure.
Oh, you ass chick. No! Holy fucktard. That's... Oh, for fuck's sake.
Do we have to listen to her? Holy crap. I can't. This has only been about politics.
Yeah. We were talking about an idiot sandwich. I found the white Oreo. She's
Good.
wearing it,
Oh,
and it's
jeez.
getting moldy.
Yes, you were aware this is a visual medium, that you were going to be on television, and you couldn't have thought, brush my hair? Oh my God. Okay.
And I think if you remember in the opening statements, the defense talked about all these third-party investigations that went on in the opening. And the easiest thing would have been me to do what all those did, which is say, don't blame us, blame somebody else, or everybody's to blame, therefore you can't hold anybody responsible. That would have been the easiest thing. So, you know, I've never bowed to political pressure. And that's not what this case is about. The defendant, in their opening statement, they talked to you about, and they did here in the closing, that he was not assigned to the school. He relayed information. He drove to the school. He went into the building. He called for SWAT. He stood perimeter. He evacuated students. He had no shields. He checked on another officer. He got the building plans. He secured a master key.
And which one of those are factually incorrect, ma'am?
Yeah. Yeah, exactly. Which one of those are factually incorrect?
There was even testimony during the trial that he evacuated students, and wasn't that a good thing? A good thing. And he relayed information over the radio, and wasn't that a good thing? Ladies and gentlemen, this is not about doing a good thing. I am not standing in front of you. In this case, it's not been about handing out participation trophies.
Jesus Christ. Randy Hill is the definition of a mother effing participation goddamn award, and he's not on trial.
So saving kids, running and getting shot, running into the hallway and getting shot at, or participation. Mrs. Oh God, I hope it's a miss. How about you tell that to the two officers who were shot through the wall, that all they did was participation trophy worthy?
Yeah.
You,
How about
you can't.
Well, the state is doubling down on tyranny and cuntiness. Let's see. It's a bold strategy, Cotton. Let's see how it plays out for them.
That's not what this case is about. This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. Mr. Turner and I, as prosecutors, we have these big books that we're supposed to follow, and the laws and all that, and he described to you that there's a special law in these books. One special law would...
Supposed to? No, you're obligated to. Jesus.
Yeah, that's kind of your fucking... Did anyone in Uvalde know how to do their damn job? Because this is the prosecutor for Uvalde, and it explains a shit ton. How much fluoride is in the water?
Actual fuck?
With regard to children. And that's what this case is about. All of this, the personal attacks, all of that was an attempt to justify the unjustified.
Personal attacks? No, he said that your case sucks balls, not that you suck balls, because you don't, because no one would date you.
No, I would assume it would be somebody sucking her balls.
Yeah, so it's not like we've been making those attacks. Nico didn't say that. He just said your case sucked. Not that you as a person suck. I think you as a person suck. Allegedly in Minecraft.
Viable, in my mind. We're not talking about people being perfect. We're not talking about pretzels. And I'm not here to send mixed messages. I'm here to say that when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty. You know, when we had the active shooter training that was brought in, that active shooter training goes through all the mass shootings of schools back to Columbine. At the time that the Robb shooting happened, we've had, 23 years of mass shootings. And school districts have begun their own law enforcement police force. That's saying, we're not just going to depend on the local police department, we're not going to depend on the sheriff's office. We, this school district, the Uvalde Independent School District, we are going to have our own police force. So what does that mean? That means these buildings.
Dear God, did you not practice this? First of all, they can't see because it's covered by your body. There is a tripod. Dear Jesus.
Oh, gee, I just realized she's wearing white as symbolism for being good.
Nick, that would require her to have a functional and logical mind and understand symbolism. And I don't think we've proven that she has a functional brain.
Look at the watch. You don't match it that way unless it's an active decision. It's
Okay,
a white
I'll give her
watch.
cunning.
Yeah. She is trying to symbolize I'm the good guy. And it's
she
failing in the in the YSL trial when the entire prosecution team for closing arguments shows up in red. The very color they claim is gang color.
Also, I wore white to my weddings, both of them, and we got them, legitimate before we crowned, but wearing white doesn't mean a whole damn lot, okay?
Jeez.
Buildings, there are their homes.
I hope she
Those
falls
hallways,
over.
there are their roads. Those students in those classrooms, those are their people to protect. Even Mr. Gonzalez, the defendant, says that in his video recorded statement to the Rangers. He says, it was a car wreck, but that's not my responsibility, that's the local PD's responsibility. But when I heard that there was a gunman and he was near the school and entering the school, that's when I got in and went. Because that's his jurisdiction, that school district. That's his jurisdiction. Those students are his people. The charge that you have talks about the legal duty that the law enforcement is supposed to be responsible for. And then it talks about the Texas Education Code. And that's because our legislature had mandated that. And we cannot turn a blind eye to that. Their own expert witness talked about being in San Antonio and how he went into hot situations. Ladies and gentlemen, I would argue to you there's nothing hotter than a gunman in a school. That's pretty hot in my.
What the hell am I watching?
She actually thinks this. I mean, this is rebuttal. This is their final moment to say something to this jury. I was expecting dead children on placards. Think of the children. And that would have been better than this pile of shit. That would have at least had a purpose. What the fuck is going on here?
This is a political speech. She started off with the thesis idea that she cannot be, politically motivated. This is a goddamn political stump speech. I hold people accountable. I'm doing this. The officers that did. This is a political speech. This is ridiculous.
This is Mean Girls Part 2. Let's try to make a trial.
And we have training, and he said, if you have training or you don't, you figure it out. This defendant had training. He even.
No, that's not what he said. Not even close.
Also, if your training doesn't tell you how to get to the place, telling someone to get to the place, Nick, you can tell me how to, upload a stream, but if I don't have a computer, it doesn't help me a whole hell of a lot.
No, and it's like saying, "Oh, she must have some kind of what was the word I saw over there? Does she have early onset dementia?" No, that demands a brain to begin with.
Have we ruled out that cordyceps fungus hasn't actually broken out and we are actually living in The Last of Us, the game?
Ladies and gentlemen, mad cow disease.
Pretty much. This is what happens when you eat cat food with your cats.
Yeah.
Stay away from the fancy feast.
No, she. Here's your filet mignon, dear kittens. I'll just open this. Yeah.
This is so dumb.
I bet
Provided
she
the
wears
training. Who
cat
put on the
ears
training?
when she does it as well.
The defense would have you ignore all of that, all the things that they say that he did and that he's a low man on the totem pole. No, he's not. He's a top man. He was a
Wax on, wax off.
This isn't the case you're looking for. Her midichlorian count is really high, but she's a Sith Lord. That's the problem. Emperor Palpatine, I am the one
I
that's
can't
been...
believe she's not even addressing the facts the defense brought. She's just ignoring them. Oh, look over here, a squirrel.
And Nico knew that he could bait her into doing this. That's why he kept addressing her. You could see her smiling, or you could see him smiling. He knew that she would respond emotionally. I'm going to go a little no tie bronca, but because her hysterical female, emotions took over, this is how she's acting. Now, had she approached this logically like I would, I'd still be pissed off, but I'd wait until Nico wasn't expecting it, allegedly in Minecraft.
police officer for the school district that showed up first. And why do we go back to having school police officers since Columbine? Because on any given day, you can have a monster that makes his way into your school. On any given day. On any given day, they would have you believe that because there was a wreck outside the school, that confused me. Don't hold me responsible because, the wreck's too much, so not my day. They would have you believe that on any given day where we have bailouts in the community, bailouts happen all the time. Even in large urban areas, you have people who outrun the police. But they want you to believe that because there were bailouts on this given day, but don't hold me responsible. Not my day, not my responsibility. They would have you believe that because he wasn't assigned to that particular school on any given day, don't hold me responsible, not my day, not my responsibility. They would have you believe that because the doors weren't locked, it's not my responsibility. On that given day, the doors weren't locked, so not my day, not my responsibility.
What? The doors weren't locked, not my responsibility. No, of course. Of fucking course it's not his responsibility. Not his school. They was supposed to be locked by the school administration who left them fucking unlocked.
Yeah, and what kind of school has a heightened sense of danger because bailouts are ubiquitous and then continues to keep the doors unlocked? I would think that the first bailout, just like the first shot, would be a notice to the school to protect the children. Are we going to, charge the school for not taking that first initial bailout as notice? Because the case could be made. Now, I'm a twice college dropout, so I don't know if it's legal, but I could use the same fact pattern to argue that the school is ultimately responsible.
Yeah. What I'm hesitant to say this, but if they had a collage of the dead children, that would still be better rebuttal closing than what she's doing right now.
I thought that the guy was awful. No, this woman is making me want Bill back, and I never thought I'd say that.
On any given day, I only had a pistol. He had a rifle, so it's not my day, it's not my responsibility. And then they would have us tell, the argument is because you had 3 other officers show up who believed that they were being shot at. Don't hold me responsible, because on any given day, if you've got 3 other people that showed up, it's not my day, it's not my responsibility. And what strikes me so much in this case, and something that we believe the evidence has been brought to you that's going on, is the contrast in the training of the schools. If you think about it, since Columbine, the students have been taught, and you heard that, lock the door, lights out, be quiet.
Did you just hear yourself, lady? Number 1, lock the door.
Well, now,
lady, did you actually read that from that paper? Number 1, lock the door.
Also, maybe don't make a, finger pew
Yeah,
pew
gun
at the
finger
jury.
motion. Yeah.
I mean,
yeah,
I'm
that-
not telling you how to job, ma'am, but seems like a bad
Nobody
idea.
tells her how to job.
Yeah, she's a lady lawyer.
We are basically teaching these kids, and the kids in room
She's
11 and room
actually
12 were
doing it all
taught
the time.
to practice
She's just
I
writing
can't. I can't unsee
impending
it.
death. You don't cry and you don't scream. But we're going to teach you what you do when a monster makes his way into the school. We're going to have you rehearse your own death.
What?
What?
Okay, I can't listen to this woman anymore. I really can't. Rehearse your own death. This is.
Now, luckily, she didn't take 45 minutes. Let's see her.
All right. Okay, we only have a
No,
couple more
I mean,
minutes.
she should be almost done here.
But yet, we have active shooter training that says to go to the fire that the defendant taught. But we're going to ignore that. Because on any given day, if he says, not my day, we're supposed to just look the other way. And I am sending a message. And I'm sorry if I'm repeating myself, because I want officers to know those days are over. We're not going to continue to teach.
So this is a political case, and you are building your political reputation upon it. So when you said that you don't bow to political pressure, you were lying.
Holy shit, monks.
Oh, let's see if Andrea, well, she's doing her own stream, but I'm like,
children
Andrea, get
to
in here.
rehearse
What the
their
hell
own
is
death
this?
And not hold them to the training that's mandated by law. That when you hear the gunfire, you go to it. You go to the shots. You stop the dying, and you hold civilians, children, above yourself. You hold them, they're the highest priority of life. I think it's Sally and Mr. Turner touched this with you about the defendant's statement, and if you're going to get all the evidence to go back in there. He says in that statement, the teacher, she told me, he's over there, she pointed, he's over there, he's wearing all black. I think that statement is very telling, because in that statement,
Who
he
also
said,
said
on 3 different occasions, I
he walked through the south door, meaning, oh, he's already inside. Right? Right, Miss Gun Pointy Finger?
Okay, I
Showing
was,
how you wish your...
I was saying that I was not going to be shocked if the verdict didn't come back today because of the amount of evidence. I think the jury is going to be like, he's not guilty. They're going to want a quick verdict now. If they were even leaning slightly, this woman's incoherent babbling has pissed them off.
She has to have had this rehearsed. Speaking to somebody. And whoever that person was, who didn't tell her this is shit, make something better, is probably the other prosecutor.
It's the same person that tells women that acting bitchy and shrill is the same as assertive and being a leader. No, you don't have to be shrill. You don't have to, she could have argued eloquently and stayed within the statute. She decided to make this a tit for tat. We didn't lie to you. She decided to bring emotion into it and make claims that she can't substantiate. And, point her finger gun at the jury.
there. I walked to the school. I walked. And you contrast that with Miss Flores, and what is she saying? I ran, and I tell him, we need to get in
I
there.
ran so far
We need to get in there.
away.
She's not saying you go. She's saying we.
And
Because in her mind, I believe you can infer that those kids and the protection of those kids are still tantamount to her. And there's
She
no
ran
evidence that she
to
had
the
after she was
other...
training.
She went
Oh,
other directions. Not building 4. Other directions. After she bugged the hell out of Gonzalez for 2 to 7 minutes.
There's
we
no
never
evidence
thought-
that she taught active shooter training. She was just a teacher. So are we going to continue to hold teachers and students to a higher level of responsibility than we?
Tell me it's not political again.
They
'cause
didn't lock the fucking doors.
this is a stump speech. We're not going to hold teachers, responsible for the cop job. The cops are there to serve and protect. Those teachers shouldn't have even had to lock those doors.
We are going to hold police officers for school districts who raise their hand and say, I will be a police officer. Those hallways will be mine. Those children are my people. Those classrooms are my houses. I will protect them. Are we going to continue to do that? No. Because on any given day, you can be like Mr. Salinas and Ms. Torres, who came in and testified to you. They dropped their children off for school that day, and the next time they saw their children, it was at the hospital. Mr. Salinas told you that the child that he dropped off for school that day is not the same child he picked up.
Hey, is it the same child that you misspelled their names on a lot of the charging documents?
Yeah.
Miss, this isn't political.
Because on any given day, a monster can make his way into an elementary school. Ms. Garcia testified that she dropped her child off at school, she went to the award ceremony, and her daughter wanted to come home with her. And she said, no, I paid $2 for that pizza party, you're gonna go and have a good time. And then she never saw her daughter again. Because on any given day, that can happen. We know that, we see it. Nueces County is not any different from Uvalde County. It's just not. What happened to Uvalde on May 24th can happen anywhere at any time. And
Are you accepting that most schools are unlocked now? Or is that, I guess, what are the pertinent facts you're starting with? That every school is unsecure?
if it's going to happen, and if we have laws mandating what the responsibility of a law enforcement peace officer is for a school district, then we better be ready to back it up.
With evidence.
You have the teachers come testify to you about what was going on. And what do we know about what the defendant had versus the children in rooms 111 and 112? The defendant had his car. It was on the corner building. He had cover. What did the children have? They had chairs and desks.
They
The
had
defendant had a pistol.
unlocked doors.
What did the
That's what the kids had. Unlocked doors.
And
Because-
also,
Yeah.
yeah, so the teacher made a really big statement. The teacher that wasn't going to check to see if his door was actually locked, that's the officer's job. So are we now saying that the teachers are allowed to fuck off on their duties, which again, he was in something unimaginable. We shouldn't be charging anyone. We should be fixing the damn problems. But he made a conscious choice that it wasn't his job to go check that door because there were shots going over there.
children have in rooms 111 and 112? They had unarmed teachers. The defendant had a vest on. And what did the children have in rooms 111 and 112? They had curtains to hide behind.
Unlocked doors.
I would also, if you get all the evidence back, that you listen to the defendant's statement. And I think it's always telling, is when that ranger asked him, why didn't you engage? Why didn't you go and approach? And the look on the defendant's face is like, not me. Really? I mean, it's like he catches himself.
Fuck you.
Ma'am, do we really want to talk about appearances? Because I have
Yeah.
been being kind. All right. We don't want to go there.
Yeah.
Because it wasn't his day. On any given day that this monster made his way into Robb Elementary, that wasn't his day. You heard a lot about the time compression, the auditory exclusion, the fatal funnel, the OODA loop, echoing. You even heard about a fatal field. Fatal field. because you know.
Ma'am, I'm wishing desperately for a fatal field at this moment, but it's your voice that I'm trying to get away from.
The fatal tunnel is every time she opens her mouth, because it's only stupid.
Yes.
We all know on any given day there may be a fatal field,
We die.
and we have to be ready. You're going to get the all the evidence behind you sent back with you, and you'll have the radio traffic, and you can look at that and decide if it's 1 minute or 3 minutes. But even a minute and 48 seconds. Well,
It's your charge! Jesus fucking Christ! It's your own timeline!
Nick, this isn't a la carte. You get to pick your own justice. Fucking just take whatever thing. This is not choose your own case time. This is not the Mad Libs of justice. Holy fuck, what is going on here?
This is why I believe that the defense should have the last word. Because, oh my god, this is so fucking stupid. And they could bring up Trooper Paul to rebut her garbage. They could bring up
the
Jerry
crash test
Holman.
dummy.
Yeah.
What did they call him? Like Action Ted or something? I don't
Yeah.
remember.
You can decide if it's 1 minute or 3 minutes. No, you already established your timeline. 1 minute, 4 seconds to the front door that should have been locked. Then an additional number of seconds where he is firing around, and then he enters through another unlocked fucking door. That is your timeline.
Yeah, and do you think they're going to have cops? If cops know that they can be thrown under the bus by this particular DA in Uvalde, do you think they're going to show up to anything?
No, they are all going to be Trooper Hill, doing fuck all at a safe distance.
put up here, 1 minute and 48 seconds. I don't know if anybody just sat still for 1 minute and 48 seconds. That's a very long time to distract, engage, and delay. And his backdrop was right here. It was right here. All you
No,
have to
it
do
was the houses over.
was see.
This woman's a DA. She's like, his backdrop was the school. No, it was the houses behind the school, you moron, you flibbity gibbet.
In order for him to have a backdrop, he has to have a line of sight. He never saw him.
Fair point, Nick.
Yeah. I wish it was Friday. I would be smashed drunk by now.
Me too.
An attempt to distract, delay, or engage. I know this case is difficult, and it has been difficult.
So much so I couldn't brush my hair.
But we cannot continue to let children die in vain.
Hey, as a tip from a former theater kid, if you have to work that hard to bring up not even a tear or a quaver in your voice, don't do the dramatic pause. You've Shatnered the shit out of it, and it only works for Shatner and
Yeah.
Calculon.
Yeah, that break in your voice, bullshit. That's all theater.
It's Vicks. You just put a little in your nose and you water up.
Yeah,
Or
it
pull
didn't
in
work
the-
for it
the
didn't
nose
work
hair.
for Amber Heard, and it does not work for Fander Disturbed here.
We cannot. New Essex County is not any different from Uvalde County. We cannot let 19 children die in vain and another 10 to suffer. They're going to be
Proving the defense's point. We don't have the monster. They can't die in vain. So convict this asshole. Did he have anything to do with it? No. But they died. Don't you see?
Jesus Christ.
Yeah, suffering for a long time.
And who the fuck sold the
On
children
behalf of those 19
$30,000 worth of gear? Why is that person not on trial? Did they even try to find the guy who... This was an unemployed young man in a fucking in a $80,000 truck with ammo for $5,000 to $10,000, gear, everything. Who gave it to him? Who sold it to him? For what fucking money? I haven't heard of any trial about people aiding.
Yeah, why was
shooter.
that gate unlocked? Because it was only supposed to be unlocked with someone standing right next to it. Who unlocked it prior to that?
Yeah.
Because the defense brought that out. Why were all the doors unlocked, exterior and interior?
I respectfully request that after your deliberations, that you return a verdict of guilty. Thank you.
Oh, she's done.
Oh, thank you, Jesus.
Ladies and gentlemen of the jury, you will have the charge of the court back there. You'll have the evidence. I will ask you to deliberate and give us the word when you have a verdict, and we will alert everyone and give time to get people back in the courtroom, and we'll bring you out and receive the verdict. We're going to have lunch served in the jury room for you. You're welcome to deliberate while you're eating lunch. And could I ask the three alternates to remain? We're going to have them go back, and I'll talk to you further. Okay? So everyone rise for the jury.
That was a horrible rebuttal closing.
Yeah, I expected crap, but I didn't expect that.
No, this was a whole new... This is... Remember the 32-second opening statement a number of years back that I covered?
Yes,
This
I do.
this is it, but as an... No, 32 seconds with her crying with a poster of their children would have been better. Because then at least they would be honest about we are doing...
Chandler Holderson's defense, where they tried to float the, well, I mean, they have evidence of like everything except the red rum. How do you know they didn't die accidentally? I mean, at least they made a point. It was a dumb point. She's like, some kids died, so he has to pay. She legitimately said that.
Yeah. I'm dumbfounded. Absolutely dumbfounded on how bad this was
I
from
almost
the
want to.
prosecution.
Oh,
We
this
can
is
listen.
like,
We can listen to Andrea instead.
Oh,
But
yeah.
this,
let me.
hold on. I have the link in private chat, so we can.
Oh, thank you.
Yeah, so we can listen to how Andrea reacts to at least
The I want her.
shit sandwich woman from the prosecution's team.
We were way behind. I love because I'm like, oh, she's
Yeah.
been talking. All right, let me get it to where. Oh God.
I think
Okay.
50 minus 55 minutes or something.
Yeah, here.
But I don't know if she's got. No, I think she listens and then talks. So go right after
Okay.
when she stops.
Oh, she doesn't pause. That's how she's on time.
Yeah. She's one of these responsible people.
Oh, well, that's not us. All right.
That means there's still a couple jurors who, and what's been asked for, anything else, but it looks like not. Gonna go straight to verdict watch. Yeah, I am not expecting anything real rapid here. I know the defense asked for it. Nico asked for it. I don't think they're going to get it, even though this is not Uvalde. This is over in Corpus Christi. It's a different county, different jury. They're still going to want to show respect to these family members and what they suffered, and they're going to want to be very careful. And even if they are kind of all on the same page, which they may be, but they might not be. I mean, if they're roughly 80%, that means there's still a couple jurors who are on the opposite side. But even if they do all generally agree, they still want to look like they're being really careful, just because that's how you show respect.
And I agree with her here. I
Yeah.
think we're all behaving emotionally, but I made the point that I have 253 pages of notes. Now, I know that their notes are taken away, but there is a lot of evidence. And even if I'm pissed off, I want to respect those kids and those parents.
So we'll go ahead and, because I was just barely starting to recap kind of where everything started when we came back from the recess. So I'm just going to go ahead and start with the states. We already talked about the Abraham Lincoln quote. I don't think that was a good start, because it just is inviting the jury to consider, are you applying this standard to yourself? You are the government standing here telling us how great it is that the government can do justice against itself. You, the prosecutor, consider your judgment. And has this been fair? Has this been just? If we're not already on your side, that's going to be real off-putting. And you have no guarantee that the jury is already on your side.
Yeah, and this appeal to Lincoln, not everyone thinks Lincoln was a great arbiter for freedom. He threw away due process. Bringing in the, leader that suspended due process for half of the nation is maybe not the guy you want to bring in.
So it was a bold move. Bold move, starting with that quote. The send the message we talked about. Super objectionable, super improper where I am. Unquestionably prosecutorial misconduct. But they didn't object. Maybe it's by design. Maybe they think it helps. Maybe they think because they were able, the defense was able to respond to the state's argument in a way that the state was really not able to respond to the defense's. The defense thought, hey, we can turn this to our advantage. Yeah, think about the message. Maybe they think it works for them if that door is open and you want to talk about that. But I certainly notice the prosecution doing that because it's improper and it's cheap and it's exactly not what the jury is supposed to be basing their decision on. What kind of message would it send? Based on what? Based on perceptions of people who didn't follow the case, like me with the Parkland guy, is that what you're saying? Placate the uninformed gut reactions of people who, like me, who are just kind of instinctively like,
I think the defense did a good job. And I know I saw different comments, and I did want to bring this up. I'm going to take Andrea off for a minute. I think that Nico was right to bring in his personal experience with losing his brother because he understands where the families are. He probably wanted like hell for justice to be done. He had to pick up his mother. As a person who's heard that mother's cry, that is a sound that sticks with you.
Yeah.
So to tell them that he understands that, would I have liked it in a normal trial? If this had been a straight case and the state had played it straight, would I like the defense bringing this in? Absolutely not.
No,
but they
absolutely
weren't
not.
fighting on a fair scale, and I think it was right to bring that in, to humanize the defense, because for all this time, the state has told them that the defense is they are making excuses for this coward that did nothing, that sat here. So he has to humanize this. He has to explain that we get the desire. Look, if it would help, if it would fix anything, but it isn't, and it's not justice.
Yeah. And running and being shot at, and then getting kids out. That's not participation trophy. I mean, just she's
It was so
it's so disingenuous and so disrespectful.
And it's so hard to swallow when she reads, okay, so the defense said that he made it to the scene and he drove into the gunfire and he talked to, the witness and he, went to find keys and he went to evacuate children, and isn't that good? It's hard to follow the line of logic when you keep saying he didn't do stuff and you just read this laundry list of things that you said, well, all that didn't count. It's very hard to hold that because it doesn't make sense. And what the defense did masterfully was taking the state's witnesses, its own law enforcement witnesses, and bringing in the perceptions of Adrian through them. Is it chaotic in a scene? Is your mindset different from a bailout to when you get dispatched, shots fired? Is that a different mindset? Do you have to switch up your mindset? So I do like where Andrea is going with this. I don't want to sniper stream the entire time.
No, but I mean, her opinion. I mean, me and Mo, we are trying to make the unbearable watchable by adding a lot of things that you don't normally see from, especially if you saw me in my line of work, that's completely different. I really am very stoic with my resting serial killer face because it works. I don't think that would work here.
Yeah. And I also think it's been the only time the lawyers, Adrian through the lawyers, can kind of express, I cried too. Those were my kids. If you don't think I am not persecuting myself every day, please understand. Because I will say that Adrian did very well at remaining stoic.
Yeah, but he still, at certain moments, he couldn't hold it back. I think that worked for him.
I like that he didn't make a production of it. In a case where it is being used as a manipulation, the stoic sort of control and not trying to use it is so much more powerful than the blatant kind of gratuitousness of the state.
Yeah.
Now, I do wonder, because the defense has been so good, are they going to be the defense for the chief? Because I think there are legitimate charges that the chief could face.
I don't know. I mean, they are tried separately for different reasons. So yeah, of course, it's possible. But those two cases has been paralleled. So I'm not sure if it is the same team. It might be the same firm, but not the same team.
Because I will say that they collected a good kind of mix of lawyers. They had the officer with tactical training. Now, I think he was, I don't know exactly what they classify them as, but the officers that are allowed to carry firearms in the UK, because I know they're a different tier, I think.
Yeah, to my understanding, at least.
I was about to say, to my very limited knowledge of UK law enforcement. So I think they got a really good team, but I think that Adrian's case and the chief's case are completely different, because I do
Yeah.
think there are legitimate criticisms of the police chief.
Yeah. One thing, if I did some of the defense for the police chief, all the damage was already done when he got there.
And I think we have to go back to the training he received as well. And if I'm understanding this correctly, it seems like the school board is much more in charge of the equipment that they've got. So
Yeah.
the school
Now,
board has a lot of
now
discretion.
apparently he left his walkie-talkie behind and lots of stupid things. Yeah, I don't know enough about it.
Neither do
really-
I. So that's what I'm wondering, if how they're going to approach it, because I think there are ways that you can mitigate some things, but I think his position of leadership is going to leave him somewhat open for a legitimate case. Because he was the one that switched it from active shooter to the barricaded subject, which changed kind of the, rules of engagement. Alrighty. Just seeing if Court TV's got the timer on yet.
No. I mean, they were allowed to start conferring during lunch, but they don't have the clock hasn't started yet.
Now, I will say that the one thing that is unique, if we compare this trial to Delphi, the one really unique thing about Indiana is we can start deliberating as the case
During.
starts.
Yeah.
Yeah. So that was a really eye-opening thing for me, because I was like, that's not the law. I had to double check. I was like, this isn't lawful law.
You're about to go all Daryl Brooks on them.
Yeah, I was like, as the third party intervener for Mo, I would like to represent that I didn't contract with the state today. I'm just kidding. Also, what an interesting thing that Randy Hill has body cam.
Yeah. I mean, you would actually, depending on when he chose to turn it on, we would know exactly when he got there and what he actually did. But they
wonder
only
if he had
they only
dash cam.
referenced. Yeah, but they did say body cam, but they might have meant dash cam. I don't know. But the very fact that there are video that wasn't shown by the state, that they let's forget about this. Let's forget about that. Let's poof. We don't. We ignore them. That in itself. Court TV is at 51% guilty now. They were at 58% not guilty a couple of hours ago.
They were convinced by that hag? This is why you hang out on the Petty Express and with Nick, because we're smart.
I don't see. I think they took it down because I don't see vote on Court TV now. Maybe on the homepage.
Now, I will say that I have noticed on Court TV and Law and Crime, the only thing that they seem to put up are points from the state. They did not really have, anything from the defense, like defense blows holes in state's theory. It was all witness testimony, snippets, and things like that. Yes, we can really start to deliberate early. You can start deliberating as soon as you're given your first break with the first witness. And yes, I will put up a poll.
Yeah, I haven't. Oh, I haven't eaten since lunch my time, which is now 8 hours ago. Um, I'm going to.
Okay.
I'm guessing you're keeping the stream up.
I will be keeping the stream up at least until 5, like the normal time.
Mm.
We will probably start watching the Paul Caniero trial while we're waiting. I'll have Uvalde going on a screen, but we might go into the first witness in the Caniero trial just because. Oh, and I have to tell the hand worker story. You're right. So I will tell the hand worker story and then we will go to the Paul Caniero trial.
But this poll was when the closing started. But I believe I checked it and I saw 58% not guilty. Maybe, yeah, I don't know. But even if it was 51% guilty on court TV, that's an extremely low number.
Yeah.
Yeah, but I need to get my. I also haven't had my afternoon nap. I'm going to be destroyed. But I will do things, and if you're still live when
Okay.
I'm done doing things, I will come back on.
Alrighty. I'm trying to get the stream that I needed, so I can't multitask. I'm aware I can't multitask, so I didn't sign up to be a police officer.
Are you saying you're in the middle of an idiot? Are you the
An idiot
are you
sandwich?
the white stuff in the Oreo?
Oh, speaking of which, are we all unindicted co-conspirators since defense was obviously watching our trial testimony or our trial coverage?
Yeah, definitely. They will charge us next.
Yes.
Definitely. The defense listened to us because they
Yes.
brought up points that we have been cursing about for 3 weeks.
Also, thank you, defense, for still listening to me after I dressed up as me, Pearl, which is, you took a gamble, and I appreciate it.
All right.
All righty.
Folks. Yeah. See you later.
See you. All right. So the hand story, the infamous hand job story. This comes courtesy of my youngest, most feral child. It is, in fact, one of my failures in parenting, but possibly the funniest thing that's ever happened to me. My oldest daughter last year was getting ready to go to college. And much to my youngest and middle son's horror, you have to go to school, or there are schools after high school. There is more school after high school. And I was I'm a big encourager of technical schools, of, having a trade or a skill instead of just going to college. So my husband and I, thinking we're doing a good thing and, broadening the boys' horizons to vocational work, working with their hands, we watch Dirty Jobs and talk about, playing or not playing with electricity, but, being an electrician or a carpenter or, construction. And I thought we had done a good thing. Like, I went to bed that night and slept the sleep of a mother who had taught a valuable lesson. And that joy and comfort in my parenting skills lasted till the next morning, when I am taking my sons to their private school. Now, let me explain to you that their private school is so Christian that girls cannot wear skirts above their knees. Okay? For gym, they can wear shorts under their skirts. All right, like Shiite Christian, okay? So we're on the way to school, and still in my foggy haze of being a good mom. Just my altogether, I have gotten my children dressed, their teeth brushed. I am taking them to a school where they're learning cursive. I am a good mom. So I'm not really paying attention to the conversation that's going on in the back seat as I'm driving down the highway. And all of a sudden, my brain starts cueing into a couple of words and starts noticing the conversation that is going on in the back seat of my car, which goes like this. I'm going to do so many hand jobs when I grow up. Yeah, hand jobs are awesome. No one should go to college. College is stupid when you can do hand jobs. I'm going to tell my teacher all about the hand jobs I'm going to do when I grow up. I'm going to tell all my friends about the hand jobs. Now, as my brain is slowly filtering this information in an OODA loop, I am working handicapped because 99% of my brain is laying on the floor, laughing so loud I cannot breathe. I need to call 911. The rest of my brain is trying to drive so we don't die. And then the other part of my brain is trying to figure out how to make sure I do not get called by the pastor/principal because my kids say they're going to do a whole hell of a lot of hand jobs when they grow up. So I had to look back in Now, this is the trick, because if your children know that they are saying something funny, they will repeat it. So I had to look at them with a straight face and say, it's work with your hand, not hand job. And you can't say that. You cannot say that to your teacher. If you say that to your teacher, you will never, ever get your iPad again. And it was at that time that when my youngest, most feral son asked, well, what's so wrong with it? Why can't we say that? I looked at him and I decided, not my job. Ask your father. Of course, as soon as said children were dropped off, I called their father and said, do you know what your son's just said? And if the teacher calls, I'm giving her your number. This is a you thing. I went through puberty with 3 girls. This is a you job. Now, that is the hand job story. So every time you think you're doing something awesome as a parent, it's generally going to come and bite you in the butt. But it does give you hysterical stories to share. Now, we are going to be jumping into the Paul Caniero Mansion Massacre Murder Trial. That's a lot of M's. I called it the Brother Betrayal Trial. Basically, this case is about Paul Caniero is the defendant. He laughed his butt off, and he's like, better you than me. And I was like, daggone. Mo, this reminds me of the time my young kiddos told their conservative pastor grandparents about their sperm and eggs at breakfast. Oh yeah, no, I have so many stories, like when my 4-year-old son loudly looked at me in Walmart, having, just procured for him another baby brother genetically related to him for play, and loudly announced that we have to buy milk because mom makes some, but she won't squeeze enough for the entire family. Don't be jealous of my glamorous life. I think, title my story, I'm sorry, Mike Rowe, but I do need to type it out. But yes, he's like, yeah, we apparently, I was just, again, not my job, yeah, he was very upset because he's like, we have a cow at home. I don't know why we're buying milk. And I was like, thanks, child. But back to the story. Paul and his brother Keith were business partners, and right around in the middle of the evening in November in 2022, I believe, Keith's house, it was on fire. And it was really strange because Keith was found shot dead outside of his home near the generator. And when the police started looking into this, they realized that the generator had been cut, and so had the generator had been turned off, and the power had been cut to the mansion. And they're really going inside and they're trying to figure out, because Keith has a family, he has a wife and 2 children, and the house is on fire. Well, unfortunately, there were 3 more bodies found in the house. And the medical examiner determined that all 3 people in the house, so Keith's wife and his niece and nephew, were stabbed to death in the house. Now, the state, in their opening, did do a little bit of emotional stuff, but she cut it right off. The medical examiner did determine that the children were not dead when they were left and when the fire was started, because they do show signs of smoke inhalation. Well, coincidence of coincidences, it was a really bad day for the Caniero family, because almost simultaneously to Keith's house being found on fire, Paul's house has a fire reported at it. Now, Paul's house is a little different. There was a small little fire. The entire house wasn't consumed. That started near his basement, very close to the natural gas line. Now, police were really interested in getting this, taken care of, because near natural gas line. But it was kind of curious, because there were small little puddles of fire going back to this little area in the basement that was burning. And there was a melted gas can outside that area. Now, the police go down, and the fire's out. Paul and his entire family have managed to escape the house before the fire got too bad, and they're sitting in their Porsche. I don't remember what name, but some sort of Porsche car. And they're just sitting there, and the officers say, "Hey, can you go to the police station? We want to kind of talk to you about this. Did you know that your brother's house is on fire too? What's going on here?" And as they're processing the scene and, getting things done, they find this kind of pile of semi-burnt stuff. And it turns out to be black nitrate gloves, jeans that have the blood of the niece and the nephew on them, and just basically all the evidence. Now, we come to find out that Paul allegedly had been embezzling trust money to pay for a whole life insurance to the tune of $78,000 from his brother's trust account. He hadn't paid the premiums in 6 months, and Keith was finding out about it. In fact, the very night of the deaths and the fire, Keith called Paul because he's like, "Where the hell is this money going? Canada Mutual Life says they don't have any record of you paying our insurance. What is going on?" So basically, the state has a crap ton of evidence. And the defense's counter to this, you know what? We've already had a really good defense. I think since it's so short, we're going to listen to the defense, because it is the dumbest thing. If Kim Kardashian had passed the bar, we need a laugh. This is hilarious. Oh, well, it's a bit longer, but she's dumb, so we can.
The defense?
And our poll is 100% not guilty. I'm not shocked.
Good morning, ladies and gentlemen. Thank you for being here and for your willingness to serve. The prosecutor just got up here and told you about a horrific tragedy. A tragedy caused by crimes that are horrifying and devastating and heart-wrenching. They're unspeakable.
Now, I don't know why she decided to tuck her hair into her collar and also dress like Sgt. Pepper off of the White Album. Not sure. Or that she wanted to be a majorette in high school. I have no answers to these questions. I cannot. We tried to look at it yesterday. She wants to annoy my ADHD. Oh, that's right. My jury story. If we get through the defense, I will tell my jury story. I'm keeping an eye on verdict.
There's no words. In fact, no one should ever have to find the words to speak about something like this, because something like this should have never happened. It's heartbreaking. Some of you might be looking at me and wondering, how is she going to defend that? What?
No, we're only wondering why your hair is tucked into your collar. It's driving me nuts. My type A personality is just like, take it out, take it out, take it out, take it out.
What can she do to defend against such awful crimes? How can she, or anyone for that matter, defend what happened here? And if you are thinking that, that's a reasonable question to have. So I want to be so incredibly clear. I am not here to defend what happened. I am not here to defend against those crimes. I am not here to defend a tragedy. I am here.
Again, tip from a former theater kid. If you're going to make a dramatic walk across the courtroom, make sure you can walk in Louis Vuittons or whatever hellacious high heel you have, because it looks like a giraffe taking a long stride. It's not powerful. It's not dramatic. It looks like you're trying to walk in stilts.
To defend Paul Caniero.
Just
Because
parts.
Paul Caniero did not do this. He did not commit these crimes. He did not hurt anyone. He did not harm anyone. He did not set any house on fire. And he certainly did not brutally murder the family members that you will hear he loved and cherished and adored so much.
Now, that's basically all of her argument, along with, I'm sorry, you poors. $78,000 wasn't a lot of money to steal for Paul. That wasn't a lot of money, so how dare you think that that would be a motive? Legitimately, she said that. She's like, well, Paul was really rich, so, you know, $78,000 was not a lot of money. It's not a good look. You don't want to tell the jury, like, yeah, you're just poor. You wouldn't understand.
When the state is ready, they can call their first witness.
What in the tackleberry is this judge? I feel like I'm watching Night Court.
Judge, the state calls Ghoulie Basu.
Bible there? Okay. Ma'am, can you just bring the Bible over in front of you? You can put it on your stand there. You put your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You have to speak up so we can all hear. Okay. I want you to sit down and get comfortable. You comfortable? Okay. State your full name for the record and spell your last name, please.
Shakuntala Basu, last name B as in Bob, A-S-U.
Okay, great. Thank you so much. If you don't mind, you have to keep your voice up. Juror number 16 in the back over there, he's got to hear everything that you're saying. So you got to make sure that we're nice and clear. Prosecutor, when you're ready.
Thank you, Judge. Good morning, Ms. Basu. Ms. Basu, could you tell us where you worked back in 2018?
Doris Duke Foundation.
Okay, can you tell us what does the Doris Duke Foundation do?
It's a nonprofit private foundation that gives away grants for areas of giving by the will of Doris Duke.
It's a charitable organization?
foundation.
Okay. Now, can you tell us what, if any, locations physically Doris Duke had?
New York, New Jersey, and Hawaii.
Okay. And were you assigned to one of those locations back in 2018?
My main office was in New Jersey, but I had to travel to New York and Hawaii offices.
Now, back in 2018, can you tell us approximately how long you'd worked for the Duke Foundation?
I started in 2001 and left in 2024.
Okay, so you no longer work there?
No.
Okay. Now, back in 2018, can you tell us what your title was with Doris Duke Foundation?
I was the Director of Information Systems.
Okay. Can you just briefly, for anyone who might not know, tell us what that means?
I was responsible for information technology, rendering technology services for all the sites, which is New York, New Jersey, Hawaii. Technology included everything: security, user computing, telecom, networking.
Now, as the Director of Information Systems at Doris Duke, who did you report to directly?
The Chief Operating Officer,
Okay, back in 2018, who was that?
Peter Simmons.
Okay. Now, I want to ask you, you said you were the director at that point in time, correct?
Yes.
How long have you been the director as of 2018?
2016, I was a director, and in 2020, I was promoted to the Chief Technology Officer.
Okay. So is it fair to say in 2016 you became the director?
Yes.
Who was the director prior to you?
Deborah Close.
Okay. Now, I want to ask you a little bit about the IT needs at the Duke Foundation. You familiar with those, I imagine?
Yes.
Okay. Now, did someone provide IT services to the Duke Foundation?
Yes, it was through a managed service provider. The company, all the companies you want me to name?
Let me just, I'll be more specific. Did the Doris Duke Foundation back in 2018 and prior to that have any relationship with a company called Square One?
Yes, they were our primary managed service provider.
Square One was owned 90% by Keith and 10% by Paul. Now, they owned another business. Yes, this is the first witness in the other case. Now, the other business was a pest control business called, I think, One Source or One Star. And the brothers owned that 50-50. Now, around the time of the murders, Keith was getting ready to lose his only client for the Square One, the kind of consultancy for computer technology stuff. They were going to not renew their contract with him, and Keith was looking to sell that other business that he owned half and half with Paul. Now, the state contends that this sale would have put Paul in a very bad financial position, that Keith had, planned on, the Square One or the computer company that he owned 90% of, not having any clients. And he had, figured out a way to keep his family financially stable as he transitioned to working for, I think, just another company as maybe an employee rather than being a business owner. So I think they're bringing her in to set up the foundation for, bringing in that sort of knowledge.
Provider.
Okay, when you say primary managed service provider, what did Square One do for Doris Duke?
Managed service provider was a key vendor, services rendered by this company that provided technology services and support to all the offices, to all the users at the foundation.
Okay, and do you know, as of, let's say, how long the Duke Foundation had a relationship with Square One?
I think the first contract was signed in 2003, perhaps, yeah.
Now, is it fair to say for a substantial period of time?
Yes,
Okay.
yes.
Now, back in November of 2018, was there a contract in place for those services between Square One and the Duke Foundation?
Yes.
Okay. Were you involved in the creation or the negotiation of that particular contract?
No, the director was then, Deborah Close.
Okay. So Ms. Close negotiated that contract?
Yes.
Were you an employee at the Duke Foundation while that was being negotiated?
Yes.
So as far as that contract was concerned, do you know who negotiated on behalf of Square One or no?
Yes.
And who was that?
Paul Caniero.
Paul Caniero, did he work for Square One?
Yes.
Now, as for Square One and your knowledge of Square One, did you know who the owners or the people who ran Square One, who they were?
Yeah.
Okay, and who were they?
Keith and Paul were primary working towards the contract.
Okay. Now, as far as Square One's day-to-day operations at Duke, who was actually responsible for that? Let's say in 2018.
Well, we had three tech support guys on site, and a fourth one who went to the New York office once a week. And we also had a senior engineer who would be brought in for special projects. But they were all managed. Technology management was done through Paul.
Was done through, I'm sorry?
Paul Caniero.
Okay. Now, back in 2018, you were in that portion of that contract. Were you dealing with Paul Caniero?
When you say dealing, he was the senior guy from Square One who helped with technology support and services.
Now, that contract, the one that was in place in November of 2018, do you know when it began?
It was a 6-year contract, so it was signed in 2013, and we were still on the contract with them.
Okay. Permission to approach the witness?
John?
Sebastian, I'm just going to show you what's been marked as S17 for identification. Do you recognize what that is?
Yeah,
And what is it?
contract
A contract for what?
for a managed service provider through Square One.
Okay. So is that a contract between Square One and the Doris Duke Foundation?
Yes,
Okay. And again, does it indicate the inception date of that contract?
it is November 15th is when it was prepared.
Okay. Now, I just want to direct your attention to the end of that, page 5 of S17. Do you recognize that area?
Yeah,
And what is that?
it was signed by Ed Henry, who was then the CEO. And on the right, it was signed by Paul Caniero, who was the lead person at Square One for all contracts.
Okay. And does it indicate with respect to Mr. Canero's, I guess there would be printed name, does it indicate a title?
It says VP here.
Okay. Now, the date again of those signatures is what?
Yeah, November 15th, 2013.
Okay. Now, you said this was a 6-year contract, correct?
Yeah.
Okay, so 13 to 2019, is that accurate? Okay. Now, was there any provision within S17 wherein the contract could be canceled at any time?
Yeah, there was clause in there with penalties for the year if you did cancel the contract.
Okay, so
Oh, good idea. Thank you so much. Let me do that. Dingus, get off the laptop. My cats listen as much as my children, which, you know, is fitting. Cats listen to no one. And he's turned off my laptop. He's a genius. I don't need to schedule it later. All right. I don't need to set this. Okay. Thank you. You are not being helpful.
It was canceled after 2015. Was there a penalty?
I'm sure it's in the contract, and there would say how much that would be, the amount.
Okay. Just gonna direct your attention, have you read it to yourself. Page 3 of the contract. Do you see that?
Yeah,
And does it indicate certain years would have cancellation penalty?
yes.
And those 2 years would be which years?
This was the 5th year, the 2018, that if we cancel, there would be no penalty for year 6, which would be 2019.
Okay.
No penalty.
Okay, so if the contract was canceled at the end of 2018, Duke would not have to pay any fee?
Right.
Okay. Now, I just want a last question with respect to this existing contract. Does the contract spell out the terms financially of what Duke was being charged for Square One services?
Yeah, it says what the annual cost would be, and then we would pay the monthly fee of what's in this column.
Okay. And in 2018, is that one of the years that's on that chart?
Yes.
Okay. And in 2018, who was in charge of Duke's IT needs? Who was the
Paul?
director?
Oh, it's Doris Duke, it was Deborah Close.
Okay. Had you taken over yet in 2018?
2018, yes.
Okay. Now, just specifically with respect to the year 2018, could you tell me what the total cost was to Doris Duke for the Square One contract?
It says here it was $1.4 million
Okay, and change, correct?
and change.
Okay. And does it indicate, you said it was paid monthly, does it indicate how much Doris Duke?
What the hell kind of IT support are you doing? I mean, that's for 6 years for 1.4 million. Or was that yearly? How are you staying in business as a not-for-profit? This is why I didn't go into business. Big numbers scare the hell out of me.
Duke was paying to Square One a month.
For the contract, this was 123,000 to 123,220.
Okay.
That is the monthly, but this is for the contract, but they were used for all technology services, so there are others,
Okay.
other costs.
Explain that to me. I think what you just said is that Duke sometimes incurred other costs to Square One. Is that accurate?
Yeah, those would be business initiatives, technology initiatives for the business of the foundation. There would be projects, special projects, and Square One had skill sets to provide those individuals to run that project.
Okay. So is it fair to say that Doris Duke spent money additional to that 123,000 a month on other IT needs?
Of course.
Okay.
So Jason, he embezzled from his brother. He was set up as the custodian or guardian of the trust, and he stole $78,000 from his brother that he was supposed to be using to pay down the term of his whole life insurance policy for $3 million. And the DoorDash case, she was the female DoorDasher who went into a client's home, filmed him because he was passed out drunk mid-wank, I guess, when he ordered food. Now, the customer had asked that the DoorDasher just leave the food on the door. She actually went in and then filmed him half nude and claimed that he had essayed her, basically harassed her, and tried to, do a big old TikTok about how she was harassed. Turns out she went into the house without being asked, so she kind of burgled him. I believe that there were other allegations that he might have been embezzling from the businesses, but I don't know if the state is going to go and prove that. The state only mentioned this $78,000 specifically in their opening statement. Now, I do believe that there have been allegations that Paul was also embezzling from the businesses, but I don't know if that's going to come in. No, not the one that pepper sprayed the food. That's in Indiana. That's in my neck of the woods. It was one single policy, and Paul, he embezzled for a period of 6 months. I don't know how much a $3 million whole life insurance policy is going to cost, but apparently the amount that Paul didn't pay to the insurance was $78,000.
Now, with respect to the time frame of November 2018, were you looking, you being on behalf of Doris Duke, were you looking into other IT services potentially to replace Square One?
Yes.
Okay. Can you just tell me, just generally, what you were doing in that regard?
I was looking at other managed service providers where the goal was to provide and enhance the support, provided 24/7 coverage, looking as to what would be the best price point for the foundation to deliver that business.
Was price important to you and Doris Duke?
Of course.
Now, in that time frame, November 2018, had you begun, potentially looking into other options?
Yes.
Okay. Now, the fact that you were potentially looking into other options, was that specifically communicated to the representatives of Square One, either Paul Caniero or Keith Caniero?
Not directly.
Okay. When you say not directly, explain that, please.
I had different companies, managed service providers, come on site and sit with me to, to understand their offerings. So.
Were the Canieros aware that you were looking at other companies, ma'am?
They came to my office, and there were Square One tech support guys there. So it was very transparent.
Okay. So you didn't do anything to hide that?
No.
But you didn't specifically communicate that to Keith Caniero or Paul Caniero?
No, I didn't have to.
Understood. Now, with respect to the potential to renew the Square One contract, did you have any communications with any of the representatives from Square One, like the management, the owners?
No, but I did mention to Keith that the cost was too high and that I was looking to save some money because I think I think their cost was higher because I already knew from other vendors what they were proposing.
Okay. Putting costs aside for a second, just from your perspective, was Square One doing a good job with why you use them?
Yeah.
IT needs?
Yeah.
Okay.
Yeah.
So this was about cost too, is that accurate?
For me, it's cost and improvement of services. I mentioned 24/7 because we had an office in Hawaii, and so we didn't have 24/7 coverage with Square One.
Let me ask you this, Ms. Basu. Was there a time when you met with Keith Caniero about potentially, exercising that final year option?
Yes.
Okay. Do you recall approximately when that was?
Towards the end of the contract, like in 2018, I would say October, November, sometime.
Okay. Now, can you just explain? I don't want to know what anyone else said, but can you just explain to me and the juries, essentially what you were discussing at that meeting, just generally?
Well, my boss was there too, the chief operating officer, Peter Simmons. Peter Simmons and I spoke to Keith to talk about that this contract was coming to an end, we had no penalty if we did not renew the contract in 2019, but we were familiar with their staff and we liked their services, but the cost was too high, so to keep the contract with Square One, what would it take them to reduce the cost and yet deliver the services that we were expecting from them?
Okay, in that meeting, obviously you were in that meeting, correct?
Yes.
And then you mentioned
Say
the
hi,
CEO, right?
giant cat.
CEO, Chief
COO.
Operating
Okay. And that's
Officer.
who again?
Oh,
Chief Operating Officer Peter Simmons,
Okay. And then who else was in the room in the meeting?
Keith
Caniero.
Caniero.
Now, at some point in time after that meeting happened, did Keith Caniero or anyone from Square One, did they follow up with respect to potential proposals being offered to Duke?
Yeah,
Okay.
Keith sent information via email.
Sorry, how did he send that information?
Via email?
Okay. Do you recall receiving that email and evaluating what was attached to it?
Yes.
Okay. I'm going to approach you and show you what's been marked as S18 for identification. Ask you if you recognize that mail.
Dingus, don't you dare.
Yeah.
Okay, and what is that?
This was an email from Pete to me with a copy to Peter about what the options would look like. And he provided the 3 options for the contract.
And generally speaking, what were those 3 options?
Like with reduced cost, and also what would the penalty be if we just did not keep the contract for multiple years, and the option to kind of get out of the contract.
How many proposals did he send?
3.
Okay, 3. Were all 3 proposals, were they different amounts of years?
Yeah,
Okay. Different types of cancellation penalties?
I don't remember the numbers, but I
That's okay. With respect to those contracts or those proposals, were they doing anything with respect to how many people would staff Duke during the contract?
Yeah, I remember the cost savings was reducing the number of support staff on site.
How many were there during the course of 2018?
3 on site.
Okay. And how many, if you recall, would be there if you accepted any of these proposals?
I think 2.
Just going to show you what's been marked as S19 for identification.
Dingus, no.
S19 it's got an A, B, and a C. Okay?
Okay.
Now, do you recognize the first page of what's in front of you, S19?
Yeah,
And what is that?
it's a contract that you showed me prior, November 16th.
Okay. So fair to say, in preparation for your testimony, I showed that to
Oh,
you?
sorry.
Ooh.
No, that's okay. But I think what you said is, prior
We
to
are
your
going to
testimony,
zoom through this.
did we
This is
meet?
kind of laying foundation. So what the state is getting out of this is that Paul has an awareness that there are going to be financial changes. Keith had been very open, according to the state, with Paul that he was looking to, drop this business, sell the business that they own jointly, and just work for someone, not be in charge of a business. Now, there were allegations, or if you read between the lines, it does seem to be some implication that Keith no longer trusted Paul with money, but then it's kind of confusing as to why he made him the beneficiary of the trust, or the trustee of the trust. So that doesn't quite make sense, but there have been allusions to there being some sort of embezzlement with the company.
In preparation for your testimony, did we talk about your
Yeah.
testimony?
Yeah.
And did we discuss these proposals?
Yes.
But those
So I'm just going to see what the defense has to say. Oh,
Site so much.
what in the hair do we have here? Ponytail lawyer.
Negotiations, but I take it that since Square One now, and she's the one that negotiated the 2013 contract between Duke and Square One,
Yes.
and she did those negotiations with Paul,
Yes.
right?
Oh,
now
God,
you were
I
in a
didn't get the right time.
did you ever have the opportunity after or between November 16th of 2018 and November 20th of 2018 to kind of give Keith Caniero an answer as to his proposals?
No.
You didn't have that opportunity? Your Honor, I have no further questions.
Okay. Ross?
Thank you, Judge. Ms. Basu, good morning. So, okay, to understand this, you started with Duke in 2001. And what was your title back then?
I was hired as a network engineer and then into operations manager.
Okay. And you started overseeing Square One in 2016?
Yes.
Okay. So, what was your title at that point?
I was a director of information systems from January of 2016, but the prior director left May of 2015, so I didn't have the title, but I did manage the IT department from the time Deborah Close left.
Okay.
So it was part of 2015.
So, 2015 into 16.
Yeah.
Square One had been providing services.
Nick, did you end up in New Jersey about 40 or 30 years ago? Because we might need a paternity test. It's young Santa laws. Seriously, though. I don't know why I just came up with that, but I looked over and I was like, Nick, were you in Jersey like 30 years ago? Because I got some questions.
To Duke since 2003, and that was under an original contract, right, that they had with Doris Duke, right? You didn't
Hold on
participate.
for 1 second. Ma'am, you have to say yes or no.
Oh, I'm sorry, yes.
That's okay, I understand.
Yes.
Now, you didn't participate directly in the original contract with Square One.
No.
But you know that Paul and Keith were involved with Square One's business with Duke since the beginning, right?
Yes, but Keith was not on site so much as Paul.
And in 2013, when Square One renewed its contract with Duke, there was a different director, the director that you mentioned previously, right?
Uh-huh.
And she's the one that negotiated the 2013 contract between Duke and Square One.
Yes.
And she did those negotiations with Paul,
Yes.
right? Now, you weren't a part of those negotiations, but I take it that since Square One had been involved with Duke since 2003, and Duke in 2013 was willing to sign a 6-year contract extending their relationship with Square One, I'd imagine that Duke was pretty satisfied with the services they were getting from Square One. Is it fair to say?
Yeah.
And when you come on to oversee the Square One relationship in 2016, you continued to work directly with Paul.
Yeah, Paul and others. There was no change.
There was a person by the name of Robert Block, right?
Yes.
And he was an employee of Square One. And he was on site at Duke in New Jersey, right?
As needed.
And you found him to be a reliable person, right?
Yes.
And you found that you could depend on him for services, right?
Yes.
And you mentioned before when the prosecutor was talking to you during this time period, you had no issues with the services you were getting from Square One.
No issues.
The one thing that you mentioned was cost, right? The existing contract you had with Square One, you thought was a little too expensive, right?
Yes.
But that was kind of the purpose of these contract proposals that had been provided to you by Square One, right?
But yeah, Debbie is the first director who ever signed a contract for 6 years. Nobody ever has an extended contract that would go for 6 years. I'm sure, you're happy with the services and you sign it. And she did it.
Right. now 2018 comes and you're in a position to renegotiate, right?
Yes.
I mean, you may be able to save some money by renegotiating a lower price with Square One,
Yes.
right?
Yes.
And that's exactly what was happening, right? You had a meeting in New York City with Keith and the chief operating officer of Duke,
Yeah.
and what you were talking about was the possibility of Duke and Square One continuing your relationship, right?
We said we wanted a revised contract with the price with an extended service because I told you that we didn't have 24/7. So improved services with less.
I don't understand why we're questioning this much. I don't understand what the defense is fighting for unless it's to take away one of the one of the cogs in this kind of Rube Goldberg of what the state has said is kind of a nebula of motives. Paul's financial situation wasn't that great, so he was going to be losing income, and his brother was most likely going to cut him off after he learned that, or confirmed at least, that he had stolen all of this money from the insurance policy.
Cost, and that was addressed at that meeting.
Okay, so that meeting took place on November 13th of 2018.
Yeah.
And then several days after that, Keith is going to forward you those contract proposals that you were just shown, right? And obviously, in those proposals, Keith is offering a 1-year extension, 2-year extension, or a 4-year extension, right?
Yeah.
And the 4-year extension has an option within it to renew for an additional 2 years, right?
Yeah, with the penalty to cancel. That's the 4-year one.
Right. But in that proposal, the maximum amount of time within that contract that Square One and Duke might be in this business relationship was 6 years, right?
How did you get the 6?
Well, it's a 4-year, there's a 4-year contract, right? With an option to continue for 2 years.
We're talking about S19C?
Yes.
Is that what you're talking about? Okay.
It was a 4-year option. 4-year
Right.
option.
The 4-year
Yeah.
option.
So we
Yes.
were talking about the maximum period the contract would be good for is 4 years with a clause to exit with a cancellation. The number that's given in there.
How long do we stay with this
So-
woman?
Keith sent you these, right? And you said that you never had an opportunity to give him a response on the contract renewal, right?
We never wrote up anything officially to say we accept or we don't accept. We never got that opportunity.
And at the meeting on November 13th of 2018,
Yeah.
you didn't say yes to renewing a contract with Square One, but you didn't say no either.
We didn't say yes, we did not say no.
And when you say we, it wasn't just you that didn't say yes or no, it was also the chief operating officer that hadn't said yes or no, right?
Correct, yeah. Yes.
So, just to go back to what you were saying about Paul before, in terms of being on site for Duke. When you say he was on site, what location are we talking about?
New Jersey primarily because that's where the IT department was. We did service the other two, New York and Hawaii, but our main location for IT was Hillsborough, New Jersey.
Okay. And that was your main location
Yes.
because that was where most of your servers and equipment were located?
We had equipment everywhere. This had the most present by size. Number of users were also larger than the other two sites.
Okay. And you were mainly based in the Hillsborough location, is that
Yes,
correct?
yes.
All right, so how often would you be at Hillsborough versus, say, being in New York?
My everyday work was in Hillsborough unless it required my presence for meetings or projects to be in New York.
Okay. So this is all I meant before. Can I approach, Judge? I'm sorry.
Sure, no problem. Just identify the exhibit.
I believe this is 19C.
Okay.
So this is what I was saying before. This is 19C, that's the 4-year renewal contract. And then it said there's an option to extend for an additional 2 years, which would take it to 2024.
Oh, so you're calculating from 19 through 24.
I was,
That's why
yeah.
you were saying 6, okay.
Yeah.
Okay.
Does that make sense?
Understood, yes.
So I mean, a minor point, but
Okay.
what I'm saying is, in this contract, Keith is offering to extend services to Square One, to Doris Duke, through 2024, right?
Yeah.
And obviously is expressing a willingness to be contractually obligated to provide those services for another 6 years, right?
Defense, you got that point out. I'm not sure what that point makes.
You said before that Keith was not really an on-site person at Duke, but
Now, I'm just a people watcher. I have rarely seen men do the praying hands as like a stance. I've just never really seen that before. It's not a stance I would associate with. Yeah, I've just never seen a man do praying hands as a kind of thinking stance.
you obviously had his phone number, right? You had Keith's phone number.
Yeah,
You had his email address.
yes,
You guys would communicate via email.
yes,
You would communicate via text message, right?
yes,
Obviously, if there were any issues with the services, you could tell Paul, or you could tell Keith, right?
yes,
Or you could tell Robert Block,
yes,
the IT engineer, right?
yes,
And you knew that he would make sure to get that information back to Keith and Paul. Is that right?
yes.
Am I watching Pineapple Express? We have Seth Rogen and, well, one of his stoner friends.
Just a moment, Judge.
Sure.
Shuffling papers, gonna make this look like my idea. Come on, sweetie.
The contract.
Oh my God, I remember. Okay, I know why the praying hands bothers me. If you were like me, a genlennial from Bring It On, Kirsten Dunst's douchey boyfriend, you're a great girlfriend. I just don't think you're cheer captain material. That is why praying hands bother me. I'm glad I figured it out. Thank you. Welcome on the trip of things Mo thinks about instead of paying attention.
Options that the prosecutor and I talked about with you today, the ones that were the proposals for the potential renegotiation of 2018, for the 2018 contract, right?
You have to say yes or no.
Oh,
It wasn't not a great question, so let me try again. When those were submitted to you by Keith, you testified that they did have a reduction in cost for Doris Duke, right?
yes.
So they did accomplish that, right?
Yes, with a clause. I just got 3 engineers who would be on site, they took it down.
I'm right. So I'm going to get there with you right now. So it accomplishes the lowering of cost, but that there's going to be less on-site.
Hey, he is Troy McCluring the hell out of this. You might remember him from such things as, yes, I really am an attorney, and no, that's against the law, and other such educational law videos.
People for this
Yes.
contract, right?
Yes.
Now, obviously,
JKD Buck, I think this man we might need to see if Nick was in New Jersey, because I'm just saying he's a young Santa Claus.
these contracts vary in terms of the monthly cost to Duke if they were to execute them. But in terms of, let's say, 19C, which you were shown, the annual cost in 2019 for that contract, for example, I'll approach again, Judge, would have been right around, yeah, for 2019 would have been.
2019, the monthly cost would be reduced to 99 than what we were paying in the original contract. But when we look at these numbers, we were going to get less support because instead of 3 engineers, we would be down to 2 engineers.
Right, right. But the annual cost to Duke would have been $1.2 million.
Yeah, 1.197.
Don't go shrinkflation on me. No, I'm not paying the same price for less Snickers. It's really the only, argument I agreed with. Yeah. I don't know why the defense is taking so much time with this. It really is very tangential to the quadruple murder case that they're supposed to be defending their client from.
Yes.
And under the 2013 contract, you were paying a little over $1.5 million.
But there were 3 engineers versus 2. We're taking a full-time person out.
Okay. And so there was never, obviously, after the 13th, when you had the meeting, and after the 16th, when Keith provided those proposals to you, you didn't have further negotiations with Keith after that. Is that
We
fair to say?
never had a chance.
Right. Okay. I have nothing further. Thank you.
Redirect.
Just one question. Had you had an opportunity to engage in further negotiation, what would have been your position on behalf of Duke with Keith Caniero?
I don't object to speculation because we don't know what those negotiations would have been. So it's a hypothetical.
It's actually not, because here we already know what was proposed. Mr. Decker's only asking what her response was going to be, so it's not speculation. We don't know what Keith's response would have been to her, but we do know that if you have an answer to that, you can tell us. So that's overruled.
The judge is paying attention and he's making orders and he's listening. Oh my God, it's a Christmas miracle.
Yeah, we already had, like I was doing the homework, what was the business practice in a private foundation and to support what would vendors cost. So I'd done the homework and it was way, way lower than what Square One, what we were paying. And if you want the amount, that's also there with Doris Duke, the cost. So it was half of what we really paid Square One. The new vendor came in with that amount.
Okay.
Just with respect to the way you answered that, I guess I just wanted to ask you question, I may have asked it originally. You weren't unhappy in 2018 and before with the services of Square One, though, correct?
Yeah, not being happy is never on the, I was always good with the services they provided. The cost just did not, it just didn't substantiate with the service versus the cost.
Nothing further.
Recross, if any.
Sit down. You are.
When you're saying that somebody came in for half the cost,
The contract was signed.
that was the new managed service provider.
Yes.
But you didn't sign that contract until April 20th of 2019. Isn't that what you just said when you were testifying on direct?
April of 2019, no, this vendor came in after Square One's business was resolved. The new vendor came the following year. You're talking about a new MSP?
Maybe I misunderstood you. I thought you were testifying when Mr. Decker was first asking you questions. He asked you what happened when the Square One contract terminated in December of 2018. And I thought I heard you say a new MSP came in
Yes.
in April.
Yeah, I didn't say April. Why would it be April if there's no business after December? We had to bring in somebody to take over the services for the foundation.
Yeah, because the company that was providing it, Keith, had passed away and Paul was in jail. So she had to she had to hire a new person. Where are we going with this?
And we had to bring in the service in the beginning of the year because Square One engineers were still working and helping the information being transferred to the new MSP. So the engineers were on site, end of 2018, helping information being transferred to the new vendor.
So the point being, though, that after Keith sent you the proposals, there were contact between you and he.
Right.
And so whatever happened in terms of negotiations with the new MSP, there was no ability for Square One to further participate in those negotiations.
Right.
Fair to say?
Yes.
Okay. Thank you.
Ma'am, you can sit down. Thank you.
Thank you.
Okay. Just watch your step when you're coming down. Prosecutor, you want to call your next witness?
Thank you, Judge. The state calls Steve Weinstein.
Okay.
We are going to get into more financial testimony. This is going to be the accountant. Now, the accountant was there with Keith when they started finding out about the insurance company saying that the premiums had not been paid. We also found out in the state's opening that Paul, to cover up his deception in not paying the premiums, was basically photoshopping the bank statements. So the money would go into an account where Paul had conservatorship or guardianship over, and he was supposed to take that money and pay the life insurance. Well, he was paying himself and then photoshopping the bank statements to say that he had paid Canada Life Insurance Company. Now, they tried to talk to the insurance company, and the insurance company said, we've never been paid. I don't know what you're talking about. We are confused. So we are going to get into more financial stuff, but the state did put this out as a possible motive, so they do have to prove it. So I believe the state rested their case today. I was under the impression that this was going to be a 5 to 7 week trial. So it does seem like they're moving through information much more quickly.
Juror number 15 and 16, just a reminder. Juror number 15 and 16, just a reminder, if you can't hear, you gotta let me know. Just raise your hand, all right? I'm not staring at you for any other reason. I just want to make sure you're good, okay? Sir, can you put your left hand on the Bible, raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Once you're comfortable, can you state your full name for the record? And, yep. Once you're comfortable, state your full name for the record and spell your last name, please.
Stephen Weinstein, Weinstein.
All right, thank you, sir. Prosecutor?
Thank you, Judge. Good morning, Mr. Weinstein.
Good morning.
Where are you employed?
In Teaneck, New Jersey.
And what do you do for a living?
I'm a CPA
A CPA? How long have you done that for?
for over 40 years.
Can you just tell us what your formal education is?
I have a bachelor's in business from George Washington University, a master's in taxation from Pace University, and then my CPA.
I don't know. I feel like my adulthood has been a master's in taxation. But ching.
Now, were you familiar with the Caniero family?
Yes, I was.
Generally speaking, how were you familiar with them?
Probably in the early to mid 80s, I met the uncle, Joe Caniero, who had a small business in Brooklyn. From him, I met his brother, Caesar Caniero, who was the father of Paul, Keith, and Corey, and I got to know them through the uncle.
What type of a relationship did you have with them in terms of, was it business, personal, or something else?
It was business. I mean, occasionally I was invited to some holiday parties, I was invited to Keith's wedding, but overall it was business.
And what type of work, in a general sense, did you do for them?
Well, I was the accountant. In the earlier years, I helped them get going. They had a little space in Brooklyn that his uncle provided for them. I would see them more than once a month, but then as the years went by, they had a bookkeeping staff or whatever. In more recent years, it was pretty much like once a month I'd come in. They had their internal accounting system. I'd review the books, reconciliations, assist with filing of sales taxes, review the payroll taxes. That's what I did.
Okay, so let me just ask you to clarify specifically, did you know Keith Caniero?
Yes, I did.
And how about Paul Caniero? Did you know him?
Yes.
Okay. Can you tell us a little bit about the origin of your employment with them?
Well, again, through the uncle, I met them, and they were remarkable. They started out in Brooklyn. I believe they worked for a company that did marketing for small businesses called The Marketeer. They did the computerization for them.
I'm so glad Richard Dreyfuss made it away from Jaws and became an accountant. You know, he gave up marine biology and decided to become an accountant. This is what I do half the time. I do try to figure out who the witnesses look like, famous people, and make jokes. This is normal Petty Express stuff, but I am taking real notes too.
And then through that, I think there was a young lady who Keith was pretty friendly with. I do not remember her name. They worked for Citibank, and through that, Keith and Paul did work at Citibank, and then from there they went to Republic Bank, and then one of the larger companies at one time was Ogilvy and Mather, if I pronounce it right.
And you may have said it, but what was the nature of the work that you say Keith and Paul did?
Computers, consulting.
Computer consulting. Okay. Now, did they have any businesses together?
Yes, so the first company was called, at the time, J. Martin Consulting, Inc., which later they had a DBA called Square One, where they rendered these computer consulting services.
Okay. And when that company started out, where was that physically located?
In Brooklyn.
In Brooklyn. Okay. Did it ever move anywhere else?
Yes, so from there, as they expanded, at one point they were looking to move in Staten Island, but they ended up moving out to Woodbridge, New Jersey. And then from there, they moved to Homedale, and then from there, they moved to Asbury Park.
Okay. Was there a company called Square One?
That was J. Martin Consulting. The DBA was Square One.
Now, did they own any other businesses together?
Yes, so then when they moved to New Jersey, at the time, it was profitable to sell computer equipment, so they opened up another company called J. Martin Systems, Inc., and they sold equipment, and that was set up. And then as that started, selling equipment wasn't as profitable, they basically just merged it into J. Martin Consulting or Square One, and they would sell equipment basically to the clients that they consulted for. Pretty much that was it. And then later on, a friend of Keith had a company called, I don't remember the name, I think it was EchoStar, but it was a pest control company out of Queens or Long Island. I think it was Queens. It was Queens.
It was EcoStar, not One Star.
And he would often ask them, Keith and Paul, for guidance, and then eventually they formed the company together. So at the end, there was two companies. There was Square One and EchoStar.
And by around the time of, we'll talk about 2017, where specifically were those businesses located?
In Asbury Park.
Okay. Now, did your work for them as an accountant, did that include both businesses?
Yes.
Okay. And did you ever do any work for them more personally in terms of accounting?
Yeah, for the whole family, basically, from the uncle on, I would do their personal tax returns, and for Keith and Paul, I would do their returns, and sometimes for their daughters, and also for their father.
Do you recall who did the bookkeeping for the businesses?
Well, it was various bookkeepers over the years, but in the last number of years, there was Larissa who was there, and then she left, and it was Tiffany Rivera.
Were you familiar with an individual named Ronald Artigas?
Yes, I was.
Who was he?
He was an outside insurance advisor.
Now, of the two businesses, Square One and EcoStar, was there one business that generated a greater profit?
It was Square One, yes.
Before we go any further, let me just ask you, about how long had you known Mr. Caniero for? I'm referring to Paul Caniero.
Probably maybe the late 80s, just like 40 years, could be 35 to 40 years.
Do you see him in the courtroom?
Yes.
Can you please point him out?
Identifies the defendant.
Sir, to your knowledge, what role did each of the brothers play in terms of the day-to-day operations of each business?
Well, over the years it changed, but many years Paul was out, like with Ogilvy and Mather, he was out doing a lot of work there, traveling the world, I guess, my understanding, and Keith was handling internally. But then as the years progressed, it became more of Paul handling the operations and Keith outside of the office.
When you say Keith was outside of the office, what specifically do you mean by that?
He was working from home, or wherever he was, but he was working from home from my knowledge.
Did you know why?
No, he worked from home.
During that time, were you familiar with whether or not Keith had gone back to school for anything?
Yes, he did. He wanted to get his degree and to become much more marketable.
And do you recall approximately what time frame that was?
I can't, but it was definitely in the years that they were in Asbury Park and probably Homedale, I would say. Those years, I don't really know the actual years.
I want to talk a little bit about the businesses. Do you know whether Paul Caniero and his family received any income through the businesses?
Yeah, they had payroll. As Keith's family, they had payroll, health insurance benefits, retirement plan, auto reimbursements, and stuff like that.
Now, to your knowledge, what if any other sources of income did Mr. Caniero, Paul Caniero, receive?
Well, outside of the company, eventually he was receiving disability.
Okay. When you say disability, do you know what he was collecting from, what policies?
Yeah, first it was Social Security, I believe, and then Sun Life.
So there are allegations that Paul kind of transferred his payroll monies to his wife's name so that he could get disability from Social Security. Now, these allegations have been made, but they also haven't been substantiated by this court yet. But there were allegations at the start of this that there were some deceptive practices against the disability claims.
What is Sun Life?
A insurance company. So
Okay. Was that a group policy, an individual, or something?
No, it was an individual policy.
Now, I believe, and correct me if I'm wrong, you indicated that you had prepared some tax returns for the brothers and their families.
Yes.
Did you specifically prepare any taxes for the defendant?
Yes.
Okay. Are you familiar with any debt that he may have owed to the IRS in the time frame of 2017 and 2018?
At a certain point, I believe he fell behind. I think that the disability wasn't being covered with withholdings. And then
Mac Ray 96, I'm of two minds. I do think that we could potentially get a verdict today, but I think it's much more likely that we get one tomorrow, possibly tomorrow afternoon. I think that each and every juror wants to do a good job and wants to thoroughly look at anything that's bothering them. So We could get a verdict today, but I think it's much more likely that it will be mid-morning to possibly evening tomorrow. I also don't know how long this judge is going to let the jury deliberate. Some judges let them go late into the night. Bev always wanted to get out on time, so she would send them a note 30 minutes before, closing. So it's a gamble. I think more likely than not tomorrow, but I could be very wrong. Juries are wild things.
And he went out and he worked out an arrangement with the IRS.
Do you know approximately how much that debt was?
I think, if I recollect, it was around 80,000.
And when you say he worked out an arrangement with the IRS, what are you referring to?
They would give you an installment plan to pay it off.
Now, do you recall where the employees of the businesses held their 401k accounts?
Paychecks, payroll service, they had a 401k department, retirement department.
Now, were you privy to any loans or premature disbursements that Paul Caniero took from his 401k?
In this 401k plan, you're allowed to borrow against your retirement. So, yes, they had loans against the retirement plan.
And do you recall about what year that was?
I don't know for sure.
Now, you indicated that Square One generated the greater profit of the two businesses.
Yes.
How many clients did Square One have by the time frame of 2017, 2018?
It had dwindled quite a bit. The major client at the time was the Duke Foundation, and then some smaller clients other than that.
Approximately how much of Square One's revenue came from the Doris Duke Charitable Foundation?
Over 90% or more.
Now, I want to draw your attention to November 14th of 2018. Do you recall whether or not you spoke with Keith that day?
Yes, we did.
And do you recall how you spoke with him?
Well, we often would speak by phone, sometimes email as well.
Do you recall speaking with him on the phone that day?
Yes.
As a result of that conversation, what, if anything, did you receive from Keith on November 14th?
I believe I received a resume, if it was the right date, because he felt like things were not going as well as he thought. And he asked me if I knew of anybody else he could maybe do computer consulting for.
And as a result of that question that he asked you, what, if anything, did you do with his resume?
I sent it to a client.
Now, during that conversation on November 14th of 2018, what, if any, conversations, or let me ask you this, because I don't want you to tell me anything anyone said, because that's hearsay. But just, did you speak about EcoStar with Keith?
Yeah, it was interesting. There was a large company that was interested in buying EcoStar. So we were talking about that.
So as a result of the conversation that you had with Keith on November 14th, who did you reach out to?
Well, I know I spoke with Paul Enkins, and I know Paul was putting a lot of numbers together on the activity of the company to put together the facts that the company would need to buy, to work out the sale price.
Do you know whether there was a potential buyer for EcoStar?
There was.
Okay, and did you reach out to that potential buyer on the 14th?
I was asked to reach out, yes.
Okay, do you recall whether you received anything from that buyer?
I don't remember the exact person, but I do remember there was conversations on at the purchase price that they were willing to pay, which was about $850,000.
So essentially, was that an offer that they were making?
That was basically an offer.
What, do you recall the name of the company that was making that offer?
I believe it was Terminix.
How did you receive that offer from Terminix?
I don't remember, but a lot of times I did things over the phone, so I don't remember if I received an email. I might have.
As a result of receiving that offer, did you send any emails to Keith and Paul on November 14th?
Yes, about the offer, sure. Yes.
Judge, may I approach?
You can.
I'm showing, I'm going to mark S10 for identification. I'm showing you what's been marked as S10. Do you recognize that?
To some extent.
Is that an email?
This would have been an email.
Okay, and do you see the date of this email?
11/15, right.
Okay.
You need to speak up, sir.
Yes, I'm sorry. 11/15/2018.
Okay, and who is that email between?
from me to Keith and Paul.
And what is the content of the email?
Basically, I was saying to them that this was a tremendous offer, and that they should work towards that. And then I was going to calculate the tax consequences, but I said we should start the process.
Okay, and I'm going to turn to the second page of S10 here. What was the responses from each of the brothers?
Okay.
And it's actually going to start the way it...
Hold at the bottom.
Yeah. Let's start here. And then,
Ms. Wallace, can you do me a favor, just for record purposes, when we're talking about S10, can we talk about the number of pages it is and
Yes,
where
sir.
you're referring to so that the record's clear?
yes.
Thank you.
S10 is 4 pages, is that correct, sir?
Yes.
I'm going to start at the 4th page. Do you see how the email sort of
Yeah.
starts down there and then moves
Okay.
backwards? If you can read that for us.
Okay, so after that, Keith said, let's do it, questioning Paul, I guess to move forward. They said 850.
Who says that they said 850?
Paul to Keith and me, and then, it's a little confusing, but I remember going back and forth with the 850. And then Paul said, thank you. And I asked, oh, do you want me to respond or not?
Okay. So just to clarify, you relayed the offer to them?
Yes.
Okay. And then Keith said, let's do it? And what was Paul's response?
I don't remember the exact response.
I'm going to show you. I'm going to direct your attention.
Oh, don't lick your finger before you touch the paper. Ew. Don't do that. No.
Okay. Do you see on page 3 here?
Yes.
Where it says 11/15/18?
Yes.
And it says that it's from Keith Caniero. You see that?
He said agreed, and then
He said-
let's do it, and he questioned Paul.
Okay. So specifically he said Paul, question
What
mark?
do you think? Right.
And then I'm going to ask you to read on the next page over. It's going to be page 2. Do you see where it says 11/15/18,
Yes,
10:57 p.m.? What was Paul's response here?
He said 850,000.
Okay, and then what was your response?
I will respond that it was 850 and wait for their response.
Okay,
We were going back and forth, right?
sure. And what did Paul say?
Thanks.
Okay, and then did you respond again some point at about 11:01 p.m.?
I said, do you guys want me to respond or not? I wanted to be sure I should go back and forth with them.
Yeah, the judge kind of gave the impression he told the jury to pack their lunches this week. We were going to get stuff done. We were going to work through a lot of things. So, yeah, it was a bit odd. The whole case was odd as hell.
And did you ever receive a response from them?
I don't remember, but, well, there was a response. I think Paul wanted to hold off because he felt we could do better than the 850.
Mr. Weinstein, during the course of your employment with the Caneros, did any of your work for them relate to something called an irrevocable life insurance trust?
Yes.
What was your understanding of that trust as it relates to the work that you performed?
Okay, so that was set up, I guess, in the late 90s, early 2000s, if I remember. It was a life insurance was put into an irrevocable trust, so the life insurance proceeds upon the deceased would not go into the estate and could be used, let's say, for estate taxes or whatever was needed. So when that was set up, a bank account was also set up at the time for the monies to be put into the bank account to then pay the quarterly premiums. And my work involved in this was putting together numbers because when the monies are transferred, whether it's from payroll or actual checks from Keith Caniero, that's considered a gift to the trust. And at the end of the year, I would determine if a gift tax return would have to be prepared based on the amounts of money that would go into the trust to pay the premiums.
Okay, so just a couple of things. So you indicated that that trust was created in the 90s?
Late 90s, early 2000s. I believe it late 90s.
Okay, and just for purposes of clarification, just have you, as in your role as an accountant, have you dealt with irrevocable life insurance trusts
Yes.
before with other clients? Okay. Approximately how many?
Oh, a number, I mean, 10, 20, something.
So you indicated that there was a bank account set up at TD Bank?
Wait, no, share tax tips of the rich and famous with the rest of us. Do we all need an irrevocable trust? I mean, what do you gain by getting that? I feel like I should know these things as a functional adult, and I have no idea what you're talking about. So, could you give us a financial lesson, Richard Dreyfuss?
Yes.
Okay, and that was to pay what?
To pay the life insurance premiums.
Okay, and what was the life insurance company, if you recall?
Canada Life.
How was that TD Bank account funded?
Through payroll from Keith.
Okay.
But there were times over the years where it wasn't from that, it was actual checks that were paid.
Mm-hmm. Now, in about 2017 and 2018, well, let me ask you this. Let me strike that. The irrevocable life insurance trust, were you aware of any trustee that was involved with that?
Yes.
And who was that?
That was Paul Caniero.
Okay. And what was your understanding, based upon the work that you did for that trust, what was your understanding of Paul Caniero's role?
To basically he was in charge of the trust, the monies going in and the monies that would be paid to the insurance company.
Do you remember how often the premiums were due?
Quarterly.
Quarterly? You indicated that you would prepare the yearly or the annual gift tax returns.
Yes.
When you did that, what, if any, paperwork did you have to review?
I needed the bank statements. That's what I needed.
The bank statements from the TD Trust checking
TD
account?
bank account, right.
Okay. How would you get those bank statements?
In the much earlier years, when I went to the client, when I went to square one, they would be there in a file for me. As the years went by, they weren't, and then I would have to request them from Paul.
Okay, so let's talk about the time frame from 2017 to 2018, those years. How would you get the bank statements then?
I would request them by email from Paul.
And would you receive those bank statements from him?
Yes.
And how would you receive them?
He would email them to me.
Do you know whether or not Keith Caniero had access to that TD checking account?
I don't believe he did, because he wasn't the trustee.
Did you ever get the bank statements from Keith during those years?
No, never got them from Keith.
Was there something on the Keith Caniero's life insurance policy called an automatic premium loan provision?
Yes, so when they would fall behind on a premium payment, the life insurance would have a loan provision that would pay the premium, and then interest would accrue on that loan.
Now, aside from your work in terms of preparing the annual gift tax return, what, if any, other work did you do that related to the irrevocable life insurance trust?
Just, putting together the numbers and then preparing the tax return. That was it.
How often would you work on that?
Well, in the more recent years, it was almost annually pretty much that I would do it. Except if Keith reached out and wanted it done sooner.
Okay. And you indicated earlier that you would go to the office, I think you said monthly?
Yes.
Okay, and when you went to the office monthly, your work would involve other things?
I'm not that. It was the other things, right?
Now, I want to draw your attention back to the beginning of about 2017. During that time, what, if any, issues did you become aware of with regard to the irrevocable life insurance trust?
That the money was going in, but the premiums were not being paid.
Okay. And did you or Keith ever look into that together?
Yes, I first reached out to Paul, and then eventually through Keith, I found that they weren't being paid.
When you reached out to Paul, do you recall what, if anything, he had said?
I never got an answer.
Okay. Now, moving forward to April of 2018, what, if any, issues arose with respect to the irrevocable life insurance trust?
Well, in what regard? They fell behind in the premiums, This is April you're talking about?
Yes, I'm going to draw your attention to April of 2018. What, if any, issues arose at that time with regard to the irrevocable life
I
insurance?
believe it was found out through Keith as well that, and Paul, that the monies weren't going to pay the premiums, but in essence, Paul said that for some reason the monies weren't going, they were being used for another reason, and then I found out that he said he was going to pay that money back.
Uh-huh.
Without telling me anything that Keith may have said to you, because it's hearsay, did you have a conversation with just Keith about the situation?
Yes.
What was his demeanor like?
He was very upset about it, disappointed.
Do you recall being copied on any emails from Paul during that time frame of
Your
April?
emails, yes.
April of 2018?
Yeah.
May I approach?
You can.
Showing you what's been marked as S11 for identification. Do you recognize this?
Yes, I do.
And what is this?
These were the payments that didn't go to the premiums, but were paid to school.
Okay, but what is this generally speaking? Like, is this an email? Is it something else? What is this?
This is an email.
And who is it from?
From Paul.
What is the date?
It's April 11, 2018.
The time?
11:01 a.m.
And who is it to?
Keith,
And who is copied?
Ron Artigis, and myself.
And what is the subject of that?
Where did the money go?
Its subject line says what?
Trust reconciliation.
Judge, permission to publish?
Good.
Very interesting.
And I can hear the back table. Thank you.
Now, I do wonder how complicated it is to appoint a new trustee, but you would think at this point, Keith would have made different arrangements. Not victim blaming or shaming. I mean, it's very lovely that maybe he gave his brother a second chance, but I don't think I would have.
Mr. Weinstein, do you see that on your screen? Do you see the email on your screen there? Okay, is that essentially the same email that I just showed you
Yes,
that's
it
been
is.
marked as S11?
Yes.
Yes? Okay, and let's just start at the top there. Can you read that for us?
To all?
Yes.
I had selected the wrong bill pay, some of the payments for 2017 and 2018. They went to a school loan, and no, I don't know. The total amount that was paid out of the trust account to the wrong payee was $25,054.77. With interest, I calculated, gets cut off. Send this amount directly to the principal as soon as the money hits my account. Please double check these numbers and let me know if they match up with your numbers.
Just gonna scroll down a little bit.
So I did some calculations also.
Okay, and what are we looking at down here?
Calculators. Calculation.
The amounts that were paid to the trust in 17 and 18, there was a number of 38,380, but for some reason I calculated 34,209, probably from the bank statement somehow.
Are those your markings on there?
Those are my handwriting.
Okay.
Yes.
So was this an email that you received?
Yes.
Okay, ultimately, did you turn this email over to law enforcement during the investigation?
Yes, it was requested.
Okay, and let's just go down a little bit. What else does it say there?
So these are all the amounts, and it says, sorry for all of the confusion, I've had my head up blank, Paul Caniero.
Okay.
Sir, you can say what it said.
S. Sorry for all the confusion, I've had my head up my ass, Paul Caniero.
And when did you put the markings on each one of the,
Sorry, Judge.
go ahead.
Once I received the email, I went through the numbers.
Okay, so it was back then?
Yes.
Okay. Ms. Wallace?
Thank you, Judge. We can take this one. Do you recall receiving that email?
Yes.
Earlier earlier, we had discussed how you would
Yeah.
receive the TD Trust bank statements from Paul Caniero. Do you recall that?
Yes.
Okay. Now, did you receive any TD Trust bank statements from him for the year 2018?
I believe through September.
Okay, so should I ask you, tell us the months of 2018 that you received.
I received January, all the months from January through September of 18.
Okay. Did you ultimately provide those bank statements to anyone during the course of the pending investigation?
Well, I did. I sent them to Keith.
Now, this is important because, again, for a long time, according to the state, Ron, the insurance guy, the CPA, and Keith could not figure out how the bank kept making this mistake because they were getting statements saying, X amount of dollars being paid to Canada Life Insurance. The statements were agreeing, but the insurance company was saying they weren't getting money. So there are allegations that it wasn't a mistake. He didn't pick the wrong bill to pay and suddenly oopsie doopsie. No, Paul had very expensive taste. We are going to find out.
My email.
Okay.
Or forwarded it to him, however I did at the time. And then this investigation they were requesting.
Okay, and specifically, we'll talk about both of those, but did you provide them to somebody named Detective Bassender from the prosecutor's office?
Yes.
Okay. And you also indicated you forwarded them to Keith?
Yes.
Okay. Do you recall the time frame that you forwarded them to him?
Well, if it was through September, it would have been probably getting them, probably November.
Okay. And what about October through the end of the year? Did you ever
I
receive?
never received any more.
Okay.
Not that I recollect.
I'm going to show you what's marked in, what's been marked as S12. Do you recognize these?
Yes, these are the bank statements that I received for the irrevocable trust.
Okay. And do these go from January to September? I'll let you look at them.
Through September, yes.
Through September, okay. Do you recall how you received those from Mr. Caniero?
Email.
Okay. Judge, permission to publish S12.
Okay.
Heck yeah.
There we go.
Yeah, I mean, she's not the greatest, but I'm just glad to not be listening
On your screen,
to the Uvalde prosecutors.
do you have these in front of you?
Yes, I
These-
do.
Okay. Let's just look at the first page here. What is there on the top where it says ATF Keith Caniero?
Irrevocable trust agreement, Keith Caniero grantor, Paul Caniero trustee.
Okay. And if we can just look at the first page there, the statement period, do you see that?
Yeah.
Okay, and what is the date there?
January 1st through January 31st of 18.
Okay. And then just going down here, we're looking at, so it looks like January 2nd, and then it goes through January 31st. Do you see that?
Yes.
Okay, and there's a check mark on this?
Yes.
Okay, did you put some markings on
That
these?
must have been my check mark, yes.
Okay, do you recall when you did that?
When I got all the statements at one time and I was going through them, yes.
All right, let's look at the first page where it says transaction date, January 2nd. Do you see that?
Yes.
Okay. And it has up at the top either debit, credit, and then it would have the balance, right?
Correct.
Okay, January 2nd, do you see a debit there?
There's a debit for $1,000.
Okay, and Do you see where that's going to?
I don't know the number, but yes, there's an account number or whatever there.
Are the last four digits 3837?
Yes,
Okay. And then you see some credits, right?
yes.
Okay, and where are all those credits from?
Coming from payroll, either from J. Martin Consulting, which was Square One, or Echo Pest Control.
So are these essentially, where we see the credits, is that the payroll that's coming from Keith Canero's?
Yes, it would have been, yes.
Now, you see a couple of more debits on this page for January, is that right?
Mm-hmm, yes.
Okay, so I'm going to draw your attention to January 10th. You see that?
Yes.
Okay, and that's how much?
$500.
And then January 22nd?
$2,500.
Okay, and then it indicates that it's being transferred to where?
3837.
Okay. If we can go to the next date, which would be February. And I'm not going to make you go through every single one of these again.
Thank you.
But I just want to ask you a couple questions. Now, we're looking at February here, and we see some red markings. Do you see that?
Yes.
Whose markings are those?
Those would have been my markings.
Okay, and do you recall what you were doing with those markings?
Trying to check from where it was coming from and where it was going, and then I probably did some type of a reconciliation of the account to make sure it was equaled.
Okay, and then I'm going to draw your attention to February 5th there. Do you see a debit?
$2,200.
And where is that going to?
3837.
And then do you also see some money coming in from the EcoStar and J. Martin companies?
Yes, through the payroll. Yes.
Let's go to the next pay period of March 1st through the 31st. Okay. And again, do you see those red checks there?
Yes.
Or those red marks?
Yes.
Okay. And here there are no debits,
No
right?
debits at all.
Safe drive home.
Let's go to April.
In April, there were all those credits, and then on April 9th, there was a debit for $8,500 to Canada Life.
Okay, now that goes to Canada Life. And is there a check number under there?
There's a check number, yes.
Okay, specifically 99502.
995002, correct.
Now, was that something that you would commonly see? Sometimes you would see monies going to Canada Life?
Yes.
And what was your understanding of what that
Well,
was for?
I mean, because they had fallen behind with the premiums, it wouldn't be a premium payment, so I think, I kind of remember the premium payments being like $7,800 something a quarter. But if it was $8,500, one of the goals Keith was trying to do is to pay down the loan and the interest, so it would be more than that amount.
Understood. Let's move on now to May 1st through May 31st.
Yes.
Do you see that?
Yes. May 1st, $5,000 Canada Life Insurance Company.
Let's stay on that date for a second. So you see May 1st, $5,000 to Canada Life Insurance Company?
Yes.
What's missing under there?
I don't see that check number.
Okay.
This would be when Paul started
move on
using
to June.
Adobe.
Here again, in June, a lot of the credits from the payroll, and then on June 18th, there was a payment to Canada Life Assurance for $7,500, and again, there's no check number on there.
Okay. Now, aside from me bringing your attention to that right now, was that something that you noticed back then?
I noticed Canada Life. That was my goal.
Let's move on to July. I want to draw your attention to July 16th. What do you see there?
$4,500 to Canada Life Assurance Company.
Okay, again, is there a check number?
No.
Let's move on to all.
It seems odd that an accountant, and accountants are usually very persnickety about details, and especially very, detail oriented. You would think it would really bother him that there weren't check numbers to reconcile on these payments that didn't have check numbers when they typically did. I'm not faulting him. I'm not saying if he had caught it sooner, but it just seems interesting that a lot of accountants I know tend to be very persnickety, and if something isn't right in a statement, it glares out at them. Like, I wouldn't notice this, but I would feel like an accountant would? ? If anyone's an accountant?
August. What are we looking at? I'm going to
August,
draw, hold on 1 second,
sorry.
question. I'm going to draw your attention to August 3rd. What do you see there?
$4,000 to
Dreyfus.
Canada Life Assurance Company.
I
No
mean-
check number.
How about August 18th?
Actually, it's August 17th.
I'm sorry, 17th.
$2,500 Canada Life Assurance Company.
No check number?
No check number.
How about August 28th?
Canada Life Assurance Company, no check number for $1,000.
Let's move on now. If we could scroll to September, please. I'm going to draw your attention to September 4th.
$1,000 to Canada Life Assurance Company, no check number.
And how about September 4th again?
$300 to Canada Life Assurance Company,
No check number?
no check.
It also escaped your notice that there were random amounts and like sometimes multiple payments in a month. Why must I be the voice of reason? Something's gone terribly wrong.
Number.
How about, I'm going to draw your attention to September 7th. What are we looking at here?
Canada Life, debit for Canada Life Assurance Company, $1,000, no check number.
And I'm going to draw your attention to 9/17. What are we looking at there?
$1,300 to Canada Life Assurance Company with no check number.
All right, let's move on to October, please. Oh, I'm sorry, there is no October. That's right. My mistake. Okay, because you never got October, right?
Never got it, never received it. Excuse me.
Crinkle. Unintentional court ASMR.
Mr. Weinstein, you indicated that you would do Keith and Paul's and the family's personal tax returns, I think?
Yes.
Okay. During your employment, did Paul Caniero ever disclose or notify you of any fees that he was taking from the trust account as the trustee for tax purposes?
No,
Now, if he was taking a fee, would that be considered taxable income?
that would have been taxable income.
When was the last time you spoke to Keith Caniero?
It was, I believe, the Tuesday night before his death.
Would it have been November 19th?
Yes.
How did you speak to him?
He would email me, we spoke by phone, we must have spoke at least 3 times on the phone that afternoon into the evening.
Without telling us anything that was said, what was just the general topic of the conversation?
Very upset, and just wanted to do something about it.
When you say upset, what specifically about? What was
The
he?
money wasn't going to pay his life insurance again, and he was pretty upset about that.
Now, what, if anything, did you tell Keith during that conversation?
I tried to calm him down, and I tried to tell him it was late. It was like 7 o'clock in the evening. I said, let's, we'll get in touch with TD Bank tomorrow to see what's going on.
Did you ever speak with Keith again?
I never spoke to him again.
And why not?
He was murdered.
When did you learn of that?
That next day, which was Wednesday, I got back to my office, and I got a call from Ron Artigis. He asked me, did you hear what happened? I said no, and he told me, and I was in total shock, and then I tried to reach out to Paul to see what was going on, and never to speak to him.
Now, do you recall speaking with law enforcement in relation to this case?
Yes.
Do you recall when that was about?
So it was in January of 19.
And what, if anything, did you provide them with?
Whatever they asked for. All records from the company, trust information, anything they needed.
Okay. And did you also provide a formal statement?
Yes.
I have nothing further.
Ross?
Now, I think that the defense is going to have a big hurdle with this witness just because, again, it's not really up for argument that he was a terrible trustee, that he was stealing, that he was misappropriating funds, and that he was paying himself out of the funds that his brother trusted him to put in a life insurance policy. So I have really no idea what the hell the defense is going to do with this witness.
So, Mr. Weinstein, good morning. When Ms. Wallace first began talking to you this morning, she was asking how you knew the Caniero family.
Yes.
You've known them for a lengthy period of time.
Yes.
Over 35 years, I guess. Throughout the 2000s and the 2010s, you were doing the Caniero family's tax returns. Is that fair to say?
Yes.
And that would include Keith and his wife Jennifer, Paul and his wife Susan.
Yes.
It would include Corey Caniero?
Not here and there, not consistently, no.
Sometimes.
Sometimes, yes.
You obviously knew the Caneros up until 2018.
Yes.
Did you have contact with members? Did you have contact with members of the Caniero family after 2018?
To some extent, yes.
Business?
I spoke to Corey a few times. Met them at the Asbury Park office to see what was going on with the business, whatever. But that was being handled by, I forget the title, the person was going to handle running the business per se. I think Caesar, the father, was supposed to be the executor, but I think it was going to be run by the attorney. That's kind of what I remember. And
You're talking about the receiver for the business.
receiver, right.
Okay.
And other than that, I spoke with Caesar. I probably did his tax return at least one other time after that. I believe I did a tax return for Corey's wife or girlfriend. I don't know. I don't remember the relationship. But yes.
Okay.
At least 1 year, maybe 2 years.
After 2018. So that would be like 2019 and 2020.
Yeah, something like that.
So Keith and Paul owned EcoStar equally, right?
At a certain point, it was someone else was a third owner, and then they were equal.
That person left sometime in the early 2010s, and then after that, Paul was a 50% owner, Keith was a 50%.
Yes.
Now, throughout the time that you were doing the taxes for the Caniero family, you're also doing the taxes for the businesses.
Not necessarily. I believe that the receiver had an accountant.
Prior to 2018.
Oh, yes, I was. Yeah.
Prior to 2018, you were filing all the tax returns for Square One and for EcoStar.
Correct.
Now, you had access, obviously, to the people who worked at those businesses in case you needed to speak to them for business issues, right? One of them would be Tiffany Rivera, right? She was the office manager.
Yes.
And that was at the Asbury Park office.
Yes.
By the way, obviously both Square One and EcoStar are in the same physical location, right?
Correct.
They're both in Asbury Park.
Correct.
At the same office. Now, there was another woman you mentioned during your direct testimony, Larissa.
Glorioso, yes.
She was a bookkeeper there.
She was there for a while, but she left way before this, I believe. I don't know. I think she was there through 16 or 17. I don't remember when she left exactly.
You said that you would stop by the office about once a month?
So this case is Paul Caniero. He is being accused of taking the life of his brother, his brother's wife, and his brother's 2 children. Now, it does involve children, and unfortunately, it's not an easy death. So I will try to cue you guys up for that. Now, Paul and his brother Keith were co-owners in one business, and then Keith owned 90% of another business, and Paul had 10% interest in that business. So technically, they kind of co-owned 2 businesses together. Now, The evening before Keith and the entire family was killed, Keith found out that, having realized that the company that Keith owned 90% of was going to lose their majority profitable client, and getting an offer on the business that they co-owned 50-50, Keith was looking to kind of switch things up. He was going back to school. He wanted to improve his marketability, and he was wanting to also detach financially from Paul. There had been some issues with Paul. Keith created as a sort of, safety net for his family, an irrevocable trust that was funded by a whole life insurance policy for $3 million. Since it was a trust, Keith had to appoint someone to be the trustee. Keith appointed Paul at the time he trusted Paul. Well, it turns out Paul was not paying the premiums. Now, this happened on 2 occasions. On the first occasion, Paul came up with a bunch of reasons why the money was sent to a wrong bill, and he said he was going to pay it back to the trust. And okay, fine. All of that money got reconciled. They made up. But in November, again, Canada Life Insurance Policy or insurance company comes back and says, we are again not getting payments. Now, this is the second witness on the stand. He was the decedent and the defendants, so Keith and Paul's and the Caniero family's accountant. Now, he also oversaw the trust, and Paul, to his, infinite Chandler Halderson Adobe skills, was actually sending statements from the trust bank account that had Canada, life insurance payments being made. So the day before the Caniero family is found dead in a burning home, Keith confronts his brother saying, hey, I'm getting told by the life insurance company yet again that they're not getting payments. And he was really pissed off, and we are going to get a chance to see Keith on the phone trying to get Paul to explain what the hell has happened to all this money. Now, the state has put out there that the total amount of the money that Paul squandered from the trust was $78,000. Now, this happens. Keith basically gives Paul an ultimatum. He's angry. He hasn't heard back from Paul. He goes to bed. Now, the state will allege that they have Ring doorbell camera of Paul Caniero leaving his house at 2 o'clock in the morning in a white Porsche Macan, which I think is a fancy dancy car. I don't know cars, but a very noticeable white car. Now, at around 2:50, and the brothers only live about 20 minutes away from each other. Around 2:50, the power and generator are cut off at Keith Caniero's house. Now, Keith, being the man of the house and the protector, he goes out to see what the hell has happened to the power. The Canieros at Keith's house had both interior and exterior security cameras and things like that. So around 4-ish, 3-ish, 3:50-ish a.m., Keith texts Paul that the generator and the power is out and he's going to go check the outside. Now, someone was waiting outside by the generator and the electric meter. The electric meter had been completely ripped out of the ground and the generator had been put off. Keith is confronted and shot 5 times. Now, according to the state, Paul then goes into the house while it's dark and attacks his sister-in-law, stabs and shoots her. Both, sadly and horrifyingly, both the parents were dead almost instantly. Now then, the state then alleges that Paul tracks down his, I believe, 10-year-old nephew and takes his life by stabbing, and also his niece, who was 6, I believe. Now, sadly and horrifyingly, and possibly the only time that the state really used emotion in their opening was when she explained that we will be hearing from the medical examiner that the children had signs of smoke inhalation. So they were still alive when, after attacking all of the family, he cut the security lines and started a slow burning fire in a cedar closet. Now, this is the state's kind of theory and what they hope they will prove. He then drives home, and we will see doorbell camera footage of him arriving home around 5 a.m. to his home. And coincidentally enough, if you would believe it, a fire starts in the basement of Paul Caniero's home, near the gas meter. Well, police are called out because it looks like a very intentional fire. There are little puddles of gas kind of going around to the basement, and a melted gas can very close to the Porsche Macan that has obvious signs of smoke and fire damage. Now, the police are able to, well, first, Paul and his family are entirely able to get themselves out. They are actually waiting on the side of the road when the police come in and the fire people come in to secure the scene. Now, they were able to quickly take care of the fire and not let the gas can or the natural gas line go up. And because they were so quick on catching this fire, they realized that there was a pile of debris underneath this window well, kind of at the origin of where this fire was started. So the police start looking through this, and they find black nitrite gloves. They find, I believe, a t-shirt and a pair of pants that have the niece and nephew's blood on them. And that's kind of why they zeroed in on Paul. Now, if you're the defense, well, the state had tunnel vision, and they zeroed in on Paul right away, and they didn't look at the other brother. And I contend that just like you don't continue to look at for your remote once you found it, oh, and thank you, nitrile. I was like, nitrite, you're right. It's been a long day. I'm probably going to go to cross with him. I know Andrea Burkhart is still live, but I don't know how much longer I'm going to be able to hold on, because holy cow, this is a long day. I'm trying to make it at least until when we generally end.
No, at that point in time, yes.
And you would be there, obviously, to check in on.
So a lot of this case is going to be financial, at least in the beginning, as we the state doesn't have to give a motive, but it's very clear, at least if you believe the state's theory, that the loss of the, access to the trust and the possible, repercussions of, again, embezzling funds could be a possible motive.
On bank reconciliations and, there were sales tax filings that needed to get done. Financially, things weren't great, so they were kind of falling behind, so we were trying to work out arrangements with New York State or New Jersey. But we would work on that. I would review the payroll and payroll taxes, correspondence, all that kind of stuff, yes.
Mm-hmm. And you'd spend probably about half a day there, I'd imagine?
Probably like that, yeah.
When you were there, that on those once-a-month occasions, you would see Paul there?
Not all the time, but he was there more when they were starting to look to sell EchoStar. He was there when I don't know how often he was there, except if I was there and he was there. he was working on the numbers for this potential purchase or sale of the company.
Okay. Your perspective on that time period, the sale of EcoStar, would be that Paul was trying to put numbers together, projecting that...
Well, I mean, that's basically the defense's case. My client is not stupid enough to have left all this evidence. And have you considered that the state completely ignored this other brother who didn't seem to really interact with Keith on the level that Paul did? So it's a crazy case. Yeah, but basically the defense is my client isn't a moron, and you poors don't understand this, but Paul, to Paul and the rest of the rich people, $78,000 of embezzlement is chump change.
Revenue in that company was going to increase. And therefore, the sales value, sales price of that company should also increase.
Possibly, yes.
And Paul wanted to wait on that increase in revenue so that they could get a bigger sales price, right?
They thought they could do better than $850, correct.
And those were based on some of the numbers and the projections he was putting together.
Correct.
You saw his projections and his numbers, right? At the time.
You have to say yes or no.
Yeah, I'm sorry. Yes.
And, you...
If you are unwrapping a lozenge, if you are unwrapping a cough drop of any kind, could you possibly turn off your mic for the love of Cheetos?
I don't know if I agreed or disagreed. It was a question of, at the time, $850 was, to me, an amazing number that this company could get. That Terminix wanted it, and from what I understood from other information was that they were looking to buy up a lot of small companies. So my feeling was, it's not really a question of agreeing or disagreeing. My feeling was, you got this number, maybe they're going to go somewhere else. Take the money and move ahead. Who knows if they'll go to another company and offer them the $850. So that's just my feeling.
Sure.
So it's not a question of agreeing or disagreeing. It could have gone up, but as what happened in my discussion, they took the offer off the table, and at one point it went down to $750. So that was my feeling.
Well,
it's not right or wrong. It's just.
I think it's this, though, and tell me if I'm wrong. This wasn't just a conversation that you and Keith and Paul were having in 1 or 2 days in November. This conversation had been going on
for a few months.
For months, right?
A few months, not a lot of months, a few months.
And in August of 2018, you're talking to...
Holy crap, you mosey more than a Georgia lawyer. You're supposed to be from New England. I expected you to have some giddy up in your step. What the hell, dude? Could we not wiffle waffle? Could we find in the nebulous fuck wherever your point is? For the love of God. Okay. Sorry. I would just he is like, have y'all ever watched Timcast? He is like Ian Crossland. And look, I am sure Ian is a really nice guy, but Ian can never find in the nebulous F where the topic is. And I feel like that with this person. Which, if I'm in the mood to hear about crazy and graphene, I'm there for you, Ian. Sometimes you make a point. But if you're a lawyer, I'm going to need you to not prick my ADHD.
Paul and to Keith, and you're saying that in terms of the offer going up, you're telling Keith that time is on your side.
Pastor.
Are you not? You don't remember? Can I show you something?
Yeah, remind me.
Okay. Judge, I'm going to approach with D10.
D10.
show you this. So this is an email, okay? And I'm just going to direct your attention to who it's from, who it's to.
Oh, I remember this, yeah, sure. I remember this, yes.
So,
I mean, you always keep things close to the vest when you're making a deal. I mean, that's... Sure. You don't tell somebody what the price is going to be, because that's the price.
right. And you're saying in this, we figure that time's on our side. Company keeps improving in the right direction, and the price we don't...
But then they came back at $750, so maybe the time wasn't on our side.
This is August the 20th. This is
Okay, why the hell are we evaluating the accountant and business management of a man who embezzled from children? I really don't give a crap. Terminix didn't end up buying them, or Paul didn't profit, so who the hell cares? I just like things to make sense and to fit a purpose, and at this point, massaging Paul's ego that he's a good businessman, it serves no purpose.
August 20th to 2018, right?
Yeah.
Okay, hold on. You just showed him a document. He hasn't identified it. I don't know what it is. I don't know who the to and from are. I don't know what you started reading from it. I need more information from that before we continue.
This is an email from Steve Weinstein to Keith Caniero, dated August 28th, 2018.
Now, spoiler alert, I have been watching little snippets of this, and this is just the start of the judge being effing done with the defense. So be on the lookout for our judge to turn into Red Foreman and want to shove a boot up the defense's behind. That's kind of why I wanted to cover this trial. I kept getting little pop-ups like, judge again expresses frustration with Caniero defense. So I'm here for it. I'm not here for another trial with children involved, unfortunately, but a judge getting pissed off righteously, and I think he's going to be more of a Borowski than a Schrader. So I'm here for a Borowski kind of moment.
At 3:41 and 16 seconds in the afternoon.
What was the date?
August 28th, 2018.
I haven't been watching closely enough to know where... And we still have to kill time.
And you're saying you remember that?
I don't, I mean, now that I see it, I
For
remember,
verdict.
but I don't remember that.
All right. Go ahead. Now you can continue. Now I understand what you're talking about. And I hope jurors understand where we are? Okay, great.
So-
Go ahead.
Oh my God, if you namaste pose one more time, like, sir, you realize you are just exaggerating stereotypes at this time of the manlit, man bun yoga instructor, beta male. I mean, you might as well be wearing a hot fuchsia suit at this point. Like, Neil Druckmann is your hero, possibly, allegedly. Did you like The Last of Us 2? I feel like, yes, he likes Neil Druckmann. And well, Starfleet Academy, he's a big fan.
Why don't I ask a question?
sorry.
Okay, that's fine. Then, actually, right above that, in this same document, we see that Keith responds to you.
Should I read it?
Well, do you remember what he told you?
I don't remember that until I read this now. I didn't remember that.
Okay. Well, then I would ask you to read it to yourself then.
You can.
Uh-oh, sidebar.
Sir, don't say
sidebar.
anything. Can
Someone's gonna get yelled at. Paul, put your hand down. No one cares. Also, can we talk about putting your defendant in the sweater shirt combo? Because it makes your client look like he's not safe around schools, in my opinion. He would look much better in a suit. I think he looks like he's trying to be Bill Cosby when we weren't afraid of that. And I just don't like the sweater look. Yeah, that's Paul. He looks a little like he's going to tell you about the good news of Jesus Christ of Latter-day Saints. And no offense to anyone LDS, but he does kind of look like a missionary to me. It might be the white shirt. And let me state on the record that everyone I've met that has practiced the LDS faith has been an awesome person, just trying to human like the rest of us. Okay, I think I've officially gotten myself off of the hate list from, well, Utah. So I might be allowed in. It just looks like they're trying to make him look like an 8-year-old, and he's in his early 60s, I believe. It's just very not age appropriate, and I don't know. They're making me watch Paul. I'm gonna make fun of him.
I apologize. So, you did have a chance to read the rest of this document,
Yes,
right?
yes.
Now, without telling us what was said by anybody other than yourself, okay? This is a back and forth email between you and Keith about the potential sale of EcoStar, right? And specifically, we're talking about August of 2018.
Correct.
And this is several months before the November conversation that you testified with the prosecutor about, right?
Yes, August is before November. Thank you, defense attorney. You're doing great. Tomorrow we're going to work on colors.
August, yes, same year, yes.
And so, and obviously, your impression of this conversation, this is back in August, is that it's not just Paul at that point in time who's hopeful for a higher number. It's you too, right? And it's Keith too.
Yes.
And
Come on, Starshine, let's go.
And is it fair to say that you had other communications with Keith and with Paul on the issue of the sale between August and November?
It's fair to say I don't remember them, but it's fair to say.
Just to refresh your recollection on that issue, Judge, I would like to approach with D5.
D5? Okay.
And just for record purposes.
Someone sink someone's battleship already. I mean, wait, wrong game.
This is an email, right? Mm-hmm. Is that yes?
Say yes or no?
Yes, sorry.
And is it an email from Keith Caniero?
Keith to me.
Okay. And the date of this is September 13th of 2018?
Correct.
Okay. Could I just have you read this to yourself?
To myself.
Yes.
He's like, look at me, I'm doing good. I'm following all the steps. I'm a good lawyer. Also, could you button your jacket when you're standing up? Hippie.
Okay. One point of being here that there were additional conversations that you and Keith had about this sale between August and November, right? Is that yes?
You already
Yes.
asked that.
And those conversations were not definitively about Keith accepting an offer of $850,000.
Well, based on that email I just read, no. It's just conceptually thinking about it, planning ahead, strategizing.
Okay. Keith is thinking he might accept that offer.
Correct.
But he's not saying. In the November email that the prosecutor showed you, Keith is saying, let's do it. Right?
Correct.
But prior to then, those statements like that were not being made by Keith. Fair to say?
Fair to say.
Okay. Because everybody is considering what their options are, right?
Of course, yes.
And that would only make sense for everybody to do, right?
Correct.
But when we get to November, Keith is concerned that his contract with the Duke estate might not renew.
Correct.
And that's when Keith is really motivated to sell EcoStar.
Correct.
And that's when he's on board to take the price of $750 that they're offering.
I don't remember that. I don't remember that. Is it in it? I know they dropped the price to $750.
Yeah. This is, yeah, it's pretty speculative.
But EcoStar was...
Okay, I know it's my ADHD, but could the bailiff get his uniform any tighter? Now, I mean, he's buff and all that, but I mean, that just has to be uncomfortable. That looks so skin tight. So I'm not making fun of him. I'm just like, oh, that just looks so uncomfy. Because it's all cutting into his like arm meat. Ugh. Look, I'm just saying I don't like stuff all tight and pinchy.
A 50-50 company between Keith and Paul, like you said.
Correct.
And that means that Keith and Paul are both going to have to be on board with a sale,
Of course.
in order for it to take place.
Correct.
Paul, you saw in that email
Those are some Gloria Vanderbilt jeans. My mom told me about having jeans so tight in the 80s and 70s that you would lay down and use a wire hanger. I mean, before your mom told you no more. And then you'd like cinch yourself into them and hope you never had to unbutton them. Now, that seems to be a trend that is still on point for the women of size in my Walmart. So I don't think it ever died.
prosecutor showed you. They come back at $750. You say this is a tremendous offer. Paul says they said $850.
No, I think I said $850 was a tremendous offer. And then when we held up, then it became $750.
Could I have yours?
Defense, possibly read the emails before you try to introduce them as evidence. Oh no, I'm running into that problem. I am a medium everywhere except for my boobular region, and then it's no.
I'm sorry. So this is S10. This is you saying.
We gotta start here. They said 850.
You guys can't have a conversation
I'm not,
amongst
I'm just
yourselves.
talking to myself.
Okay, all right.
I love that the lawyer is using the witness as his phone a friend. Oh my God, he wants to be a millionaire. What is going on here? Did you happen to look at any of the evidence before you came into work today, Cletus?
I think it's based on the 850. Sorry, it's confusing emails.
Okay, but anyway, the point is, they come back, right? Keith wants to take the offer, right? And Paul says they said 850, right?
Correct.
Meaning They're not offering 850 now. They said 850.
Correct.
Right? Meaning also that Keith wanted to take the 750 at that point in time.
Maybe, I don't remember that, but possibly.
Okay. Judge, could I just approach with S9?
Sure.
You gave a statement to the state, right? You gave a statement to the police about this case,
Yes,
correct?
yes.
And you know that that was documented?
Is this River's first, River Tristan Starshine's first trial? Because I'm really not trying to dog on him. I am irritated because he seems to be confused as to what he's doing. But he seems kind of unused to the procedural kind of aspects of this. Now, Paul Caniero did start off with private attorneys at the start of this case, but these are public defenders, and this is not to dog on public defenders. Public defenders are generally very good and have the kind of procedural stuff down. He looks kind of confused that he has to explain and call out for the record what email this is, where they're looking. He seems really confused, and typically your public defenders are in courts more often than nearly any other criminal attorney or criminal defense attorney, because they're always defending people. There's always people that can't pay. So his kind of confusion makes me wonder if this is like one of his first trials, and just observationally, he seems to not be with it.
Okay.
Okay. So I'm going to show you this. This is S9. It says Statement of Stephen Weinstein at the top.
Correct.
Okay. I'll just have you flip through this and see if you recognize it.
Oh, about the 850?
Well, we'll get there. We'll get there. But just take a look at the last page.
Oh, that's it.
See your signature on that?
Frodo got to Mount Doom faster than we're getting to your point. Could we get there before, Peter Jackson remakes The Hobbit again?
Yes.
Okay. So flip back, if you could, to page 4.
Sir, what's the date of the statement?
This is January 24th, 2019.
Yeah.
How many pages is the statement, sir?
The page...
Let him answer.
9 pages.
And did you sign the last page?
Yes, sir.
Okay. Do you recognize it?
I recognize my signature, yes.
Do you recognize the entire document?
Yes, I do.
How do you recognize it?
Oh my God. Is the judge having to lay foundation for this lawyer? Tristan, were you awake during class? Sir, I say this as a twice college dropout, and proudly so, because I don't have any loans. I paid mine off. Though I do feel like, if I didn't get the degree, we should have, called it even. Anyhoozle. Sir, I say this as a comfortable non-lawyer, but do you know what you're supposed to be doing here?
I remember these words, and I remember... I remember...
So is that the statement you gave to the police?
Yes.
Any doubt in your mind?
No.
Okay. Now go ahead. Whatever page you
Tristan, stop standing there looking like a moron. The judge is getting pissed.
want. Mr. Murray.
Okay, so now that you've read that, the detective asked you, can you tell us who the offer was from and how much it was for? And that's on line 22 of page 4. You see that, right?
It's page 4. Oh, yes.
Okay. And then you answer that question on line 24 of the same page.
Correct.
Right? And your answer is, the offer was for roughly $850,000.
Correct.
But that was reduced to $750,000 by terminus.
Correct.
Okay. Okay.
Done.
Could I have that?
Yes.
Thank you.
Okay, so I asked ChatGPT, Is the defense for Paul Caniero new to law? Because that's basically all I could figure out for the cluster F that is this questioning. Now, Monica, the one that did the opening statement, is actually listed as Assistant Deputy Public Defender. Andy Murray, the one I've been yelling and calling Cletus and Tristan, is also from the Public Defender's Office, but it doesn't say how many years he has. So they're not brand new to the law, and they have some experience. Well, this is, comforting. Paul, you did a great job. How you feeling? Dear Lord Tristan, go faster.
I would be correct to say, though, that wherever Keith was, when you would go to the office, the Asbury Park office on a monthly basis,
Yes,
Keith would not be there.
correct.
He was never there when you were there.
I would never say never, but not a lot of times when I was there. Correct.
You would see Paul far more often than you would see Keith.
More often than Keith, correct.
No wonder this trial was going to take 5 to 7 weeks. Holy God. Find a point, Cletus.
Trust account that you testified. You would have to prepare the state and gift tax forms for that account potentially every year.
Potentially, yes.
Yes, or quarterly,
depending on whether there were contributions, I guess, above
Exceeding that amount for that year. I don't remember what it was. It's probably around $10,000 or $11,000.
In order to do that, you would need documents about the trust account.
Correct.
And
welcome, Squid Pro Quo Raiders. We are on, I think, the second witness of the Paul Caniero case. This is a case where the defendant, Paul Caniero, has been accused of the quadruple homicide of not only his brother, but his brother's wife and their 2 children. But we are also on verdict watch for the Uvalde case. Now, I'm probably going to go for a little bit longer, maybe an hour longer. I don't know in regards to the Uvalde case as far as what exactly his rules and the courtroom rules are as far as the lateness that the jury can stay there, and kind of his general rule. Like, we knew that Bev wasn't going to let anyone stay late, but I don't know about this judge, so I'm trying to at least hang on until we would typically end. Knowing my luck, I will end a stream, I will go try to eat some food, and that's when the verdict will come back.
you received those, you said initially, from...
The defense... Oh, crap, I'm a professional. The defense in this trial is working every one of my ADHD nerves because he, like Ian Crossland, if you've ever watched Timcast, can barely find a point with a map and Mr. Tumnus right next to him to show him how to get into Narnia. So he might be testing the Jesus in me, and I don't have a whole lot left. Now, if you want something to be rage-inducing, I would recommend that you check out the rebuttal closing statement from the state in the Uvalde case, because never before have I seen a more unhinged and ridiculous woman. What's Narnia? It's that imaginary land in the Lion, the Witch, and the Wardrobe. So yeah, I'm basically just waiting until the end of the day. We're closing in on 4 hours on the deliberation clock. I don't foresee the verdict coming in tonight as much as I joke, just because of the amount of information and evidence. There were over 1,000 pieces of evidence in the Uvalde case, and I think the jury's going to need to take some time to kind of process all of that and, talk about all the kind of horrible things that they had to see. I think that the defense did pretty good, and the state was just horrific, as always. But I did not think that the lady lawyer on rebuttal was going to be as bad as she was. And if you want to see something super de-duper snarktastic, I will be making a clip of this. But the defense actually used the state's opening in their closing statement to prove that they were full of cockapoo-poo. So there you go. But now we are on to this case. Now, look, I'm going to tell you guys, the defense in this case could not find a question in a wet paper bag. And they're annoying the crap out of not only me, but the judge. The reason I kind of picked this case, I wasn't itching for another case that horribly involves children, but I chose this case because every other day I'm getting pop-ups from Court TV as we're doing Uvalde. Judge pissed at defense. Judge ticked at defense. Judge exasperated with defense. Now, Ponytail Lawyer seems to be either relatively new at this, because he doesn't seem to know like the standard operating procedure for how to, present a document, how to put the information into the record. He seems to have wandered in here and like, I can play a lawyer.
Going to square one physically.
Correct.
And then later by getting them from Paul.
Correct.
When the prosecutor showed you those documents before with your check marks on them,
Yes.
those were bank records, right?
Correct.
And they were the bank records from the trust account.
Correct.
And those were records that you had reconciled.
Correct.
And this is something that you had done for years at that point, certainly since 2010 until 2017, you were engaged in that activity, right?
Correct.
What we saw...
How close is New Jersey to 3 Mile Island? Where was he during the 3 Mile Island incident? I feel like we need questions answered.
In those records were debits from the trust account to an account that you said you didn't know what it was, but the last four numbers were 3837.
Correct.
Right. Now, those debits would have been on those records when you originally reconciled, right?
Correct.
And you were aware then that in these prior years, in 2013, 14, 15, 16, that there were debits on the trust account.
Correct.
That were not going to the insurance company.
Okay.
Right?
Yes.
I mean,
So I was aware Paul was stealing before we caught him really stealing. I don't know where you're going with this defense. I mean, it's a bold strategy, but let's see where he goes with this.
that's
Correct.
Is that fair to say?
Fair to say.
So, in all these prior years, by having access to these trust account documents, you could see that there was money leaving the trust account, going into an account that you didn't know, right?
At the time, correct.
But that wasn't the Canada Life policy.
Correct.
Sunshine, could you get to
In
a
prior
point?
years as well, not only were there debits from the trust account to an account ending in 3837, there were also debits
Oh, wait. Okay.
to an account.
One sec. Whoever is
ending
crinkling the wrapper.
1361. Do you recall that?
Whoever's crinkling that wrapper next to the microphone is getting sent to Greenland. Oh crap, where did I put it? Doo-doo. No, where did it go? Oh, it's behind there. Sorry, I'm talking to myself. It looks like we are back in the courtroom, so I'm getting... All right.
Two will soon learn his fate.
Now, officials say that the lives of 19 students and 2 teachers, they were taken that day after police waited more than an hour to intervene. And Gonzalez faces up to 58 years in prison if he's convicted on all of the counts against him.
Yes, and we see they've been out 3 hours, 47 minutes. A perfect time to bring in Court TV crime and justice correspondent Matt Johnson. Thank you for being with us as always, Matt. You've been tracking this trial closely. What have we heard from that jury, Matt?
Judge Ashley, Julia, nice to see you both. So it's been an emotional trial at times with disturbing graphic evidence that we haven't been able to show you, but the jury has seen it. And it appears that this jury is focused on some...
What the hell happened to Ryan Seacrest? Good God.
Some of that key evidence in this case. We have 2 jury questions so far. Here they are. The jury asked for an easel with markers and a witness list in order of their testimony and a list of the evidence. The second question, not too much longer later this afternoon, the jury asked for a monitor or laptop. Why is that telling? Well, the jury listened to testimony for 10 days during this 11-day trial. The jury watched disturbing body camera video. They watched graphic crime scene photos on monitors and heard from 38 witnesses. The witnesses included investigators, survivors of the shooting, and family members of the victims, many who were emotional on the stand. Adrian Gonzalez is the former school resource officer charged with 29 counts child endangerment, and he faces up to 58 years behind bars if convicted. All parties being instructed even right now by the judge to be within 15 minutes of that courtroom. No one's going to wait if there is a question or a verdict in this case.
Now we know the last thing this jury heard were those closing arguments. What stood out to you about them?
Well, first off, they were very powerful closing arguments.
No. The state's rebuttal argument was pure insanity. Okay, so it looks like we are in for the long haul, y'all. I am going to be texting Mr. Mo and seeing if he can put a pizza in for me, because we are, we're here. They are giving, sorry, I really haven't eaten all day, which is not good because I am an ADHDer who can forget to eat, which is really, really bad for you. Like really bad. You're not supposed to do that. Ta-da. Sorry. Can't, no, and I refuse to make myself rewatch her closing statements. But we are going to go back. I thought they teased me. Court TV, you absolute butt monkey
Arguments
teases.
from both sides in that Texas courtroom this morning. Prosecutors said that Gonzalez failed to act as an officer and save lives, focusing on saving the children, while his defense team told the jury that the state was looking for a scapegoat, not looking at any of the other officers' actions in the same way. Both sides telling the jury that the trial will send a strong message to officers nationwide, but which message depends on the verdict outcome. Take a listen.
This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. That when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty.
The problem is the message that will be sent is be Officer Hill. Set up perimeter even though you're not asked to set up perimeter. Don't go in. Don't go into the eye of the storm. Don't even wait 30 minutes. Stand back. Don't do anything because I don't want to be sitting in that chair. That's the message that will be sent.
Nearly 3.5 years to get to this point in time. Emotions, we have to say, are running.
I will keep an eye on Court TV, so you don't have to see any of this. But with the judge not letting people go very far away, it does seem like he intends to let them deliberate into the evening hours.
Now that you tell me, but I don't remember.
I would like to show you the document and see if you recognize it.
Who is unwrapping the world's most annoying and largest Werther original? For the love of God, turn off your mic. Have a little bit of mic courtesy.
Judge, this is D32.
D32, okay.
Granny Smith, there have been two questions that the jury has sent. They wanted a whiteboard with markers and a list of the witnesses and the evidence. Now, also, they wanted a laptop so they could possibly watch videos, and the judge has told everyone involved in the case to not leave any farther than 15 minutes from the courthouse in case there are more questions. Yeah, that's Nosy Rosie is right. The judge did told them to plan on full days, which at a minimum would be 5:30 Texas time, so 6:30 my time, and it is 5 o'clock my time. So about an hour. Now, it wouldn't shock me if the judge is willing to let them deliberate later. In the case of that, I will stay on as long as humanly possible, but then if it goes past 8, I get up at 4 o'clock in the morning. I turn into a potato every night. I don't plan to stay up. So
This is an email, okay? This email, we'll just go to the top, okay?
JKD Buck, this man is honest to God if Ian Crossland from Timcast became a lawyer. It is the vibe. I'm half expecting him to talk about graphene and communism or something.
Sure, go ahead. Does it appear to be at the top from Keith Caniero?
Yes.
Does it appear to be to you?
Yes.
Does it appear to be dated May 11th, 2017?
Yes.
Flipping through, oh, I should ask you, do you have an independent recollection of receiving that particular email?
I don't.
Okay. I just want you to flip through to page 3, okay? And you can just look at that yourself and flip through page 3 and 4 of that document and tell me if you've seen that before.
Oh, thank you so much, Heather May. I appreciate it. I appreciate your service at a public school, and I will be continuing to cover in about an hour to an hour and a half. I don't know where I'm going to actually, but as I can, I will be recording me reading through the DOJ report on Uvalde, the Texas Congress report or House report, and also the Uvalde city report. I will be adding those over time to my playlist for Uvalde. I really do want to see if anything, was actually done to correct some of this. I am really quite horrified that there might be more schools that are very lackadaisical with their security. Whether it's due to being inconvenient for the, teachers, or it's a lack of funding. And I would much rather that we didn't do a trial and we, spent the resources going into schools and making sure that they have a workable security system that the teachers won't bypass. But that would be logical. And when have we ever done that as a species? Interesting Newport Marina. Thank you so much.
I don't remember ever seeing this. I don't. I do not remember seeing this. I might have, but I don't remember right now.
Okay. Do you have any reason to dispute the fact that this email was sent to you?
No reason to dispute it.
Do you have any reason to dispute the fact that when this email was sent to you, it contained an attachment?
Okay, yes, I don't remember, but no reason to dispute.
Have any reason then to dispute the fact that in years prior to 2018, withdrawals from that trust account were made not just to an account ending 3837, but to other bank accounts as well?
Possibly. Well, you just showed me that, so I'd have to say yes, but I don't remember that.
You don't remember?
Correct.
Do you remember an account, the last 4 numbers of which are 1361, that you encountered in any of your dealings with Square One or the Caneros?
You asked me for 4 digits of an account number? I mean, that's pretty difficult. And you're talking about 7, 8 years later? It kind of sounds familiar, but I can't remember that.
Okay. If you were to see a record connected with that account, could you tell me, would it refresh your recollection as to whether you handled that in that capacity in the past?
Yes.
Okay.
Let Kim Kardashian answer the question or ask the questions.
This is D33.
D33, okay.
And this is a TD Bank record.
May I just see that, please?
Yeah, sure.
And this is what I'm talking about. Is he new? He doesn't know to show it to the state. He doesn't know kind of procedurally what he's doing. And yet he passed the bar in 2008. Sir, let me explain to you the differences between you and me. In 2008, you graduated from law school. In 2008, I had my second child, and now she's graduating with honors from high school. Now, I'm not saying, because it's apples to oranges, but I'm just saying, what is it you do here?
You want me to see the debit or credit on this?
No, I'm just asking you to see if you recognize the account
So
itself.
it's J. Martin Systems before they closed it in 14.
Okay. So this is an old operating account for Square One.
Okay.
Is that fair?
That's fair.
And it ends, this account number ends in 1361.
Correct.
And this is a closed account, but you don't know when it closed.
When the company closed, I don't remember. I don't remember now when J. Martin Systems was dissolved, but that company was closed, correct?
But this particular account, you don't know when this account was closed.
No.
If there were withdrawals from the trust account to the company account in prior years, we imagine that those would have been available for you to see when you did the trust reconciliation.
Correct.
And obviously, if you saw those and didn't mention anything to Keith about them, tell me if I'm wrong, I'd imagine that would either be because you didn't notice them, or because if you did, you didn't think that they were a big deal.
No, everything's a big deal, but right now...
Yeah, accounting's kind of one of those jobs where it's detail-oriented. You can't kind of wing it like law. I'm looking at you, son.
Pulling things out of context, and I don't know the actions I would have taken back then on these items. I would have definitely not classified them as payments to the Canada Life Company, and I might have spoken to Paul, I might have spoken to Keith. I don't remember what I did at this point. That's 2014, for example. And I also, as I said earlier, when things were not financially in good shape as they were, the premiums were not getting paid, and money was going from all the different companies to cover things. So I don't remember the actions that I would have taken. So nothing is unimportant, but now it's out of context, I can't remember.
Okay, well, you bring up a good point. So let's take a step back.
I have never hated yoga more than right at this moment, and this affected prick doing this prayer pose stand. I don't know why, but it bothers the ever-living snot out of me today. Now, tomorrow might be different. I might have my faith in humanity restored. Thank you.
You said money was going different places from the two companies back and forth, right? It wasn't just from the companies, though. It was, money was coming from Keith's personal account into the company, right? And coming from the company into Keith's personal account.
What time frame are we talking?
This is, I would say, and I'll ask the witness judge, but I would imagine this is really throughout the 2010s that this is going on.
Could I respond?
Yes.
Okay, so as I said earlier, there was an email from Keith regarding the sale of EchoStar or whatever. In the email, Keith even discussed that...
Hold on, sir. Don't say what Keith said in that email.
I'm sorry, the email, when I read the email.
Okay, but I don't want you to say what Keith said in the email. That's hearsay. But you're trying... Hold on.
I'm sorry.
I want you to illustrate your point and respond. Just be careful in what you say, if you don't mind, please. Thank you, sir.
There was an understanding that there was factually an understanding that there were loans from officers or shareholders on the books. Everybody understood that.
Sure. But we should probably explain that, though. So a loan from an officer on the books means that, for our purposes, Paul and or Keith had given money to the company.
Possibly, yes.
And on the books, that was a liability for.
This is the second witness, and the judge is already fed up with the defense. So I am waiting for some Borowski like, what the hell is wrong with you? And I'm so disappointed in you as like a lawyer. I'm waiting for the disappointed Indian dad meme, to come through. So I'm just really waiting for, that's why I picked this trial. I wasn't itching to find another trial that involved children, but I was looking for one where we could join in the judge's righteous fury against stupidity.
Correct. And you actually did prepare documents to demonstrate the company's assets and liabilities throughout your involvement with them, correct? And those you did, I think those are balance sheets, they're called?
Well, after a while, I just prepared tax returns. But earlier years, I would prepare some compilation financial statements. Yes.
Okay. So, but you had mentioned money going back and forth, so I just want to get back there for a second. Keith would put money into the company, Keith would take money out of the company, correct?
Correct.
And that would happen throughout the 2010s, that was going on, correct, right? Paul would put money in the company, Paul would take money out of the company.
Correct.
That would happen throughout the 2010s,
Correct.
right?
Correct.
Keith would use the company to pay for certain personal expenses, and he would then put the money back into the company later, correct? Keith had the company pay for his tuition to go back to school, right?
Correct.
There was, on the balance sheets that you prepared, there was a company credit card through American Express you had to keep track of, right?
The bookkeeping department did, yes.
The bills on that were quite large.
Correct.
You had to factor those into the balance sheets and whatnot that you put together, right?
Correct, yes.
And you would see the statements from the credit card, from the American Express account, right?
Yes.
And you knew that the credit card there were open accounts within it, not just for Keith and Paul, but for Jennifer as well.
That I don't remember, but they had their credit cards all together, yes.
And there was money in terms of 401k loans,
yes,
that Keith had taken, right?
I don't remember, possibly. When things were slow, that might have happened, yes.
Okay, so was Keith owed by the company, and how much was Paul owed by the company?
I have absolutely no idea at this point in time.
Okay. If I were to show you a balance sheet that you prepared from November 30th of 2016, would you be able to tell me if you prepared it?
Yes.
Sir, did you drink the hair products? How many times did you rinse your head when the shampoo says rinse and repeat? I feel like he'd use the entire bottle of shampoo and then send his significant other out for another one. I feel like he is the reason that there is warnings on hot coffee at McDonald's. Why they tell you to unwrap the Pop-Tart before you put it in the microwave.
Judge, this is D35.
D35? Okay, thank you.
Someone sink a battleship already?
Just to start, is there a cover letter on the front of that?
This is not, I did not prepare this. This is from their internal books.
I see.
Jesus, Mary and Joseph would you say that you looked at anything before you came in? Or his mom. Look, let's be real. His mom picked out that thing. She had a tie tack and he forgot it.
Could you flip back to the first page? Yeah. Is that your letterhead?
This I got from the company books, yes.
Okay.
And all I said on here is, can I read this, Judge?
I don't know what it says. Prosecutor, have you even seen the document yet?
No, I can just take a quick look.
This is what I'm talking about. He doesn't seem to know the procedure. Oh my God, I think we might have gotten the disappointed Indian dad look from the judge. Oh my God, that is the look. That's the look that, sir, your behavior right now is negating both the theory of evolution and the benevolence of a divine, creator. I award you no points, and may God have mercy on your soul. The judge legitimately looks like he's waiting for Ashton Kutcher to pop out like, punked!
Do you have an objection to him reading the front page? Okay. Yes, you can. You can read it once you have it back.
Please be advised that EchoStar Pest Management and J. Martin Consulting Square One are affiliated under Section 414 of the IRS Code under subsection B, C, M, or O. Thank you. And this was to, I don't remember the year now, but this had to do with the retirement plan. But
I know, Karate Cat Mom, that the McDonald's coffee case was no joke, and she had very scalded no-no parts. I just feel like if one orders coffee, the implication is that the beverage is hot. Unless one orders an iced coffee, then I would think that she has the expectation of it being a cool beverage. But kind of implicit in coffee is that it's hot, as we generally understand it. But, I mean, hey, her lawyer got her paid, so good lawyering.
I did not prepare that financial statement. That's from the books, from the QuickBooks Online at the office.
Okay. Which you had
I don't even know if I attached it to this. I really don't know at this point.
You don't know how this got
I prepared the letter, but I don't remember.
Okay. So if I'm
And the purpose of the letter was because all the employees would have to be covered by a retirement plan. That's why I mentioned it.
Right. So I guess my understanding I'm getting from you right now is you don't know how this letter, with your letter.
Okay, Jason. All right, guys. I didn't realize that McDonald's had been warned. I haven't read that case. I did know that it actually was a real case, but I didn't know that they had been warned that their coffee temperatures were too hot, and they continued. Yeah, then good on her. Make them pay.
Your head got attached to these documents.
I don't remember. The only thing I could say is that at one point in time, as it was asked previously, Paychex handled the retirement plan, and then for a couple of years or so, they switched to another company to handle the retirement plan. So it makes sense to me, they needed to know this so they would know that EchoStar and J. Martin Consulting employees would all have to be covered. So I was asked to then put that letter. I don't even remember being asked. I don't remember doing it, but that's my letter.
Okay. Though you didn't prepare this document, that's attached to the letter. You recognize it as an internal company document from Square One.
Correct.
And you recognize it being from their QuickBooks.
QuickBooks Online, and I don't even understand why that had to be attached to that letter if it was going to a retirement company, so I really can't help more than that.
I understand. What I'm trying to find out more, okay, is not why it's attached to the letter. It's more, given your knowledge that this came from the Square One QuickBooks, which you had access to, by the way.
Yes.
And could review regularly, right?
When I visited, yes.
Right. Given your knowledge that this is a document from that location, would you be able to verify the accuracy of a line item in this if I were to show it to you?
Yes.
Okay. This is page 2, okay? I'm sorry, page 3 of D35.
No, this is 2.
Oh, I'm sorry.
Oh my God. Now, you know what I would watch, ABC? These two living in a house together like the Odd Couple. One's Richard Dreyfuss, the other one's Ian Crossland. And they get up to crazy hijinks. You know what I don't want to see them, giggling about? A trial. I'd like one person in this duo to know what the hell they're doing. And it seems like the accountant does. I was kind of hoping the lawyer would too.
This is page 3. Sorry.
Page 3. That's okay.
Just going to ask you to look towards the line.
Yes. There were 2 loans payable to Keith and Paul.
Okay. What was the loan payable to Paul?
At the time, the loan payable to Paul, and I probably would have to have made an adjustment for this $32,000. But on here, the loan payable to Paul was $179,285.34.
Okay. And the loan payable to Keith?
At the time was $118,690.92.
Okay. Thanks.
What does loan payable mean?
It means that they either put money in directly into the company or may have paid expenses on behalf of the company, and that money would be owed back to them at that point in time.
Can you see from the sheets what they were for? How they paid it in?
I'd have to go back and look, because there were various, they might have paid money on behalf of the company for computer equipment and stuff like that.
Okay. All right. I'm sorry, I just want to make sure that the jurors understand what that money was. Go ahead.
So, what this is going to show is, aside from the monetary amounts, right, is that both Paul and Keith are taking their money and putting it into the company.
Yes, correct.
Right? And the purpose of that could be to fund payroll in a given week, right?
Correct.
It could be for the purchase of office supplies.
Correct.
It could be for any number of things. But the point is that when they transfer the personal money into the business, it's for the purpose of the business. Fair to say?
Correct.
Is there a point in all of Carmen Sandiego, in her geography lessons, that you would get to at any point?
The other thing of what you just testified to about D35 is that as it pertains to D35, Paul is owed
you would
more
think
than Keith is.
Yes, at that point in time, yes.
So at this point in time, the indication would be that Paul has put more money in than Keith and gotten less money back, right?
Well, I don't know about getting less money back. I know at that point his loan was larger than Keith's.
Because he had put more money in.
Correct.
At that point in time. Okay. And that was $179,000. Over the years, did you would have interactions with Tiffany Rivera?
Correct.
Okay. You had a chance to speak with her, obviously, in person, correct? She would also maybe communicate with you in writing from time to time?
I remember in the early years, I wasn't a big email person, so I don't know about email. When you say, I guess writing, you mean emails.
Tiffany Riviera was, I believe, an office manager or possibly in charge of bookkeeping as Square One grew. Originally, I think they used him to kind of incorporate and do the accounting, but then as the company grew, they moved to in-house payroll and things like that. But he still did their quarterly books or annual books, I think. I don't know. At this point, I really don't know why this witness is still up here. The state brought him up because he was aware that Keith had found out the night before he was murdered that the life insurance was not being paid. The premium was not being paid with money that he was depositing into an account that Paul had access to for the second time in this year. And see you later, Heather May. Be careful, stay warm, and get your snow supplies ready if you're going to be affected in the giant snow hell freezing over event that's happening this week.
Maybe some, but maybe you should call me.
You've obviously seen a ton of Square One and EcoStar documents throughout the time that you were providing accounting services to them, right?
Correct.
And those documents would include not just, financial records, but sometimes lists of transfers between companies and things like that, right?
Yes, I believe so.
And Tiffany might have written something in pen on some of those documents?
Maybe, yes.
You had an opportunity to observe her handwriting over those years, is that fair to say?
Yes.
Okay. Your impression was that the checks were sent from the trust account to the insurance company. How?
But so ask that question.
How did the checks, who wrote the checks for the trust to go to the insurance company?
As I said earlier also, for the most part, the procedure was to be that the payroll, there would be a payroll transfer to the TD bank account. But that doesn't mean that all through the years that happened that way. Sometimes there were checks written from square one, which I would consider like against the loan payable officer or a shareholder distribution. It all depends on the flow of money, cash flow at that time.
Okay. Let me see if I understand you.
Ian, you don't understand anything. Don't attempt this. It will hurt you and it will hurt me seeing you try to think. We will all be in pain, and I'm a recovering Catholic, so I'm trying to get over masochism.
Ideally, the trust account would have regularly been funded through payroll. In the real world, in reality, that didn't always happen.
Correct.
Meaning that the trust, right, is responsible for making quarterly payments to the insurance company.
Correct.
But in order for the trust to do that, it's got to be adequately funded.
Correct.
And you're asserting that because of other business needs over the years, that trust account may not always have been adequately funded.
Correct, and that's why the loan started many years ago.
Okay. So your understanding of the start of the loan is not...
Let me just clarify.
Yes.
I meant the loan provision in the insurance that started because there was not enough funding and paying of the premiums.
Right. So premiums aren't paid on the insurance policy. That gets converted to a loan against the policy that would need to be paid back before money's applied to premiums again. That's your understanding?
I didn't know the actual details or logistics, but I would think that you could do them simultaneously. You could pay a current premium and pay back a loan and the interest as well.
Okay.
You didn't only have to, you weren't not allowed or restricted from paying a current premium until you paid the loan back.
In either case, though, your understanding is because the trust account hadn't been adequately funded in prior years.
Yes, gravity is real. I can't handle this anymore. We're speeding up after. No, we are not doing more. Gravity is real. Numbers happen. If you don't have money, you overdraft. This is ridiculous. This is reality. I understand, Ian, you haven't been there very long. So we're just going to go back and see if the state needs to unconfuselate everyone. Good night. He went to break. Holy crap. What the hell? Oh, God, he's still on.
EcoStar, right? Let me rephrase that, because I shouldn't use that word, perhaps. Paul, aside from the income he received from Square One and EcoStar, was also getting money from other sources, such as disability, right?
Yes.
Yes, disability. Are we going to get into the fact that Paul made sure that his salary went to his wife so he could get benefits? Do we want to talk about how shady all that crap was? Because you're kind of opening the door to the fact that he committed disability fraud. Not that it matters in the grand scheme of quadruple murder, but it seems like you shouldn't be exposing your client to more felonious, possible charges in your defense.
And Keith was not.
No, he wasn't.
And if Doris Duke went away and EcoStar and Square One lost that contract, that would totally cut off Keith from making any money.
At that point, yes. Yes.
But
Except for EchoStar, which they still were earning money, but correct.
nowhere near what Square was. But that fact wouldn't have cut Paul off from the other money he was getting from sources such as disability.
Correct.
And what he's doing here rather terribly is he's trying to disprove the motive that the state put out, that Paul was going to be in a very not so great financial state if the company did sell. Because yes, he did have other sources of income, but his outgoing bills were above his means. He had been spending more than he was earning, and it was going to be very hard to stay in the lifestyle he and his family had become accustomed to when this, if the business sold, and if he had to actually find not familial work to earn a living.
Just wanted to clarify one other thing, and I want to show you S12, which you looked at before. This was the TD Bank, the statement for the Keith Caniero Irrevocable Trust that you said you would look at periodically?
Yes.
Okay. When you recognized it before, I'm sure you saw at the top, it does say ATF Keith Caniero Irrevocable Trust Agreement.
Correct.
And then below that, it also lists a address.
Correct.
And it lists the address of 15 Willowbrook Road, Colts Neck, New Jersey.
Yes.
Okay, that was
Keith's home
Keith's home address, right? So the trust bank statements have Keith's home address on it, correct?
Now, because of the trust and how it was set up, Keith could have been getting bank statements, but he had legitimately had no control over this. So if he did see any discrepancies, if, anything like that, he had to go through Paul for any of the discrepancies. So it's not like Keith maybe knew, but it's also that Paul was at this time, I do believe, doctoring the statements. So he did get the statements, but they were doctored.
And over the years, you remember Keith sending you via email trust documents from the trust account.
I don't remember. I just remember in more recent years I would get them from Paul.
Okay.
And remember also earlier on, they would have a statement for me at the office in Woodbridge or Homedale. So I don't know how they got there, either from Paul, if you're maybe saying Keith. They were at the office when I would go there. So in the later years, well, current years, based on the incident, it would come from Paul.
Okay. But you're saying you don't have a specific recollection of getting
I don't remember
account
that at all.
statements from Keith?
Yeah.
Okay. Do you know, so I guess what you're testifying to is the fact that if you picked up the records physically, you don't know who put them there.
In the earlier years, maybe they gave them to the bookkeeper there were other bookkeepers in the past, or whatever, but I don't know how they got to the office. They were there.
Okay. And then, do you remember?
Damn it, now I have the song from Mahogany, Do You Know Where You're Going To, stuck in my head. Damn it, Ian. I already didn't like you, now you have a song from Mahogany. Although Diana Ross is great, now I have Do You Know Where You're Going To stuck in my head, so thank you for that.
Receiving an email from Keith in February of 2018 with the trust account bank statements attached to it? You know. I marked this as D16. This is an email, correct?
Yes.
It's from Keith.
Yes.
It's to you.
Yes.
It's got, we see it has attachments on it?
Yes.
We see that there's attachments listed in the file, right?
Yes.
We'll need to go to those. These are the...
Yeah, but it seems like the judge is letting them go, and I know the Murphy's Law of streaming. I have Mr. Mo making me a pizza, but I know as soon as I turn this off and get comfy in my bed, they're going to call the verdict, because that is just the way this goes. So I am staying on at least until 6:30, because that's generally when court ends for the day, to see what the judge's kind of policy is on letting them go late. He has told all prosecutor and the defense to stay within 15 minutes of the courthouse. No, because then I will have to go back on, and you guys don't understand. Once I'm off, I am off.
Okay, that's fine.
What's the date of the email?
I'm sorry, Judge. This is February 17, 2018. So, you agree with me that, though you may not have a specific recollection, there may well have been times where Keith was sending you the trust account statement.
That sense that he did, but I don't remember. Yes.
Okay. Another issue I just wanted to go back to very briefly with you was this issue about the account ending in 1361, the closed.
Hey, public service announcement to whoever's in court. Watch what I do here. Now, it's amazing. It's a Christmas miracle, and it's even a pre-Lenten miracle. But watch this. It can be done.
Right. So, I'm going to show you. Just going to show you what I marked as D41. Okay. This is the trust account. It's a trust account, and it's for the year 2014. Okay. Yes. I'm just going to take you to the April section of that.
Hold on.
Can we do it sidebar?
You can.
Sidebar 2, the defense is just chugging along on the judge's very last nerve, being terrible at his job. You know, I'd need the Werthers to deal with this man. I would have so many emotional support snacks out. Yeah, it's the good little boy outfit in a 40-year-old man, or I think he's 60-year-old man's body. It's just, it's very incongruous.
To sustain the objection based upon what... Sorry, I'm going to, just so that the jurors know, I'm going to sustain the objection based upon what we just talked about, but I'm going to let you ask whatever question you want to ask right now.
Okay, thank you, Judge. So, Mr. Weinstein, redirecting your attention to the April section of the 2014 irrevocable trust account statements. If we look to the date of 4/24,
11,000 went to 1361.
Right. Thank you. So 1361 was the J. Martin operating account. Right.
Systems, yes.
Systems. Yes. Okay. Thank you.
And yes, Kelly Rager, 3456. We are on Uvalde Watch. I don't think that we will get a verdict today if the judge allows them to leave at a relatively normal time. If he says that you're here until you come to a verdict, then I think we'll get a verdict tonight. But if he allows them to go home and come back tomorrow morning with a fresh brain and to go over, I do think that they would probably prefer to come back tomorrow. I think that the last thing that this jury wants to do is seem disrespectful to either the victims or the family members, so they want to do a really good job. And there was so much information in the trial. I had close to 250 pages of notes just myself, and I missed a little bit of the trial. So I do think that it will be really dependent on how late the judge makes them stay, and wanting to show respect and deference by doing a really good job and looking at all the information. Oh, are you done, Cletus? Don't threaten me with a good time.
That after
Damn.
After November,
I was so close. I thought you were giving up. You were taking your binders of stupid and you were getting ready to go to your little desk and be quiet. But then you decided to do another prayer man pose, because of course you did.
of 2018 into December of 2018, let's say, you had some dealings with Tiffany Rivera, right? And you had also some dealings with Corey Caniero? Yes. And did those take place at the Asbury Park office?
Yes.
Okay. And was it your understanding at that point in time that with Keith now...
I'm trying to remember if it was then or after that, but I do remember meeting in Asbury Park. I can't really remember for sure if it was December, but I do know at some point in time I was trying to figure out what their plan was.
Okay. It's certainly after November 20th of 2018. Yes. And Corey is involved at that point in time in administrating the businesses.
Well, his father actually, Cesar Caniero, was like the executor or the administrator or whatever, and Corey was trying to assist his dad.
Prior to that.
Now, you will want to take notice in the defense. The defense has put up a third-party defense stating that the state did not thoroughly investigate the third brother of the Caniero brothers, Corey. Now, according to the state, this is ridiculous. I don't know, but from all available kind of true crime podcasts, which I know are not, admissible in court, it seems to all accounts of people that have researched this case, that Corey was not really involved in anything really financially. Yes, he might have helped, the father try to be the, executive or executor of the estate, but he wasn't involved to the extent that Paul was.
Prior to November 20th of 2018.
Mm-hmm.
You would never see Corey at the businesses, correct?
Years ago, he was working there, but no.
When you say years ago, can you clarify that?
Yes. It was a number of years. He was working there for a short period of time.
Short period of time?
Yeah, and then he wasn't. And that I can't remember.
Less than a year?
Probably a year, something like that.
You don't have a recollection of how many years ago that was? Okay. You have a recollection of why he left?
No, anything I would have known is hearsay, not happening. That's all I would have known, something like that.
You're using the word hearsay to mean something you heard from somebody else?
Yeah, like, around the office. I don't really know why he left.
Okay.
I can't give you a definitive answer.
Okay. Can you give me an answer on whether he left because of his own decision or because he left because other people thought he should leave?
I have absolutely no idea.
EcoStar is placed into the hands of a receiver you testified about, right? The receiver who...
I think everything, yeah.
Yeah.
The relevance of this, Judge.
I'm sorry?
Relevance. This is after the fact.
Picked out these people's outfit. We have Milton from Office Space. We've got Ian Crossland. We've got, well, we've got Kim Kardashian, and then we've got the state prosecutor who seems fairly normal. What is this case? I must have a talent for picking the ones. Well, I kind of knew this one was going to be a cluster F because the judge, being pissed off was the only thing I was seeing in court TV updates. And I was like, oh, this seems like a trial for me. The judge losing his ish every 5 minutes because the defense is just terrible. I mean, at this point, Ian over here is about as useful as tits on a bull.
Ladies and gentlemen, I apologize to you. There was just an issue that I had to deal with. I have to decide what evidence you hear and what you don't hear, so sorry for the little delay there. Counsel, go ahead.
Thank you, Judge. Are you aware of the fact of whether EcoStar was sold in the years after 2018?
Yes.
Are you aware of what year that occurred in?
Yes, I do.
And what year was that?
I do because I was home recovering from hip surgery.
Just tell us the year, sir.
I'm sorry. That's how I remember, though.
Okay, that's fine.
I had to speak with the attorneys about that situation. I think they formalized the deal probably in May or June of 2019, I believe.
And do you recall how much it sold for?
I don't remember that. In the end, I don't.
No.
I don't.
Do you remember if it was more or less than what you were talking about?
I think it was in that area, if anything, but I don't remember.
When you say that area, are we talking about 750?
Between the 800 area, something like that.
I'm sorry, just one moment.
Sure.
Oh no, Kim. You tell him to sit the hell down, Kim.
When we are talking about officers of these companies, in terms of Square One and in terms of EcoStar, we're talking about just Paul and Keith, right?
Correct.
There was, during these years, 2010 through 2018, there was no third person.
Well, EcoStar at one point was a third officer.
Right, but
otherwise it was Paul and Keith.
It was Paul and Keith. Right. There were no other officers.
Right.
Okay. I have no further questions.
Redirect.
Thank you, Judge. Mr. Weinstein, on cross-examination, there was some discussion regarding the fact that the TD Trust account wasn't always sufficiently funded to pay the premiums.
Correct.
Okay. When there was money in there from Keith's payroll, where should that money have gone, to your
To
knowledge?
pay the premiums of Canada Life or pay down the loans. Anything, it should have gone to Canada Life.
Okay. In terms of the bank statements, there was some discussion about whose address was on the TD bank statements. You indicated, I believe, that you would receive them from Paul.
Correct.
Were there times when you would have to request them multiple times from him?
Yes.
Can you tell us about that?
Well, in the period of time, 18, beginning of 18 and later in 18, I would ask Paul, email Paul for the bank statements.
And what would happen?
Sometimes it took time, and then he would send me multiple of them at the same time.
Now, there was discussion on cross-examination to the fact you were asked whether Keith was on disability, and you'd said no. Do you recall that?
Yes.
Okay, and I think you indicated Paul was on disability?
Yes.
Okay, to your knowledge, would that have prevented him from obtaining outside employment?
Yes, it would have.
Nothing further.
Recross. If any.
I don't think so, Judge. Thank you.
All right, sir, you can step down.
Thank you.
Thank you. Call your next witness.
Thanks, sir. State calls Ronald Artigas.
Now, Ronald Artigas is the insurance agent. We should be able to get through him fairly quickly. The state, I think we are going to see this pattern going forward. The state's going to be very quick and efficient, and defense is going to try to kill me. with ADHD.
I said, just watch your step. Could you put your left hand on the Bible, raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. You say you're...
I thought we weren't letting Al Pacino play any more court movies after Devil's Advocate. I'm here for it, though.
Full name for the record and spell your last name once you sit down and you're comfortable. Go ahead.
Ronald F. Artigas.
Spell your last name for me.
A-R-T-I-G-E-S.
Prosecutor.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
Can you tell us what you do for a living?
I'm an insurance broker.
And where do you work?
Raymond G. McCarthy and Company.
Okay, just if you could slow down a little bit because it's hard to understand you.
Oh, okay.
Where do you work?
Raymond G. McCarthy and Company.
Okay, and how long have you been in the business of being an insurance broker?
45 years.
Are you familiar with the Caniero family?
I am.
How are you familiar with them?
I was introduced through a broker, Robert Reichenstein. I was working with him and handling health insurance for a company that Paul and Keith worked at.
What time frame was that?
2000.
Okay, and over the years, did you do any work for them?
I handled the health insurance. I also handled life insurance. Also handled homeowners insurance for Paul. I had, other accounts, disability insurance and so forth that we handled for J. Martin, Square One.
Okay, so there's been testimony about it, but just to your knowledge, how many businesses did Paul own?
2.
Okay, and who did he own them with?
Keith.
Okay, were you familiar specifically with Keith Caniero?
I don't understand what you mean.
Were you familiar? Did you know Keith Caniero?
I did.
Okay, and about how long have you known him for?
Since 2000.
Is it the same for Mr. Caniero too?
Yes.
Okay. You indicated that you would do some work with regard to certain types of insurance.
Yes.
Did you ever do any work specifically with regard to the businesses?
Yes.
And can you tell us about that?
Well, for J. Martin, I handled the ancillary benefits as well as the health insurance. So we did the group health insurance, we did the group disability insurance, group life insurance, group dental insurance. And EchoStar, which is the other company, we handled the health insurance and also the workers' comp insurance.
Who was the group health insurance provider for the businesses?
Verizon.
Do you know if Paul Caniero and his family were covered by that health insurance?
Yes.
Okay, and who was the group disability insurance provider for the businesses?
Sun Life.
And do you know whether the defendant was receiving any disability from Sun Life?
Yes.
To your knowledge, what role did both Paul and Keith play with regard to the day-to-day affairs of each business? And I want to stick to the time frame of 2017 and 2018.
So they both owned the organizations, and I think Keith, for the most part, was working from his home at that time. Was going to school and managing affairs for J. Martin. Paul was managing EchoStar.
When you say Keith was going to school, do you know what he was going to school for?
He went back to school to get his degree, master's degree.
Okay, and do you know when that was approximately?
I just know that I believe he completed all that in 2017.
Okay, do you know why he went back to school to get his master's degree?
Yeah, he was looking to sell J. Martin and EchoStar and move into a CIO position with the corporation.
Did he have any specific corporation in mind, or was this just...
Not to my knowledge.
Now, how long, you may have said it, but how long had you known Paul Caniero for?
Same as Keith, since 2000.
Do you see him in the courtroom today?
Yes.
Can you please point him out?
Paul.
Identifies the defendant.
Now, as Keith's insurance broker, do you recall whether he was a policyholder of any life insurance policies?
Yes, he was.
Do you recall what they were?
He had a number of term insurance policies. Some were his own policies. Some were company policies. He had whole life insurance, disability insurance, but life insurance, he had term and whole life insurance.
Were you familiar with the Canada whole life insurance policy?
I was familiar with the policy, yes.
Okay, and you mentioned a couple of different things. You said a term policy and a life policy. Is there a difference between the two?
Yes. So term insurance is basically you're paying a premium for a certain period of time, and then there's a death benefit attached to that. There's no return. The premiums are generally leveled for a certain period of time. Whole life insurance, you're paying a premium that's guaranteed for the rest of your life, and at some point that death benefit will be paid because of the fact the policy is guaranteeing an insurance payment when you die or when you reach the age of 100, whatever that insurance amount would be given to the recipient because the policy ends at 100. The difference between term also is there's no return on the money that goes into the policy. Whole life insurance policy has a guaranteed cash value, so at some point, if you wanted to turn that policy back to the company, they will reimburse you, for the premiums paid plus interest. And also, there's a dividend structure. So it can be used not only for death benefits, but it can also be used as far as a savings vehicle.
Now, Keith's Canada Life insurance policy, was that a whole or a term?
Whole life.
You indicate that you were familiar with that. Were you involved with Keith Caniero when he purchased that whole life insurance policy from Canada Life?
No.
How then are you familiar with it?
Keith had contacted me. I was familiar with the policy when Bob Reichenstein left the business. I was aware of the existing policies that he had life insurance. Canada Life was one of them. Then in April, I think in 2018, Keith had contacted me. He had a statement. He was trying to figure out why there was a loan against this policy. And that's how I contacted Canada Life, became a little bit more familiar with the policy.
What was the death benefit or the payout value of the Canada Life insurance policy?
$3 million.
Do you know who the beneficiary of that life insurance policy was?
It was a trust.
The trust, okay. Were you familiar with the terms of the trust and how it was structured?
No.
Okay. Were you familiar with the trustee?
Yes.
Who was that?
Paul.
Now, with respect to Keith's Canada Life whole life insurance policy, was there something called a cash value component to that?
Yes.
Can you explain that?
So whole life insurance, you're paying a premium, obviously, for the rest of your life because they're guaranteeing the death benefit at some point. And because it's such a long-term relationship with the insurance company, if you wanted to, you can give the policy back to the insurance company and they will reimburse you money that builds up in the policy, guarantee a cash value in the policy. You also have access to that. You can take a loan against the policy. So you'd still have the insurance minus whatever the loan value is of the policy.
Were you familiar with how the premium payments on that Canada Life insurance policy were structured?
They were paid on a quarterly basis.
Do you recall the amount?
$7,900.
And how would those premiums get paid?
They were paid by the company to a bank account, and then that money was transferred to Canada Life.
Do you know who was responsible for transferring?
So that's $24,000 a year if my math is mathing. Approximately. Look, I'm not doing 800. Y'all are lucky I'm even approximating this. But, I mean, it seems like a good fiscal policy, but you kind of have to be rich to cash in, or at least able to pay the premiums. I learned something new today that I would not have learned unless I were forced to in the name of true crime, because Mr. Mo wants to talk to me about financial stuff, and I'm like, no, thank you. But there you go.
The money from that bank account to Canada Life.
I think Paul.
And do you recall where that bank account was held?
TD Bank.
Now, to your knowledge, who had access to that TD Bank trust account?
Paul.
Do you know if Keith had access to that?
I don't believe he did.
And without telling me anything anybody said, what makes you think that?
Because of...
Hold on. All he said is he doesn't believe he did. Doesn't know or not know. So I don't know what the basis of that. Isn't it? It would be speculative anyway.
Do you know the answer to that, or did you use the word "I think" because you don't know for sure, or do you know?
Just repeat the question.
I had asked who has access to that bank account, and I believe he...
Okay. Who had access to the bank account?
Paul.
All right. Are you aware if anybody else had access to the account?
No.
No, you're not aware, or nobody else did?
No, I'm not aware.
Okay. Go ahead.
Were there times when you would review bank statements from that TD Trust account?
There was only one time that I saw bank statements.
Do you recall when that was?
In November 2018.
Okay. Do you recall the specific date? If not, it's okay.
No.
Okay. Now, do you know who would get those trust bank statements?
No.
Okay. All right. So you recall reviewing those bank statements, though, in November of 2018?
Yes.
Who did you review them with?
I was on the phone. They were sent to me via email, and I reviewed them with Keith and Steve Weinstein.
Okay. I want to back up now to April of 2018. Specifically, I want to draw your attention to that month. What, if any, issues did you become aware of regarding Keith's life insurance trust?
Keith had contacted me, inquiring. He had gotten a statement
showing that there was a loan against the Canada Life policy. He didn't understand policy, so he contacted me. He asked me what that meant. What is a, why would there be a loan against this policy?
And did you explain?
And I said, based on what I see here, there's either the money was taken out for whatever reason you would take it out, or there's also in a whole life insurance policy what's called a premium loan. So to prevent the policy from lapsing, if there's this substantial cash value in the policy, they'll take a loan against the policy automatically to make sure the policy doesn't lapse and pay the premium.
Do you recall?
Now, this was the first instance where Paul said, look, I accidentally, as trustee, paid the wrong set of bills. I meant to be paying Canada Life, but it was going to my account, as happens once in a while. Basically, he said, I'll pay the money back. It's my fault, my bad. And it seems like Keith forgave his brother and was willing to keep him on as trustee, or alternately, I don't know how difficult it is to switch trustees on an irrevocable trust. So Paul stayed the trustee, and then again in November, Keith finds out that Canada Life is again not getting payments.
Receiving any emails in April of 2018 regarding that conversation?
Yes.
And who did you receive an email from?
Keith.
Okay. Do you recall receiving any emails from Paul?
I was CC'd. I was part of an email chain with Keith, Paul, myself, and I think Steve.
I'm showing counsel what's been marked as S11. May I approach?
Okay.
I'm showing you, sir, what's been marked as S11. Do you recognize that?
Yes.
Okay, and what is that?
This was we were trying to figure out, I think it's a breakdown. Let me just read this. This was Paul had identified why the premiums hadn't been paid, and this is where they went. So he was giving an explanation of the premiums were paid to the wrong place.
Okay, so let me just ask you, this email, who is that from?
Paul Caniero.
Okay, and when is it sent?
April 11th.
What, of what?
2018.
Is there a time?
11:03, 11:01. No, yeah, 11. I can't remember.
Is that
11:01 a.m.
And who is it to?
Keith Caniero, and CC'd me and Steve.
Okay, and is there a subject line?
Trust reconciliation.
Okay. Permission to publish?
You can.
Mr. Ortiz, do you see that on the screen in front of you? You see that? Okay. Is that essentially the email that I just showed you?
Yes.
Okay. And you're copied on this, is that right?
Yes.
Okay, and this is from who?
Paul.
Okay. And is this the email that you were just referring to?
Yes.
Okay, and does Mr. Caniero on there indicate he selected the wrong bill payee from some of the payments?
Yes.
Okay, if we could just scroll down to the end, please. Okay, what does that last line say before his signature?
Sorry for all the confusion. I've had my head up my ass.
Okay, thank you. Did you look into this issue any further after you received that email?
No.
Okay, do you know what happened with regard to any missing payments?
No.
I want to draw your attention about 7 months ahead now to November 19th of 2018. Do you recall that date?
Yes.
Okay. What, if any, communications did you have with Canada Life Insurance Company on behalf of Keith that day?
So Keith had contacted me regarding, again, a loan on this policy, and it had grown from where it was. He didn't understand. He had said that the premiums were being paid. So I said, perhaps there was a problem with premium payments, and they took a loan out on the policy to pay your premiums under the automatic premium loan provision. So I contacted Canada Life to find out whether or not the premiums in question had been paid, and they said they didn't receive those premiums.
Did you relay that information to Keith Caniero
Yes.
that night?
Yeah.
That afternoon, if you recall. And how did you do that?
Via phone.
What specifically did you tell Keith?
I said that as far as Canada Life, they have no receipt of any payments.
Without telling me anything that Keith may have said, what was his demeanor like?
He was frustrated.
What did you and Keith do that afternoon and that evening?
Well, we were trying to, Paul wasn't feeling well. We were trying to just find out why the premiums weren't credited through Canada Life. So the question was, if they were paid through the bank, then Canada Life obviously should have received those payments. So somewhere there was a mistake.
Now, when you
Yes, and there was a lot of confusion because if you'll remember from the last witness, if your brain still works, Paul was using Adobe or some kind of thing to add that or show that payments were being made to Canada Life. Now, there weren't checks associated with those payments, but it did say, withdrawal to Canada Life, but it was all various numbers and amounts. It wasn't like a uniform amount like quarterly of the $7,800. It was more like $1,000 here, $1,500 here, $500, $300. It was really weird and odd, sort of piecemeal things that should have probably been caught if the accountant was paying attention.
say you were trying to find out, were you looking at any documentation over the phone with Keith?
Steve had shared the TD Bank statements with Keith and myself.
Okay, and when you say the TD Bank statements, what year?
The ones for 2018 that specifically stated the fact that the premiums were paid to Canada Life through the TD Bank policy. So, it's a Canada Life right on there. So that led us to believe that there's a possibility that maybe Canada Life made a mistake.
Okay, so just so I understand, those 2018 bank statements were showing payments being made to Canada Life?
Yes.
From where?
From that statement.
The TD Trust account?
Yes. Well, from the TD Bank account.
How did you end the conversation with Keith ultimately that night? Was there a plan for the next day?
Keith had sent an email to us all. He was frustrated with what was going on, and he had said that he was going to make recommended.
Don't say what he was going to say.
No.
Without telling me anything that Keith may have said, did you have a plan for the next day?
In regards to this?
Yes.
I didn't have a plan because of the fact that I had done everything I could.
Okay, understood. Now, aside from the email that you said you received from Keith that night, what, if anything else, did you receive from Keith?
That night?
Yes.
I don't think I received any. There was perhaps some other emails, but it was mostly a conversation on the phone.
I'll ask it this way. Do you recall ever receiving a resume from Keith?
Oh, yes.
Okay. And when was that?
That same night, I believe, he sent the resume. We had a conversation in regards to what he was trying to accomplish, and his hope was that he was going to move on private industry and go into the commercial business, looking for a job as a chief information officer for a company. So my wife was vice president at Presidential in the technology field, so I offered to share his resume with her, and that's why he sent it.
I want to draw your attention now to the next morning, Tuesday, November 20th of 2018. Do you recall that date?
Yes.
Okay.
Tiffany from his office called me and said that there was an incident at Paul's house, a claim, and he needed to speak to me. So I called him and he answered.
And what did he say to you over the phone?
Paul, could you look any more guilty? Like the day you find out that your brother has been unalived and his family horribly unalived, but you have to call your insurance guy because of the fire at your house, in which allegedly you were trying to burn evidence of you being the unaliver. Yeah, way to look all the innocent, dude. Again, due process, the state has to prove their case beyond a reasonable doubt. I just don't think they're going to have a hard time with that.
So there was a fire at my house. I contacted the insurance company, put the claim in, and so the claim's already been reported. And then he was going to give me the claim number, and then I'd work as I do, helping to get the claim paid.
What time was that phone call at about?
9:30 a.m.
Do you recall the name of the his homeowner's insurance company?
Sure.
Okay, and just to be clear, he called you and told you he had put a claim in for his house?
Yes.
And nothing further?
Cross.
So, good afternoon.
Good afternoon.
Keith had a number of different insurance policies.
Yes.
And some were life insurance, some were other types of policies. Do you know why the Canada Life policy in particular was in a trust?
No.
You don't? Okay. you were aware that premiums were supposed to be paid on that policy quarterly, right?
Yes.
And those quarterly payments were supposed to be $7,800?
Yes.
Well, Keith got you involved with this policy, I'd imagine, because, you know, you're in insurance and you're familiar with these type of things, right?
Yes.
You weren't the one that advised Keith to put the policy in trust.
I was not.
Okay. In April of 2018, you mentioned.
Be lazy. I kind of picked this one because I kept seeing pop-ups that the judge was losing his ever-living mind with the defense. So I thought there might have been like a Borowski Chambers now. And, you know, I love to see it. But then I didn't realize that Ian Crossland from Tim Pool was going to be the defense attorney. So you win some, you lose some. We're going to get righteous judge anger at stupidity, but we're also going to have to deal with said stupidity. Yeah, it's kind of like Haunted Mansion. I expect to see Walford and whatever his name is, the two little old men Muppets somewhere near the ceiling.
There was an issue with payments getting from the trust account to the insurance company.
In April, Keith had asked me why there was a loan against this policy, and I explained to him how that loan could possibly have been generated.
Now, at this point in time, there was that email that you had referenced where Paul's talking about paying the wrong people from the account, right? You saw that just a second ago?
In a cup, and then you need to put the rest of it in. Get a cup.
After that happened, Paul told Keith that he was going to put that money back, right? Pay that money back, right?
Yes.
And he did actually pay that money back to Keith, right?
I don't know.
You're not sure?
No, because after that, at that point, I was out of it.
Okay. So there was no follow-up with you and Keith about whether that money was paid back to him?
Correct.
Okay. And then between that event in April and the event in November that you talked about, did you have any further involvement with issues related to the trust account?
So the next time I became aware of anything was when Keith contacted me in November.
Right. Okay, so between April
Nothing.
and that date in November, there was nothing.
I thought everything was handled. Yeah, closed.
But your involvement was nothing?
Nothing.
Okay. Now, Keith, going back to the April portion where you were involved, Keith was in communication with the insurance company, right?
No, I don't think Keith was in April. Keith had asked me what on a whole life insurance policy. Why would there be a loan against the policy? So I had contacted Caniero Life, and they told me that premiums hadn't been received.
Didn't Canada Life send Keith a copy of the entire payment history for the policy in April of 2018?
Well, that's maybe where the reconciliation came. I didn't have a copy of that.
Okay.
So
I'm sorry, I didn't mean to interrupt you, but I just wanted to say, didn't Keith send you that via email?
The
history of payments on the policy?
Yes.
He did?
Oh, yeah, he sent me.
Okay.
Yes.
Crystal 7260. I know the jury can go as long as needed, but do we know about how late they may stay if they're not close? That's what I'm kind of waiting for. I'm hoping that since we're near to where they typically end, that the judge may come out and ask them. I mean, we kind of got a feel for Bev that she wasn't going to let them stay late. As for this judge, I don't know because there have been several times where they stayed late and he has been irritated at the attorneys for making his court staff stay late. But I don't know what his general policy is about keeping people late or what it is. So not quite sure.
Okay. So basically, your understanding then would be in April, Keith was in contact with Canada Life. They sent him the payment history for the policy, and he sent it to you.
When I spoke with Canada Life, I believe, when I spoke with Canada Life, I asked them to send the payment history to Keith.
Okay.
And of course, Paul.
Just keep 20.
20.
So just to show you this, you can take a look at it. You recognize me?
Yes.
Oh, you see your name on it?
Yes.
Okay. What is that?
I'm sure Jesus. But this was when we found out there was a loneliness policy. And the insurance company saying that they didn't receive a payment is the reason why I asked for a payment history, so that they could basically come to a conclusion of if payments were made, where they went. Okay. So that's why he sent it to me, because when he got the payment history, it was again just identifying the fact that certain payments weren't made.
I see. So clarify, asking, is it Keith sending you the payment history from Canada Life?
Yes.
Okay. When we go to the payment history, everybody does.
Yes.
Okay. We look at 1999, right?
Yes. 7/28.
July 28th of 1999.
Yes.
Okay. When we look at this, we can see.
And thank you so much for the £5, Paula. Just a small thank you for keeping the stream going so long. Thank you so much. Yeah. Like I said, I would probably stay until 7 and then I will stay. Because if not, we won't have mornings with Mo. So, and I kind of turn into a pumpkin around 9 p.m. Like I'm still awake, but I have surpassed my sociability. Except on Fridays. Fridays I can do it, but I know ahead of time.
That you testified before that the quarterly premiums were supposed to be $7,854, right?
Yes.
If there's 4 of those a year, that would be about $31,200
Okay.
a year.
Right.
Okay? But when we go through this, like if we look at 2003, only $16,294 is paid towards the policy, right?
From what I see here, it says payment amount $16,294, applied as premium, applied as a loan payment.
Right. What I'm asking you though is, over the course of 2003, if there's quarterly payments, what we should see is over $31,000 going to the insurance company, right?
Yes.
But that we're not seeing that there.
Based on this, you're correct.
We're seeing about half that going there, right?
Yes.
Okay. So
Is this any better? I unplugged and replugged. So maybe it's
All I'm trying to say is, in terms of quarterly payments, when we look through this, we look at, again, 2007, right? We're seeing $9,838, right?
Yeah, oh yeah. So right here, you see $9,850 on where state paid the premium, $7,854, and apply this to the loan.
Right. And so as of 2007, when that payment took place, that loan was already over $45,000, right?
Mm-hmm.
So.
You have to say yes or no, sir.
I'm sorry?
You have to say yes or no, please.
Oh, yes.
And the only point I'm trying to make is the failure to pay the quarterly payments to the insurance, right, was not a new thing that happened in 2018. It was something that when we see the policy, we see it goes all the way back to 2003.
Yes.
We just look at it, right?
Absolutely.
And that's what we saw.
Yes.
And when we look at and think about there being a loan on the policy, we see that this is not a new phenomenon either. It goes all the way back in the policy until the early 2000s, right?
Yes.
Did Keith, let me ask it this way. So, if I'm understanding you correctly, after this issue gets resolved to your understanding in April of 2018.
No. Oh yeah, April 20. I'm sorry. Yes, you're right. April.
You don't have any more communications with Keith about the trust account itself until November of 2018.
Yes.
And you might have had conversations about other insurance policies with Keith, but you didn't have any further communications about this insurance policy until November of 2018.
Yes.
Now, you had made some calls to the insurance company on Keith's behalf in November, right?
Yes.
And you actually, for some of those, when they asked for your name, when you called, you said you were Paul Caniero.
Yes, I'm calling for Paul Caniero.
You said you...
What? I identify myself as Paul Caniero.
You identified yourself as Paul, right?
Mm-hmm.
And obviously, you know, we understand that was what you were going to be able to get information from.
That's, I was just trying to establish if there have been payments made on specific dates. I don't recall it, but specific dates. And I had asked them to send information because they said they didn't get the payments. I don't recall, but I believe I asked for them to send another account history or something.
Okay. Now, that was that day in November when you called the insurance company and pretended.
Okay, you guys, I think I'm going to call it a night. Hagatha is dying. I am too. If in the next hour we do get a verdict, I will pop back on. Yeah, no. I will not be staying up until 11 a.m. or 11 p.m. That is not going to happen. I will keep my, yeah, I'm not sure if it's because, it's been a longer stream. I'm not sure. I have had problems with this particular feed, so I will be switching it. But I think I am going to call it a night. I'm not staying up until 11 p.m., but on the plus side, this might mean that, oh gosh, what Nick. Nick, I will send him a message because he might actually be up and Sweden time is different. So I sent Nick a message that let him know that they can deliberate until 11, and because Nick is in Sweden, he might actually be up in time to catch a verdict if they have one late at night. But I'm going to call it a night. Thank you guys so much. I do have you guys sending over to Defense Diary, but I don't know if they're still live. So you guys are free to go wherever in the internet you want. Thank you so much for hanging out with me all day. And we'll be back doing pretty much the same thing tomorrow if we're still on Verdict Watch. If we're not on Verdict Watch, I might do Mornings with Mo and then sleep in. And then Friday we'll be back on Paul Caniero's case. It will just play it by ear. I will see you guys in the morning. Bye, you guys.